Morning to you all. I hope you are well. So we are about to begin our conversation this morning, our constitutional symposium. So I think we'll give ourselves another 5 minutes whilst we allow others to join in, and then we begin. Thank you so much. A good morning to you all. The Zimbabwe Council of Churches welcomes you to this Constitutional Symposium. My name is Tariro Senderai. I'll be your moderator for today. So without really wasting much time, I would really ask that Fundisi Potamani gives us an opening prayer for us to start the conversation today. So over to you, Fundisi Potamani. You can unmute your mic and give us an opening prayer.
Heavenly Father, in the name of our Lord Jesus Christ, we come before you this morning in honor and adoration because of the opportunity that you've given us to interact as your people. You know, Lord, what has happened before us, and you know what is ahead of us. Therefore, dear Lord, we commit the day and the proceedings unto your capable hands. That, Father, in one special way, speak to us as we interact. Let your Holy Spirit guide this discussion, such as in all, Lord, only your name shall be exalted higher and higher. Let it be your will, O God, as we interact. In the name of the Father, the Son, and the Holy Spirit, one God, blessed forever. Amen.
Thank you, Reverend Putomani, for that beautiful opening prayer. So I'll hand over to Reverend Dr. Kennedy Gondongwe to give us welcome remarks and, of course, to unpack the objectives of this constitutional symposium that the ZCC is hosting today. So over to you, Dr. Gondongwe. You can unmute your mic and go ahead.
Thank you so much, Tariro. Special greetings to everyone in attendance at this very momentous meeting of the minds. We want to welcome people from all our regions. We want to welcome everyone from different spheres of life. Some are coming from politics, some are coming from the perspective of law, some are coming from the perspective of social sciences, some are coming from the perspective of theology, some are coming from various other perspectives. But the beauty of it is that it's possible to meet as one with all the divisions of minds. It's such a blessing that then we can forge our perspectives, we can fix our choices as Zimbabweans. That is the best that we can talk about, that in spite of the various views that we hold, depending on how we're socialized, depending on where we're coming from, but it's possible to meet and discuss over these things. So you are most welcome to attend this, and we want to thank Zimbabwe Council of Churches for coming up with this initiative, because at some point we have to talk about these things. So we are really grateful to you, Tariro, the General Secretary, and his team for this robust, proactive, innovative orientation to topical issues that are affecting us. The major purpose for this meeting is that perhaps even before I do this, let me give the background. The background to this is that constitutions are sacrosanct, very important documents, whether they are written or unwritten. Other countries have got unwritten constitutions, others do have written constitutions. But as you would know, that it took many, many years for Zimbabwe to have what we call the 2013 constitution, when we have languished in a Rhodesian constitution that did not serve us well as people. And we modeled our constitution along other constitutions in the world, such as the American one. The USA constitution is one of the best. The Kenyan constitution is one of the best. The South African constitution is one of the best. And Zimbabwe, obviously, coming in through. But we had lived in an era where constitutions were used as weapons by the powerful. For instance, I can give an example. The Malawian constitution, the preamble itself, at some point, once upon a time, the preamble of the Malawian constitution read, "The president of Malawi shall be Dr. Kamuzu Banda." Very personalized constitution. And you see that the trajectory of the nation is very wrong, because it's tipped towards the selfish, egocentric views for one person. And we had such things happen in our country. And our longest house constitution, of course, it carried us through, but it was a wrong document for Zimbabweans. Initially, because it was never by the people. So constitutions are sacrosanct. Constitutions must be made by the people, we the people. We the people. The American Constitution starts by saying, we the people have said this. So a constitution must be a product of people's views and contributions. We the people, the grassroots. So this is the situation that we are talking about. And Zimbabwe, before this 2013 constitution, amended its constitution more than, in 33 years, it amended it more than 19 times. And that's not good for a constitution. That's not good for a constitution. So we are saying, because of the sacrality of constitutions, because of the nature of constitutions that demands people to participate, and the document must embed the values for every nation. But the situation at the end now is that the constitution is being amended in a haste. The constitution is being amended in a haste, perhaps for the national good, we don't know. Perhaps for the good of political parties, we don't know. Perhaps for the good of those who are in power, we don't know. But what we are sure of is that it has been amended in such a haste. And when it has been amended in such a haste, then what we discovered is that it is signed into law within the shortest period of time possible. It's signed into law. When it is signed into law, those who are aggrieved, they rush to the courts. And when they rush to the courts, there are many things that are coming about the legality of the appointing or appointment of the Chief Justice and many other things involved. And as I speak to you now, the issue is before the courts. And the question, obviously, the overarching question that now demands or that begs for an answer is are these amendments good for the nation? To what extent do the amendments resonate with the aspirations of common people, of Zimbabweans by themselves, so that we are able to say, we the people of Zimbabwe, we have spoken. Can we really preface our constitution and these amendments and say, we the people have said? To what extent have been the people consulted? Of course, the constitution itself have provisions in terms of how it must be amended, but to what extent have all this been met? And as churches, we are concerned. We were with the people from the word go. We contributed with the Zimbabwe. We know what we want. And as churches, we are the conscience of the nation. And when such things happen, which are brewing conflicts, disgruntlements, and in the interest of public interest, we are bound to come up with these symposiums where we assess the tempo and where we also remind those in authority that the people must come first. So the objective is to consult with the constituencies. The objective is to find out from the experts how we must proceed under the situation. How should we proceed? How the nation should engage, how we must reflect, and how we must throw the issues back to the people, because we are in a democracy, and we believe that our constitution is of course, no constitution is permanent, but it mustn't be amended willy-nilly to the service of any one person's personal veto. It's a sacred document that must carry the values of a nation. So I invite you, friends, to contribute. I invite you, friends, to share your experiences, to share your views, so that together we shape our nation. We don't have any other home. Zimbabwe is our home. This is where we are called upon to participate in civic life. This is where we are called upon to give our all, because it's our motherland. Let's contribute. Let's share views. The church, Zimbabwe Council of Churches, is mandated to have these symposiums so as to educate our people. So with these few words, I once again welcome you, and feel free to share in a very civilized manner. No abuses, no abusing each other, but let's stick to issues and not tissues. Let's not talk about people, but let's talk about issues. Let's talk about issues, not tissues. So with these few words, over to you, Tariro, and my deep welcome to everyone participating in this symposium. I thank you.
Thank you, Reverend Kennedy Gondongwe. I think this was quite a reflective opening remarks, and of course to set the tone and to give us the objectives of why we are meeting today. I thank you for that. So I think we move on now to having some theological reflections of why we find ourselves convening today as the church around these constitutional developments. So I'll hand over to Reverend Dr. Kenneth Mtata to take us through why we are here today, and of course, what we aspire to achieve at the end of this conversation. Over to you, Dr. Reverend Kenneth Mtata. Thank you.
Thank you very much, Tariro. It looks like my video is disabled, but I don't need to be on video. Thank you very much, Dr. Gondongwe, our chairman for the Theology Committee, for these very important words of welcome and to set the tempo for our conversation today. I also want to recognize the leadership of the church who are present with us this morning, particularly members of the Supervisory Council, our bishops. I can see many of them are connected here. Our members of clergy, I can see that many of them are connected. I can also see our structures from the local ecumenical fellowships, and our guests who have been invited to come and contribute to our conversations. And thank you very much, the ZCC Secretariat, particularly Tariro, for convening this space. The people of faith from long tradition have been connected with laws and commandments and codes of life. This goes back to the Old Testament tradition. It gets refined in the intertestamental period, and we see it also being explained and expanded in the New Testament. The people of faith, the people of God, have always had laws governing the way they relate in personal, private life, but also in the public life. We must remember that the codification of some of these laws, for example, on Mount Sinai, when people had been delivered from the slavery and the captivity of Egypt, was meant to separate the life under oppression in Egypt and the life of freedom and the life of people who have been freed, who were going to the land of promise. In other words, while we see that there were laws that were oppressive in Egypt, the law was given on Mount Sinai as a testament of freedom for the people of God who were going to the land of promise. And these laws and the commands were understood to govern how people related with one another in love, in recognition of each other's dignity, and in making sure that people related in just and fair treatment of the other. The laws were also put in place for people's relationship with the divine, people's relationship with God to be defined. But you will realize that the relationship with God, the efficacy and authenticity of such a relationship, the obedience of God was judged according to how human beings treated one another. In other words, the greatest commandment was, you shall love the Lord your God with all your heart, with all your strength, and with all your mind. And the second was, you shall love your neighbor as you love yourself. So the test of one's authentic relationship with God was measured by how they related with their neighbor. In other words, you were known to be one who is obedient to the laws of God when you treated your neighbor with dignity and with love and with justice. For this reason, the church has always been committed to societies that are governed by laws and their constitutions. And these constitutions and laws put all people at the same level. And that is why you realize that at the initial moments when Zimbabweans started to reimagine a homegrown constitution, Zimbabwe Council of Churches and the broader ecumenical body were very much deeply involved, leading to the birth of the National Constitutional Assembly. And the church's contribution to the 2013 Constitution is very, very evident. The footprint of the church can be seen even in the preamble, in the values, some of which were taken verbatim from the 2006 vision document that had been proposed by the church, the Zimbabwe We Want document, as Dr. Gondongwe just mentioned. But today, Zimbabwe is confronted by a new situation related to the Constitution, where the church needs to summon itself and to organize itself to participate in this quest for the implementation of the 2013 Constitution. While the Zimbabwe Council of Churches and the ecumenical body contributed to the process and content of the 2013 Constitution, we seem not to have foreseen how much responsibility and energy that would be needed for us to make sure that this Constitution was implemented and was honored and respected. And for this reason, we find ourselves in a new space in which we must commit ourselves without apology. I know that there are many people for whom this sounds like a secular responsibility. There are many Christians for whom the task of the engagement in the public space is the responsibility of lawyers, is a responsibility of economists, is a responsibility of politicians. But we know that the responsibility of engagement in the public space is a Christian responsibility, because Christians from the beginning, as we have seen, they've always aligned themselves with a God who is always defending the cause of the widow and the orphan. And there is no way the cause of the widow and the orphan can be protected if there are no laws that protect the widow and the orphan. The church has always aligned with themselves with an economic understanding, an economic orientation where everyone is able to sit under their own vineyard. They are able to sit under their own sycamore tree. Economic independence is the hallmark and the value orientation of the church. And for this reason, the church cannot sit and hide behind the pulpit when the economy is exclusive and marginalizing and when the laws are applied in a selective way. In other words, engagement of the church in making sure that the economy is inclusive, the laws are fair, just, and are applied in an unselective way is a core mandate and the calling of the church today in Zimbabwe. And for this reason, we are taking up this responsibility. We want to re-energize our church at a local level, at a congregational level. We want to energize our clergy. We want to energize our bishops. We want to energize our ecumenical structures at a local level, at regional level, at continental level and global level, to say that Zimbabwe, we want to commit again to the law, to the constitution, and to the spirit of the law, to constitutionalism. And as we enter into this terrain, we are not entering this as guests. We are not entering this space as people who must seek permission. We are called by our Christian mandate and by our mandate as citizens of Zimbabwe. And it is in this view that I want to encourage all of you to participate in this conversation. And we pray that God may continue to enlighten us. We have very professional people who are with us here to enlighten us so that we can know what should be our next steps. Thank you very much, Tariro. Thank you very much, all our guests. And thank you, our church leadership, for being part of this conversation. We pray that God may guide us as we take up this sacred task. Thank you. Let's pray. Our Heavenly Father, we thank you that your word calls us to order our lives personally, but also to order our lives collectively. As we are going to be reflecting together this morning, we pray that you may bless our reflections, that they may bring order to our society in ways that bring justice, fairness, and the equal treatment of all Zimbabweans. We pray that you may awaken your people to the value of the Constitution and constitutionalism so that we can live productive, fair, honest, and joyful lives which we share. We pray all this in the name of our Lord Jesus Christ, who did not only affirm the law, but who also exalted its spirit. And we pray in his name. Amen.
Amen. Thank you, Dr. Reverend Kenneth Mtata, for those theological reflections. Of course, that will show you that I think the church continues to have a stake in such conversations, and also because the church has always had a footprint in constitutional developments in the history of Zimbabwe. So I will not waste much time, but I think I would like to appreciate our member churches who are present in this conversation, our local ecumenical fellowships who are present in this conversation, our pastors, our reverends, our bishops, and of course our women ecumenical fellowships who have taken the time to participate and to converse on this very important conversation. But of course, last but not least, I would also want to introduce our panelists for today. Although before I start introducing them, I would want to then speak to how this conversation will be structured. So today we will have 3 sessions of conversation. The one we are in this morning from 9 to 11 o'clock. And then of course, the second one that will be from 11 o'clock to 1 o'clock. Then the last one will be from 2 p.m. to 4 p.m. So these are 3 sessions where the first session will deal primarily with the legalities around amendment number 2 of the Constitution. So we have panelists for that session, and our panelists for that session include the Law Society of Zimbabwe, who will be represented by Machovana, who's already in the list of participants today. Then of course, we'll have submissions from Dr. Musa Kika, because we are aware of the contributions that they've made to the very fast developments we are seeing right now with regards to the constitutional amendments. Then we'll also have Professor Maduku. Unfortunately, Professor Maduku is in court this morning, but he will participate in the second session, the mid-morning session, which is from 11 o'clock to 1 o'clock. Then we'll also have in this morning section, Dr. Alex Makaisa, who of course I think we can recognize is someone who recently launched a constitutional, he recently launched a constitutional platform, which is called the Constitutional Law Center, where he is now a convener, which was launched sometime last week. So we also have in his capacity as a constitutional expert and also as an academic in that area. Then of course, that's the conversation we have around the legalities. Then in the afternoon, the mid-morning session, we will have Professor Love Momaduku, who will join us in the afternoon, of course, as a constitutional law expert. Then we'll also we'll be discussing the politics surrounding the amendment number 2. We'll also have Richard Mahomva, who is an academic, who will give us his submission from his perspective. We'll also have Linda Masarira, who's a presidential candidate for LEAD. And we'll also then have the last speaker, who will be Senator Komichi, who of course is a representative of the MDC but of course in his capacity as a senator who participated in voting against the proposed amendments. Then the last session, the third session in the afternoon, we'll have Namatai Kwekweza, who is the leader for We Lead Trust. We'll also have Blessed Mhlanga, who's part of the media and will hear perspectives of the media in covering the constitutional developments that have been happening as they are the fourth arm of the state. And then we'll have Stabile Dewa, who's from Walpe, who will give us their perspectives from a women's perspective or women's movement perspective, especially with regards to the quota system being elongated to beyond 2023. Then of course, last but not least, we'll have Professor Atham Tambara, who will give us his view in terms of how we move forward from such developments, of course, from an economic point of view. And also we will have Kipson Gundani, who's also an economic player, to give us their perspective to say how will they be affected by amendment number 2. So this is how we'll structure our conversations for today. So we are in the first conversation this morning, where I would like to introduce the Law Society of Zimbabwe, being represented by Machobana, Dr. Alex Makaisa, and of course, Dr. Musa Kika. Dr. Musa Kika is an emergency right now, but I think he will join us in the next 10 minutes or so. So without wasting much time, I will hand over to the Law Society of Zimbabwe to give us their presentation with regards to their view on the developments constitutionally and what we need to do in terms of moving forward as citizens. So over to you, Machobana. What is the perspective of the Law Society? And how have you been receiving these constitutional developments? And also, how do you perceive we move forward in terms of going back to the place of constitutionalism and rule of law that the Zimbabwean people deserve? So over to you, Mr. Machobana. Thank you.
Thank you, Tariro. Let me start by extending my gratitude for the invitation to the Zimbabwe Council of Churches. And let me also extend my thanks to my fellow participants and also to the listeners who are in this conversation today. Tariro, I will not per se speak to the constitutionality or otherwise of this amendment. We are all aware that this amendment is undemocratic. Someone says, how can a constitutional amendment be unconstitutional? That is possible, but I'll leave that aspect to my brother, Dr. Alex Makaisa, to deal with that. Perhaps today what I will seek to do is to speak as a student of politics or political science. I have no training in that respect, but I think by virtue of being a Zimbabwean and living through these tumultuous times, I'm qualified, to make a few remarks. I'm a lawyer by training, and I think the tragedy that we have had in Zimbabwe is that we have had too much faith that we have placed in individuals, individuals like judges, individuals like politicians, and oftentimes we have been disappointed. I think we need to reimagine Zimbabwe. Dr. Mtata, in his introductory remarks, did refer to the Zimbabwe that we wanted when the constitutional quest commenced some time back. I think what we need to do is we need to go back to basics. We have seen the effects of civilian mobilizations across the world. We have seen what the National Constitutional Assembly, the NCA, did in mobilizing Zimbabweans to the establishment, leading the people of Zimbabwe in the struggle for a constitutional dispensation that was good for Zimbabwe, that was authored by the people of Zimbabwe. That movement, you recall, led to the government capitulating in the year 2000, and they tried to bring about a constitution then, the Constitutional Commission process that resulted in the draft. That draft was rejected by the people. And then thereafter, there was the attempt to bring about the Kariba draft. It was all in response to the need and the quest for the establishment of a democratic constitution. We have also seen the mobilization that has happened in the United States, the Black Lives Matter. What am I talking about here? I'm talking about the fact that it is important that the people of Zimbabwe, we have outsourced the solution to our problems to the courts, to the politicians, and we have stood aside akimbo and watched as spectators. I think it is high time that we reclaim that space that we properly and democratically own. It is not a space that we should cede to the politicians, to the courts, so that they make decisions for us. And then when they fail us, we get to this kind of situation. The current problem that we have is more of a political problem, and I think it needs political solution. We have seen the danger that obtains if a political party obtains a 2/3 majority in parliament. These are the things that happen if people are not attentive and are not watching the political processes that unfold in their country. We had in the last elections, of course, there was a good turnout, but the people, more people focused on the presidential election and forgot about the parliamentary elections. Now we had a situation where ZANU-PF got a 2/3 majority, and they're using that to good measure for their own benefit. And now we have the 2023 elections due in about 2 years' time. The danger that we may have is to have the same political party attaining a 2/3 majority again in that election. You would know that there is trepidation, there is fear that after the historic decision by the 3 High Court judges in the matter involving the Chief Justice, or the former Chief Justice, if you like, now we are not even sure how the Supreme Court is going to deal with this one. My brother, Dr. Makaisa, will obviously speak to the issues surrounding the constitutionality of the amendment and the crisis that it has sparked, and whether we have a Supreme Court that will be able to sit. But the fear that is there basically is that we do not know how the Supreme Court is going to sit and decide the appeal that is pending before it. Because you see, the fear that we have is whether they are going, the judges that will sit are going to really interpret the law, or they are going to interpret it in a manner that is there to assuage certain interests within Zimbabwe instead of the law itself. So my proposal is this: what we need in Zimbabwe, we need to set up. It is unfortunate that the National Constitutional Assembly mutated into a political party. It left a huge space in the Zimbabwean constitutional movement, constitutional protection. So I think what we need as Zimbabweans, of course, with the leadership of the church, and I think the church is key, because the church per se is seen as neutral, is not per se, pandering to the whims of any political party. It is there to protect the interests, or to stand for the interests of the people as guided by the Bible, as guided by God, is guided by those commandments that God gave to us at Mount Sinai. So the constitutional movement that we need is supposed to be, insofar as I'm concerned, a permanent feature in the politics of this country. It should bring together the church. It should bring together the labor, the students, the various residents associations in this country. And this constitutional assembly, movement should be able, its prime mandate should be to protect the constitution. One of its mandates is to go out into the countryside, because we know that the people in the countryside, yes, they've gone to school, but these people ordinarily are cut off from the flow of information, the debates that is going around. But we know what happens when our people have been given that proper information, and it can only be that movement or the coming together of the church and all these other organizations in Zimbabwe that can, in fact, then educate the people of Zimbabwe. Most people do not even know what is contained in our constitution. Yet there is a section, I think it's section 7, that says that there should be an education program that's rolled out to the people, so that the people are aware of the contents of the constitution. So for some people, because they're in the dark, they do not know what it is that we are speaking about. They do not know how this will impact their lives, how this will impact whether the country gets investment, whether this will impact the nature of the education that their kids are going to get. It's because they're in darkness. So we need to shine that light upon these people by educating them, taking our time, so that they appreciate how this constitution seeks to protect them, protect their interests, how this constitution will impact having their kids access the job market, or how it will impede, how an amendment will impede their access to the job market, to a better livelihood, to a better welfare, and how the elderly will be taken care of by the state itself. So it is important to get out into the countryside, to reach out to the people, because this also has a bearing as to how the people will decide the 2023 elections. If there is a party that does not seek to protect their welfare, to protect jobs, to create jobs, because it's mutilating the constitution, then people will be able to make an informed choice and decide which political party they need to put in government, so as to protect their rights, protect their constitution, ensure that their welfare is taken care of. I will stop here for now, Tariro, and then we'll deal with other issues. I mean, maybe when it comes to plenary. Thank you.
Thank you so much, Machova Nangube. I think you have really touched on some really key issues, and I'll just pick a few that I think people should just start thinking around as they prepare their comments and their questions at plenary. Of course, right now, as we speak, participants can utilize the chat box. You can start putting your questions there. You can start putting your comments there. And as we go to plenary, we'll start interacting with your contributions based on the presentations made. But thank you so much, Machova, and I think you have touched on some critical issues. What I've picked out, you spoke of, there's that call for citizens to go back and re-own their space and the power that they have, and not cede that power and space to, of course, political parties and players. There is also the issue of the 2/3 majority, that keeps on remaining being a problem, and it continues to be a thorn in the side of citizens. And you also then gave a proposal, you're already furnishing potential solutions to the situation we find ourselves in, where you are saying we may need to consider setting up a constitutional movement that is a permanent feature, one that is not temporary, but one that is permanent, and one that gives some permanent solutions in safeguarding and protecting the Constitution. And I also like the last contribution that you made, that we cannot continue to downplay the importance of constitutional literacy exercises among citizens, especially for those in the marginalized communities. Thank you so much. So now I'll hand over to our second presentation from Dr. Alex Magaisa. Of course, I know you guys know him as the man behind the big Saturday reads, but now we have seen he has a new baby now, which is called the Constitutional Law Center, where he is a convener. So now, Dr. Alex Magaisa, we hand over to you to hear your views in terms of the legalities of Amendment number 2, to also maybe give us highlights of where we are and where we are going to go to, and maybe the solutions to what some are already terming the constitutional crisis that Zimbabwe is facing. So over to you, Dr. Magaisa. Thank you.
Thank you very much, Tariro, for your kind introduction. Thank you very much to you, and also to the Zimbabwe Council of Churches, and to everybody here for inviting me, firstly in my personal capacity, but also for inviting us as the Constitutional Law Center as we begin to take the baby steps in this very, very important space where we seek to promote and to defend the Constitution. I shall say a little bit more about it later when I talk about the way forward. But for purposes of addressing the issues that you have asked me to look into, I would like to, first of all, say that to this very distinguished audience, I see there are so many people here that I have a lot of respect for, people that I have not met in person, but I've encountered in the work that they do. I really appreciate that they've spared their time to be with us today. So, Dr. Gondongwe, Dr. Mtata, my brother Mashoana, they've all spoken so eloquently about the Constitution, what a Constitution is, what it is supposed to be. Let me just reiterate some of those important aspects of a Constitution. I am a firm believer in the Constitution, and a firm believer in the idea that every person, every citizen, every Zimbabwean must have at least a very basic understanding of what the Constitution is about. This is something that we often leave to the experts, so-called experts. We often discuss it at a very esoteric level, but it should really be part and parcel of our daily conversations in the same way, that we make reference to very important and spiritual texts in our lives, including the Bible. The Constitution is the document or the text that governs how we live, how we are governed. And it is so important that every citizen has a basic understanding of what the Constitution says and what is expected of their government, those who govern them, as well as expected of them as citizens. I look at the Constitution as a product of the nation's collective imagination. It is the product of how we as citizens collectively look at ourselves and look at our future. It's an aspirational document that says, this is the Zimbabwe that we want. I'm happy that the very historic document, the Zimbabwe we want, from the mid-2000s, has been referred to already. It is so important as a compass, as a moral compass, as a political, as a social compass in our nation, because it tells us a collective view, a collective belief in the kind of Zimbabwe that we want. And so we always have to make reference to it. Mashoban and I sat at the table during the constitution making process, and I can assure you that the Zimbabwe We Want document was one of the most important documents that we always made reference to, because it gave us an idea of what Zimbabweans wanted to see about their country. So something that is a product of the collective imagination needs to be believed in by a significant number of people. It's not enough to have a constitution. It's not enough to have 94.5% of the people voting for it at the referendum. People must believe in it beyond that date. And I think this is something that is lagging at the moment, partly because most people are not aware of what the Constitution says, are not aware of what the Constitution itself actually provides for, so that even if their rights are infringed, they cannot even make reference to the Constitution. That should stop. We need people, constitutional champions, who will preach the word of the Constitution, who will explain the meaning of the Constitution, not just to citizens of Harare or Bulawayo or Gweru, but to people in Lotito, to citizens in Chikomba, my home area, to citizens of Nkai. We need people to understand in their language, in the language that they understand, what the Constitution is about and what it means for them and how important it is. Now, another aspect that I should make reference to is the concept of constitutionalism. Some years ago, I wrote an article which I called Constitutionality without constitutionalism, that it is possible to have a constitution but without constitutionalism. And I tried to explain the meaning of constitutionalism. Most lawyers and most political scientists, I imagine, understand what constitutionalism is. But just to say in very simple terms, constitutionalism is about the limits of power. It's about limited government. When we say limited government, we say the government, those who have power, must be limited by law. And so you can have an absolute monarchy, which is provided for in the Constitution. It will be constitutional, but it will be lacking in constitutionalism because there are no limits to that government. When we have a constitution that is constitutionalism, it must contain those limits on power, those limits on those who are holding power. We call them checks and balances. And there are many structures that we talk about. One of them is a principle called the principle of separation of powers, that the power of the president and the executive must be separate from the power of parliament, the legislature, as well as the power of judges, the judiciary. It's so important that you keep these powers separate and in separate pockets of the state, because if you concentrate them in the hands of one person, that person or that institution is going to be dictatorial. And so you need to separate these powers. We all understand this. In our churches, in our organizations, we try to distribute power so that it's not held in the hands of one person. If you do that, you are creating a recipe for disaster, a recipe for dictatorship. And that is what the 2013 Constitution tried to do. It tried to promote the spirit of constitutionalism so that we would have a constitution, but we would also have a constitution that is predicated on the basis of constitutionalism. Now, as a lawyer, I would probably end there, but I don't like to end there because in my training, in my experience, in my reading of laws and constitutions and practices of other nations, which are more successful than ours, I live in a country that does not have a written constitution, but it has worked pretty well for most of the time. There are, of course, people who would like for there to be a written constitution in the United Kingdom. But if you look at it, it has been for centuries without a written constitution, and it seems to have worked. And I've dedicated myself to understanding why it seems to work in that way without a written constitution. For us, every time that there's a problem, you have to say, let's go to the constitution. What does it say? And we fight over a provision. We say, oh, this word means this word means that, and so on. We end up tying ourselves in knots. Here we have a country that does not have a written constitution, but they always seem to find a way of resolving their challenges. Somehow they do. And I've always asked myself, why is it that way? Now, many of you here are more experienced than me in reading the spiritual, the scriptures, and understanding how the world has been in the past. But there is something that is so important, and these are called norms and conventions. Norms and conventions are things that are unwritten, but they govern relations between people. They govern relations between institutions. We use norms in our own lives. There are certain things that we expect a young child to do when a visitor comes to our home. There are certain things that we expect a guest to do when they come to our home, how we treat them. There are no rules that tell us that we must do ABCD, but we do them anyway. Those are the norms. Those are the codes, you could say, practices that have become institutionalized in our lives, in our society, that we just do them as a matter of course, because it's the right thing to do. Now, I want you to understand where I'm getting to with this. Our constitution can never be complete in the way that it deals with challenges that we face as a people. There will always be issues that go outside the written text of the Constitution. So we then have to ask ourselves, how do we resolve those challenges when we're in that space? And this is where the norms come in. This is where the conventions come in. You know, things like mutual respect, understanding that you are a political party, the other is a political party. You are not enemies. You are simply competitors in the field of ideas and how to govern the nation. You don't treat each other as enemies. We need to inculcate a norm of mutual respect between political parties, between companies, between organizations. And I believe it is the same. You've got the Zimbabwe Council of Churches. I would like to imagine that it is also built on that principle of mutual respect between, Christians of different denominations, but nevertheless are bound by a certain code, are bound by a certain norm that keeps you together and gets you to work together. This is something that we need in our political space. We don't have it. Another one, which I often refer to, drawn from one of my favorite books by some political scientists called Stephen Levitsky and Daniel Ziblatt, in a fantastic book called How Democracies Die, is the norm of forbearance. Now, I'm sure you won't understand this, and I'm sure you are better experts than me in talking about forbearance. But forbearance, essentially, is where you say, I have the power to do this, but I'm not going to use that power anyway. You have the legal right to do something, but you don't do it. We ask for forbearance in our prayers. We also ask for forbearance from those that we work with, that we interact with. It's the same thing. What we often see in our political space is that every time there is an issue, people are so pedantic on the issue of rights What does the law say? If the law says this, therefore we should do that. Okay, that's fine. You could say the rule of law. But sometimes there are situations where you might decide that it is not necessary. We have what we call the power of mercy, the prerogative of mercy. It's in our constitution. It says someone has been sentenced to death, but the president can exercise his or her prerogative of mercy to spare that person's life. So we have some of these constitutionalized, but we don't apply them in the way that I think we should do. Our nation is very young. Part of the reason why we don't have a fully developed set of norms and conventions to guide us and to govern us whenever we face problems in our constitutional makeup or setup is that we are a young nation. We are only 41 years old. It seems like a lot, but we haven't done enough in order to develop, these norms that should be guiding us. And we need also a maturity in our leadership. And maturity is not about the number of years that a person has lived on this earth. It's about how you engage others. It's about how you show those values and principles of mutual respect that have already been referenced to. Now, I've spoken a lot about this because I wanted to give context to the issue about the legality or otherwise of Constitutional Amendment number 2. I've spoken about this a lot of times. I have written about this a lot of times. Sometimes I don't even know where to start and when to end. But let me say this. A constitution can be amended. A constitution is not immutable. I'm happy that, Dr. Gonoko has already mentioned that we like to treat our constitution as a sacred document. That's very important. If we treat it as a sacred document, it means that we don't tamper with it unless it is absolutely necessary to tamper with it. Now, our constitution itself has set a very high bar concerning how it can be changed. It is provided for in the Constitution. And for most provisions of the Constitution, you just need a 2/3 majority in Parliament in order to change the Constitution. Now, this is quite a high threshold under normal circumstances, because for all other laws, all you require is an ordinary resolution, which is 51% of the voters. When you have a 2/3 majority, you are putting the level a little bit higher. Now, the issue here is, our problem is that one political party, unfortunately, has a 2/3 majority. And even if people say it doesn't have a 2/3 majority, it is able to summon a 2/3 majority. And it has been able to do so in order to pass the 2 constitutional amendments that we have at the moment. But that's one aspect. The second aspect is that if a constitutional amendment does not follow those procedures, then it can be regarded as unconstitutional. So one of the issues at the core of amendment number 2, and I should also mention amendment number 1, is that there is a dispute over the constitutionality, over the procedure that was used in order to come up with this amendment. The argument is that that procedure does not comply with what Section 328 of the Constitution says regarding how amendments to the Constitution must be done. That's an issue that is before the courts and hopefully will be resolved. The second aspect is that, and this is not often talked about, but it's important that I make reference to it. Apart from the procedural aspect, there are also substantive aspects of a constitution. When we were doing the Constitution, we provided for what we call the founding values and principles of the Constitution. They are found in Section 3. Very important list. Now, whatever you do in the Constitution, if you are going to change the Constitution, then the argument is that you must always be faithful to the founding values and principles of the Constitution. If you don't do that, it means that you are undermining the very foundation of the Constitution. You are destroying, to use the language that is often used in law circles, the basic features of the Constitution. And so it is possible to look at amendment number 1 and amendment number 2 and to say, do they fulfill or undermine the values which are provided for in section 3 of the Constitution? In my opinion, my respectful opinion, there are a number of values and principles of the Constitution which are offended by amendment number 1 and amendment number 2. I'll just speak to one of them because I don't think I have a lot of time to speak about all of them. One of the most important things that we have in our Constitution is the separation of powers, which I've already made reference to. Another one is the issue of transparency and accountability of the leadership and how the leadership is chosen. Now, what you will find with amendment number 1 and amendment number 2 is that they create what we call over-concentration of power in the office of the president. The president now has exclusive power to appoint judges of the Supreme Court and the Constitutional Court without going through the public interview system that was set up under the 2013 Constitution. The president can now appoint the prosecutor general again without going through the processes of public interviews which were provided for under the 2013 Constitution. The government can enter into international agreements and there will be not enough scrutiny by Parliament, which was provided for again under the 2013 Constitution. The civil service, and this is something that people have not looked into, it has been relegated, but it's so important. The chief secretary to the president and cabinet is now effectively the head of the civil service under the amendment number 2. Now, the point I want to make with these few examples is that there has been an over-concentration of power in the office of the president. The president having the power to determine the composition of the leadership of the judiciary, the president having the power to determine the prosecutor general, and all these other elements which are supposed to be political referees. In life, in order to have fairness, when you have two different teams, you need to have a referee who is impartial. And this is why a player cannot be the referee in the game that they are playing. What we are seeing in Zimbabwe right now, the amendments that are taking place, number 1 and number 2, they give too much power to one of the players at the expense of the others. Now, this itself is very offensive to the founding values of the Constitution. And in my opinion, it goes against the basic features of the Constitution. Another aspect is that, and I know that people have talked about this a long time, the issue of promoting or raising the retirement age of judges. Now, let me start by saying that there is nothing wrong with saying that we want to increase the retirement age of judges. The Constitution allows that. It can happen if you get the sufficient numbers to do so. But there are certain things that the Constitution says you cannot do. So number 1, if you are going to raise the retirement age of judges, in this case we are referring to it as the term limit of judges, and I've explained elsewhere why the issue of age is part of the term limit. If you raise it, it must not benefit the incumbents. It must not benefit those who are there. To give an example, if we are going to change provisions about the reverends, the bishops, the pastors who are here, the law says it must not benefit the pastor, the reverend, or the bishop who is in office at that time. If it does that, then you need to change the Constitution in order to allow that to happen. And to change the Constitution in that circumstance, you must go back to the people. It's not enough to have a 2/3 majority, because a 2/3 majority is just for Parliament. But you must go back to the people and say, our people, we said our judges should retire at 70 years. We think that they should retire at 75. What do you think? And if the people said yes, that would go ahead and it will be done. Now, this has not been done under amendment number 2, and is one of the reasons why there is a lot of challenges concerning the constitutionality of this provision. I have some sympathy with the judges of the Supreme Court and the Constitutional Court. And my sympathy with them is that they have been thrust into this position by the government. The government is the one that has gone ahead and made this amendment, passed it into law. The problem is that the judges who are beneficiaries of this amendment are also supposed to then sit in judgment of the legality of that amendment. Now that puts judges in a very embarrassing position where they must make a decision about something in which they have an interest. And that's why we call it a conflict of interest. For me, it's not even about the fact that the judges were cited. Even if they were not cited in the legal proceedings, they would still have been in a position of conflict because they are the beneficiaries of this amendment and they are being asked to make a decision as to whether it is a legal provision or an unconstitutional provision. I think that this is unfair on the judges. I think it is embarrassing to put judges in that position. There was no need, and there was a way in which this could have been avoided. It could have been easily avoided by simply asking the people going to a referendum to say, should we raise the retirement age of judges or should we not? That would have put the matter outside the hands of the judges. But now judges have to deal with this thing, which is putting them in a position of serious conflict. So, I've spoken for too long already. I hope the point that I've made makes sense. Let me conclude by saying that if we are to make headway as a people, we really need to get a grip when it comes to the idea of constitutionalism. I've explained it. Constitutionalism is about limits of power. But for us to do that, we need to get people to understand the Constitution. And Mashoana spoke about the need for a constitutional platform that will do this job. And bemoaned, like many people, the demise of the National Constitutional Assembly, which did fantastic work in the late 1990s, 2000s, putting the constitutional reform issue firmly on the national agenda. We can never be thankful enough for what the National Constitutional Assembly and its founders did for our nation in the crafting of our national narrative. But we're left without that platform. So, over the last few years, colleagues and I have been saying we need to have a platform that will speak to constitutional issues. We already have fantastic organizations that are doing wonderful work. I can refer to organizations that we all know, like the Zimbabwe Lawyers for Human Rights. That's fantastic work. Organizations like the Zimbabwe Human Rights NGO Forum, they do fantastic work. Elections organizations and others. But what we have not had is a platform that is solely dedicated to promoting, to explaining, and to defending the Constitution. I think we need to do more of that in the civic space. We need to do work that promotes research in constitutional issues, to support the work that is done by human rights defenders, that educates even civil society leaders concerning human rights, concerning constitutionalism, that does the same with the media, that does the same with the Christian community. I'm so happy to be talking to you. This is the second time, and I'm privileged to be talking to members of the Christian community, a wonderful platform. We need to do more. We need to do more to educate the people about not only fundamental rights and freedoms in the Constitution, but also about the governance network, framework in our country. How are we governed? Who has power to do what? And what do you do if that power is offended, if that power is misused? We need to have this. We need to make sure that people understand one of the founding values of the Constitution is that the authority to govern derives from the people. The people are the principals, and those who run government are the agents of the principles. The agents must act in the best interest of the principles. If they don't, then they are breaching their part of the bargain. We need to do that. This is what the Constitutional Law Center is designed to do. And I hope that we are going to forge important networks, connections, links, so that we draw synergies with members of the Christian community, the Zimbabwe Council of Churches, and other Christian organizations, and other, of course, religious organizations, so that we are able to engage members of the public, your members, on these issues that are so important. I said in my last meeting with members of the Christian community that if you go to every home in Zimbabwe, almost every home in Zimbabwe, you are likely to find a Bible. That's wonderful. That's great. You are likely to find some religious text. Maybe there will be a Quran, but maybe there will be other religious books. That's great. I would like us, my dream is that every household in Zimbabwe should have a copy of the Constitution in a language that is understood by that household. It's something that the Constitutional Law Center would like to do so that people are more empowered when it comes to understanding what the Constitution is and what it means to them. It should be part and parcel of daily conversations and not something that is left to experts. Thank you, Tariro. If you allow me to go on, I will spend all morning talking about these things. I love them so much, but I appreciate the platform, and I hope that people have picked up one or two things that may be able to use as they go away into their communities. Thank you so much.
Thank you, Dr. Magaisa, for that really comprehensive presentation. I think you touched on amendment number 1 and amendment number 2, but also I really want to thank you for going above and beyond to participate today, despite the fact that you may not be feeling too well. But you have really educated our church members, and I'm hoping that they were following through the discussion, they were following through the presentation, and I'll just speak on some of the main issues that you raised. Of course, the issue of constitutional literacy in our communities is something you have also emphasized on. And you also spoke of the issue that we may have a constitution in written text, but there are some things that fall outside, the written document that can be addressed by possibly the agreed norms and conventions that people use to address certain conflicts that may arise in terms of the practices we have. So trying to merge things that are not captured in the written text of the Constitution, and of course the norms, that govern us as people, that are unwritten, but that govern the relationships that we have with one another as people. You also spoke of forbearance. I think this is something that people have heard today. I think for some, it's a concept that is new to them, where you are saying sometimes you may have power to do something, but you do not discharge that power to do it. And you also spoke of the prerogative of mercy. This is a norm that is unwritten, but it's something that we are practicing. So we are saying when it comes to constitutional issues, things that are not captured in the Constitution, we can actually use the conventions and the norms that we subscribed to that govern the relationships between people. And the idea of constitutionality, you speak of the issue that besides raising the constitutional literacy of people within the communities, but people also need to understand the governance framework upon which the Constitution is premised on, how they are governed, how they can actively demand proper and transparent governance as citizens. I thank you for that contribution. And you also lastly spoke of the issue that people are the principles, and of course government is the engine that makes the principles, that makes the issues of the principles to move. So thank you, Dr. Magaisa. I really appreciate you taking the time and teaching our member churches and our congregants, and also, touching on the important issues they need to know about the developments. I'm not too sure. I think I may need to ask if Dr. Musa Kika is in. He had indicated that he may have been facing an emergency at the moment, but if he's not in, all is well. I'm sure he can join us in the mid-morning session as well. So if he's not in, allow me possibly to move to the plenary session, where, of course, now I think you've been noting down your questions, you've been noting down your comments. We address these to our panelists, Mr. Machoba Nangube and, of course, Dr. Alex Magaisa. So it's now over to you, participants. If you want to speak, raise your hand and we'll identify you and allow you to unmute your mic to make your contribution or to ask your question. So now we are moving to the plenary stage of this conversation. But in the meantime, as I wait for people to raise their hands, I think I'll read the comments in the chat section as well, so that we are all together on this one. So I am seeing there's a very long comment that speaks of what an exciting space for emboldening the role of the church in governance issues. The challenge, however, is that we consider the church to be divided in Zimbabwe. We've got the few prerogative churches and those stuck in regime convertism. The conversation groups stick with and support ZANU-PF standing with whether right or wrong. These church groups, in fact, have been captured by the regime, and for a very long time, we have church leaders on record, for example, instructing their congregates to vote for a certain political party. For me, this is the pivot of our problems, because these church groups do command a constituency, which unfortunately services on church leadership instructions than independent citizens' interests and engagement on the matters of interest. What you have then is a situation where a huge constituency, which as a collective is disconnected from the political debate and engagement, as long as their church leaders have a position to support the regime in all the matters. So I'm now waiting for our participants, those who want to raise their hands, ask their questions to the panelists. So now I'll identify them. I can see Reverend Gibson Botomani has raised his hand. So Reverend, you can unmute your mic and ask your question or make your comment. Over to you, Reverend.
Thank you so much, Tariro, and thank you so much to the two lawyers that have presented so far, and also the theological reflection from Dr. Mtata and the opening remarks. My question goes to the effect on the rule of sub judice. I'm a bit skeptical how we're going to proceed, considering that there is a challenge in the court. How safe are our lawyers, especially Dr. Kika being the applicant to this cause? Is it not that we are actually violating the rule of sub judice, such that by the end of the day, we end up being like the Honorable Minister of Justice, who went on to make a comment in regards to the judgment that was given by the Honorable Justice Joe. Thank you so much, Terry. Just a brief.
Thank you, Rev, for your question. So I think our panelists are noting down and they'll comment and respond. I would also want to identify Hati Nzani Sozayapi. You can unmute your mic, ask your question, or make your comment. Over to you.
Thank you very much, the host. And I want also to thank the lawyers who have presented clearly their positions and helping us to understand what it entails the amendments. My question is, besides the proposed conventions, what we are doing, are there other avenues that can be explored in order to be heard, so that the 2/3 majority alone in parliament cannot take the will of everyone? Because we have voted this constitution in 2013, and now we are now using 2/3 majority to unmask or to tear down what is the will of people have done. Besides the convergence, besides, is there other avenues that can be explored legally that can help us to come out of this mess? Thank you.
Thank you so much for your question. You are saying that are there other avenues that we can explore, outside of relying on the 2/3 majority, which has proved to be quite problematic. So I think this is over to our panelists. I'm sure they are noting down and preparing their responses. I would like to pick on a question that is in the chat section. Someone is saying, what do you think is the role of the church in promoting access to human rights in Zimbabwe? Then, of course, there's a question to Dr. Alex Magaisa. Question to Dr. Alex Magaisa. Let's assume we are in a constitutional crisis, as you aptly put it in the presentation on Constitutional Amendment number 2. What role can the church play to be effective in engaging in addressing this situation from a church's perspective? So this is for Dr. Magaisa. I'm sure he has captured this and is preparing to respond. Then I'll just touch on some of the comments that are coming in. Someone says that the problem Zimbabwe is facing is that everything is politicized. How do we depoliticize the civic space to ensure that citizens are free to engage with each other and help communities to understand their rights? At the moment, that space does not exist. So this is a question again to our panelists. How do we depoliticize the civic space so that people can engage on issues and, like Dr. Gondongwe had mentioned, and not on tissues? I think I'll read the other comments that are coming in. At the moment, I'm seeing no one has raised up their hand to ask a follow-up question. So I think our participants are okay. But now maybe I can hand over to our panelists to respond to the raised questions. And then, of course, we prepare to close this plenary session and this conversation so that we can prepare for the next conversation mid-morning. So, Machobana, I think the questions, we have heard them. Possibly you can comment, you can address and possibly respond to the questions that have been raised by our participants. So over to you, Machobana. Thank you.
Thank you, Chariro. I'll try to respond to the questions that have been raised. There is the issue that has been raised about the sub judice rule. That rule speaks to the fact that one should not comment about a matter that is before the court. What that means is that one cannot, the court is required to decide on. I'm not sure whether Dr. Kika was coming here to comment about the arguments that are going to be advanced in court or those things that have been raised in court per se. I think he was coming here to comment as a private citizen about the amendment number 2, whether it is constitutional or not. He's entitled to make his that are pending before, the arguments that are pending before the court. Then there is a question that has been raised about whether there are other avenues beside the 2/3 majority, so that everyone is catered for when these amendments are being undertaken. Of course, the 2/3 majority is not the only thing that is not set out in the Constitution. The Constitution requires certain things to be done when an amendment is being brought about. The first thing is that the Speaker of Parliament should gazette the bill, the proposed amendment in the Government Gazette. This is primarily so as to inform the people of Zimbabwe, because there is another aspect that comes to the fore: the participation of members of the public in any amendment process that is being driven by Parliament. So members of the public are entitled to participate. They can participate either in meetings, they can participate either through writing emails or letters that are sent to Parliament that then should be taken into account. So what the gazetting of an amendment does is it informs the people as to the contents of the proposed amendment. What the law then says is that what has been gazetted in the proposed amendment should not materially differ with what then comes out in the final act that is then incorporated as part of the Constitution when the amendment is being done. So members of the public, members of the church, everyone is entitled to participate in this process and then be able to say, okay, fine, these are the proposed amendments, and then they make their contributions. If then the final amendment that is then adopted by both the Senate and the lower house and then assented to by the president materially differs from what had been proposed, then we have a right to go to court to challenge and say this is not what was in fact sold out to us. So what you need to do is this then becomes unconstitutional, then the court can set it aside. But then there are of course legal arguments that would have to be advanced in that respect for and against. And then the role of the church in promoting access to human rights in Zimbabwe. This is one of the things that the church is doing, holding, these meetings. What the church is doing is leveraging on technology that is obtaining in our space today in the 21st century. So the church is doing, a huge step in reaching out to the people of Zimbabwe. But soon, I suppose, I want to believe that the COVID restriction will be lifted. I've worked with the churches before, especially in Bulawayo and in Matebeleland, where the churches has invited experts who have come in to do what is called the training of trainers, where pastors from various denominations from across the city, across the region, are then trained, then who then in turn go back to their communities to train the people. So I think what the church is doing now is part of that process, which is key. And because the church is also liaising with the various experts in different, disciplines, it should be able to utilize these resources to reach out to the people so that the people are educated on the human rights that are inherent in them. Most people want to believe that human rights are granted by the state or by the Constitution. That is not so. Human rights are part of us by our virtue of being human beings. They are endowed upon us by God, the Creator. So what then we need to do is to be able to educate the people to know that they have these human rights and that they should enjoy them by participating, whether in a political space, in a religious space, in a space that they're entitled to participate or that they want to participate. I think I'll leave some of the questions to my brother, defer to my senior, Dr. Makaisa, to take up the rest of the questions. Thank you.
Thank you, Machovana Ncube. I think you've tried to touch on some of the questions. So now I'll hand over to Dr. Makaisa to address the comments and questions as well.
Thank you very much, Tarino, and thanks to my brother, Mashone. I always say that we should have one moment, one day when we sit down with my brother Mashawara, my other brother here, Pulu, who is not here, and others. We were right in the thick of things 10 years ago during the constitution making process. And, you know, when I talk about norms and when I talk about certain soft things that are very useful in finding a solution, I think that we could have a few things to say, just as an anecdote. We would have very heated conversations at the negotiating table. Sometimes almost coming to, you might have thought that there would be some physical action between the different political parties and representatives. But there were always moments that united people. And very often we would go to a certain part of the hotel where we sat down and ate together. That eating together, and I don't use it metaphorically, no, it provided a certain atmosphere which was very different to what would have been happening in the negotiating room. You would almost think that you are dealing with two different sets of individuals. You know, the ones who are in the dining room and the ones who are in the negotiating room. But this was always fascinating because sometimes whenever things got very heated at the Rainbow Towers, where most of the negotiations took place, we would decide that it's better to go somewhere. Sometimes people would go to Masvingo or to Bulawayo or to Nyanga. It wasn't because people wanted to have fun, but I can assure you that the change of venue, the change of setting, it made quite a huge difference in some of the ways in which people interacted. It was very fascinating in that way. I remember, if you have watched a documentary film called Democrats, which is a documentary film which talks about some of the things that happened during the constitution making process. There is a moment in which Paul Mangwana, is very angry, very bitter. He's almost shouting at me, or he is shouting at me. And so people, ask, how were you able to remain, calm in those situations and so forth. But what people don't realize is what would have happened afterwards. Maybe the camera did not catch that, because you would probably go outside and have a cup of tea or have a cup of coffee. And by the time you come back, you've probably resolved your differences. I'm a firm believer, and I'm sure there are many experts among you who understand this art of negotiation, art of finding each other. I don't think we do that enough. Someone asked me this question in the comments. What can the church do? Now, my anecdote is not just an anecdote. It is also telling you what the church can do when it is dealing with protagonists on different sides who are seemingly unable to find each other. I think that you can provide platforms, you can provide create events, create situations where you start getting people from different political organizations together, where you start getting people from different civic organizations together, so that there is a meeting of bodies, a meeting of minds, people engage. The more people engage with each other beyond the cameras, you'll be surprised at the results that you can achieve. So, I would encourage a lot more creativity in the way that the church handles the issues concerning political protagonists in our country. As Mashawara said, our principal problem ultimately is political. And it is there that we need to go in order to find a solution. You have got the churches, you've got even parts of the international community. They are midwives. You are the midwives. You are the ones who make things happen without you, it doesn't happen. You assist in getting it done in the proper way. And I think that there can be a lot more creativity, in my opinion, how you can play a role in finding this together. I talked about norms, I talked about values, I talked about principles. These are critical things. I know that there have been efforts, you have tried to bring political actors together. It may not have worked the first time, but keep trying, keep trying. Occasions do arise. And when you do that, you get more, as you get more interaction between them, you get more and more understanding between the actors. Mashawara has already spoken about the sub-judice rule. It is an important rule. I don't need to get much into that. I think he has dealt with that very well. But the Reverend Potomani, I think, who raised that issue, also made a follow-up, which I thought was even more interesting. When you asked, why are we here? What is the effect of November 2017? And I think this is very important, because if we want to understand our problems, we have to also understand the genesis of the problems. This issue that we are facing is an issue that goes directly to the coup of 2017. I say this, and I'm sorry if others are offended by it, but I've always wanted to call a spade a spade. Because if we don't, we end up mistaking it for a spoon when it is a spade. Let's be very clear about it. What is happening in Mali is also very indicative of some of the challenges. These things come in pairs. One comes after the other. The challenge we are facing right now is that we have something that happened 4 years ago, the coup, which left a lot of unanswered questions, perhaps even unfulfilled promises, or maybe even broken promises. And so what we begin to see is creation of nests, barriers, in order to fortify and control the space that is being controlled by individuals against each other. And not just against political parties, but also within political parties. And so it's not surprising to me that we have seen changes to the running mate clause, which was supposed to begin in 2023. That would have had a very fundamental impact on the dynamics within political parties. And the removal is not by coincidence. It is part of managing the internal political dynamics, in my opinion, within ZANU-PF itself. The suspension itself in 2013 was also as a result of attempts to manage the internal political dynamics of both political parties, ZANU-PF as well as the MDC, which was led by Morgan Tsvangirai at the time. I think that my brother, Professor Atam Tambara, is here. He was a lot more closer to the negotiations between the principals, and he might speak to that issue with more authority than I do. But I recall, as part of the lower echelons of the negotiations, that there were a lot of political dynamics that took place there. So I'm not surprised that the running mate clause was removed by amendment number 2. It is a political move within a political party and nothing to do with the national issue. Avenues to challenge it, Mashawara spoke about it. Please, please, please. I don't care which political party it is. It could be ZANU-PF, it could be MDC Alliance, it could be MDCT, it could be any party. Never give one political party a 2/3 majority. If you give one political party a 2/3 majority, they will play around with the Constitution. It doesn't matter who they are. It doesn't matter who the leader is. Don't trust them with a 2/3 majority. So how do you not trust them? That's why people should vote in a tactful way when it comes to elections. Please be careful as you go to 2023. Some of us raised this issue in 2018, and we said, even if the presidential election goes one way or the other, please don't let one political party have 2/3 majority. Because when you do that, you have given them a passport to change the Constitution. Nevertheless, there's something that I also want to raise about the Constitution. We were careful during the crafting of the Constitution to realize that if we let the Constitution be subject to changes by a 2/3 majority, all of it, then it would be at severe risk of changes. So we realized that there were certain parts of the Constitution that were so important, so sacrosanct, if I may use that word, that they cannot be changed even by a 2/3 majority. One of those parts is what we call the Bill of Rights, the Declaration of Rights. Provisions of that part of the Constitution cannot be changed without a referendum. You need a 2/3 majority, and then you need to go to a referendum. So if you want to change the freedom to demonstrate and petition, for example, that would have to be subjected to a referendum, and people would have to vote on it. Now, the other parts are exactly what Amendment number 2 is trying to do, which is extending the term limit of anybody who is in office, such as the president, or in this case, the judges. According to our Constitution, that cannot benefit the incumbents. If it's supposed to benefit the incumbents, then it means you have to change that part of the Constitution. And that part of the Constitution cannot be changed without a referendum. So we had some inbuilt mechanisms beyond the 2/3 majority in order to prevent the mutilation of important parts of the Constitution. Now, some of you might say, well, you should have done that for the rest of the Constitution. Well, I understand that. But there are certain things, that really, having a referendum is an expensive exercise. And sometimes there might be a mistake in the Constitution, maybe a word which was misplaced. You need to change it. You can't always go to a referendum just to make that change. So again, as I said, this is where the norms and values come in, those unwritten rules. There are certain things that you can do and certain things that you can't do. If those norms were applicable in our situation, I can tell you one thing. The government would not have proceeded with an amendment which benefits the current judges, and in particular, the current or the former Chief Justice Malawa. They would not have done that. They would have exercised more respect toward the Constitution. They would have exercised more forbearance. They would have actually gone to the people as required by the Constitution to ask them whether it is proper or improper to extend the term of office of the Chief Justice. So in my opinion, there are a lot of things that can be done. Depoliticization of the space, it's a huge job that has to be done. We have become so polarized as a nation. But as I said, this is where the church comes in. This is where civic society comes in. This is where, our organizations come in to try and find a way of bridging the gap between people within communities, rural and urban, as well as, even within the political parties themselves. We need to have more dialogue, more platforms of engagement where people talk about their concerns and they appreciate that they are being listened to. May I conclude by saying, you cannot solve the future without attending to the past, to past grievances. And, our country has gone through severe turmoil and trauma, the trauma of the liberation struggle. It has left a lot of people with many scars. The trauma of Gukurahundi, which, I cannot even say has left scars. There are gaping wounds which exist. We talk about the 2008 election violence sometimes as a separate event, but there was even a lot of violence that also took place, Mrabachina, the 2000s and so forth. Now, we make the mistake of saying we can bury our heads in the sand, sweep all that under the carpet, and hope that when we take our heads out of the sand, everything will be bright and beautiful. It doesn't work like that. Even today, people who committed atrocities during the Nazi regime in Germany, decades ago, those issues are still being attended to. Why is that so? Because it is important to understand the hurt that is felt by people who have been the victims, who are survivors, people who have lost at some point in our history. We cannot ignore that and say that it's in the past, because no, it is not in the past. It is in the present. When we talk as a church, when we talk as organizations, as actors in our civic spaces, we need to acknowledge this and to deal with these issues, because if we don't do that, we are simply transferring that burden to future generations. And as future generations come with less knowledge, it will be more difficult to solve those problems. And I think that we need to do more. I would like to see the church doing more to working on these issues of national healing. I know that we have the National Peace and Reconciliation Commission. For me, it has been one of the greatest disappointments of the new constitution. I would like the church and others to play a more prominent role in dealing with these issues that stand between us and ourselves. Thank you.
Thank you, Dr. Magaisa. I think we are now coming almost to a close of this session in the morning. But before we close, I think I'll just ask our panelists just to tie this in and give their closing remarks in terms of where to from here. What now? What do we do? What are the recommendations? So briefly, in under 2 minutes each, Dr. Magaisa and Machoba Nangube, let's just tie in our presentations and conclude. What do you think is the solution of what we are experiencing right now? Where to from here?
Thank you, Chariro. Like we have already said, the Constitution is such an important document. Dr. Magaisa has alluded to our various conversations during the time when we wrote that document. This is why we are so worried, some of us were part of that process, that document is then being torn to shreds today. But however, it's not all lost. If we consider that the constitutional reform agenda or agitation took so much time to bring about fruit that we had in 2013, and that we are seeing being unraveled now, we as a people need to come together. I'm happy that Dr. Magaisa is doing something, has already taken leadership. I think what we need to do is to join forces with him, bring together more people on board so that we defend the Constitution. We may have lost for now, but we have not lost the war. We have lost the battle. We can always go back to this Constitution if we push properly, putting our heads together. This Constitution will be re-enacted. Thank you.
Thank you very much, Mashana. I don't have anything much to add to what I have said. When I spoke earlier, I thought I was actually doing my closing remarks. But just to say that I think that, as Zimbabweans, we need to get a grip on the Constitution. We must know it the way that we know other important texts in our lives. We must recite the Constitution from an early age. We want to go back to young kids in primary school so that they begin to understand and talk about issues to do with the Constitution. This is a long haul. What we have gone through, as Bashar has said, is a battle that is still in motion, still in play, but there is a longer process. If we don't really get up and do things now, I can assure you there will be more amendments. The last Constitution was amended 19 times, and every time people thought that was the last time. So there are more amendments that will come, and the sooner people get together and understand what needs to be done, defend the Constitution, then I think we are going to have serious problems. So we must continue, look ahead. For me, I'm not even just focusing on amendment number 1 and number 2. these battles will go on, but we must look at what else might happen in future, and we must try to prevent it. That is, for me, what is more important at this particular time. These amendments and the battles over them should reawaken every Zimbabwean to the possibility, in fact, the probability that there's going to be more amendments. And so how do we get together to stop that? And we hope the Constitutional Law Center will play its part in trying to conscientize people, explain the Constitution, but also to defend the Constitution. Thank you very much, Tari. Thank you.
Thank you. I'd like to express my sincere gratitude to both Machoba Nancube and Dr. Magaisa for this. I think it was well read, and of course one that raised awareness amongst our church members. This session was quite insightful, and I think it also provoked us to start thinking around how we can locate ourselves as the church in providing solutions to this challenge, which is not a challenge for only political parties alone, but also it's a challenge that is affecting even the ordinary citizen of Zimbabwe. You know, so I thank you very much for taking the time, for being part of this conversation. We appreciate you, and I think I will officially say that this session is closed. So we will reconvene at 11:20 for the second conversation, the politics around amendment number 2. So thank you, colleagues, for joining in. We can take a break, and those who want to reconvene or come back for the next conversation, 11:20, this is the place where we'll convene. Thank you so much, colleagues. Thank you. Hello, colleagues, how are you? So I think we are now preparing to have the second session for the Constitutional Symposium. So our panelists, we have three panelists. We have Mr. Richard Mahomva. He's an academic and he will give us the view from that angle. Then we have Miss Linda Masarira. Of course, she will give us her view as a political actor who's a presidential aspirant. And lastly, we will have a presentation from Senator Komichi. Of course, I think we need to understand why he voted no for the amendment in Parliament. So without really wasting much time, I'll start by welcoming our panelists and welcoming our participants. Thank you so much. I know some of you are coming from the morning session and you are with us here. I know it's not easy, but I know people want knowledge, people want to understand. This session is mainly to discuss the politics surrounding the amendments and also in terms of how political actors are going to be affected by the amendments that are now law. So without wasting much time, I will ask Richard Mahomva, an academic, to just take us through his understanding of the amendment number 2 and how as an academic he perceives this as something that is either, is it progressive, is it retrogressive, that it speaks to the culture that we want to have in terms of constitutionalism and of course the rule of law. So Richard Mahomva, over to you. You can unmute yourself and make your contribution. Thank you. I'm not too sure if Richard is in. I can see him being reflected there. It's only his video that is reflecting. Maybe he can try to switch to audio so that he can make his presentation. Richard, over to you. Okay, in the event that he's not yet in, I think maybe he's trying to fix his connectivity. I think it's okay that we move on to our second panelist, Miss Linda T. Masarira. Linda, we just want to understand your perspective of these amendments that have happened. You know, we have a very big question right now where a lot has happened in the past few weeks. The amendment passed into law. There have been these challenges that are now coming as an aftermath to the amendments. And now we see there are quite a number of cases in the courts, but also would want to understand where does the ordinary person locate themselves in such processes. And I'm sure our church members want to seek clarity as to what these developments may mean. And also we want to hear the perspective of you as a political actor. What's your perception about these amendments? Where do you think we can go from here? And how can we remedy what some are calling a constitutional crisis, if you believe that there's a constitutional crisis? So over to you, Linda. Thank
you. Good morning to everyone who's participating in this symposium. I would like to state that we actually do have a constitutional crisis in Zimbabwe that a lot of people don't even appreciate the importance of constitutionalism and the importance of playing their role, their part when it comes to constitutional issues. It is unfortunate that over the past 8 to 9 years since we've had this new constitution, I think it's about 7 years now, we have hardly had constitutional awareness programs that go down to the grassroots. We have just had civic society reaching out to the same people time and again, and sometimes maybe to deplete the donor funding that they'll be having, which has left a vacuum with the ordinary Zimbabwean at the grassroots, who do not even understand what constitutionalism is and the importance of holding our constitution in high regard as the supreme law of this land, as enshrined in Section 2 of the Constitution. That is why you'll find that we still have a lot of hullabaloo over constitutional issues, because when these things are happening, we have a certain section of the Zimbabwean society which says these constitutional things are things for the politicians, or maybe things for those in power or in governance issues, and people don't really understand how constitutional issues affect their day-to-day livelihoods as well. So when I look at it, we need to also appreciate the fact that the constitutional responsibility of the National Assembly is to make constitutional changes in line with trends and as demanded by the electorate. When I was listening to Alex Magaisa speaking, there's one thing that struck me when he said, we should never give a single political party two-thirds majority. And he was very right. But when we also go back to the political economy, they do not have an appreciation of the importance of having a multi-party democracy and having diverse representation of different political parties or groupings of people in our parliament. We have suffered from politics of patronage, politics of personality since 1980 in Zimbabwe. And that has led to so much toxicity, so much polarization in our political economy, to the extent that people do not even understand why they vote. Now we've got a lot of activists coming out, crying out loud that the constitutional amendments are illegal. But when we look at some of the operational ways in which these amendments was done, they were done in line with the role of parliament. The political implications of this is there's been too much tomfoolery in our main opposition party in Zimbabwe, that is the MDC, since 2018. And I think whatever has been happening within the MDC has affected a lot of citizens in a lot of ways. They lost a lot of seats by recalling different MPs. They've been fighting against each other at the expense of the electorate. And either way, even if we still had those MPs who were recalled, with ZANU-PF having had two-thirds majority after 2018 elections, amendment number 2 was still going to sail through. I personally feel that it is abuse of office by the ruling party to make constitutional changes for its benefit without considering the will of the people. We all know how the constitutional amendment number 2 was done. Even the consultation processes was done during the lockdown period, and they were done online. Most people did not even know that the consultation processes were going on. And I feel that they should have given it time to get the bill to the people, so that people also participate in what they felt was not supposed to be done. So basically, I feel when it came to amendment number 2. Thirdly, the way that the issues that were supposed to be amended were just packaged into one bill. That's also made people to just vote maybe for something that they were in support of, and maybe they did not support some other clauses which were meant to be amended. I'll give an example. I've liaised with our various women MPs in parliament, and they said they voted yes to the amendment bill because it was extending the 60 proportional representation seats. You'll find that some other people were voting for their own interests or things that they thought were applicable to what they believed in. And that will take me to our political crisis in this country. We have had MPs who represent the interests of the political party that they are coming from, at the expense of representing the interests of the electorate that voted for them to be in parliament. That is the biggest tragedy of our politics in Zimbabwe. Very few MPs go back to their constituencies even to consult on such issues. And that also goes back to the whipping system that we have in parliament, where MPs have to toe the party line at the expense of those who vote them into office. And then we also have the electorate not understanding the roles of the MPs that they elect to represent them in parliament. That is why we will continue having this disconnect between the elected officials and the electorate. So the implications of amendment number 2 depend on the particular clause from my perspective, because when I look at the removal of the running mate, I see that we will not have a vice president who can hold the sitting president to account. And that was a very important clause, which I feel that even the time that they decided when they were drafting the constitution, they put that into consideration, that it is necessary to have a running mate, checks and balances, so as to check the power of the president. Absolute power corrupts. And as long as we continue to have appointed vice presidents, we will never move away from politics of patronage and politics of loyalty in this country. And we will never be effectively able to deal with pertinent issues like corruption as we would, because everyone has to be towing the line of the president for them to maintain their political seats, which they get through appointment. When I look at the 60 proportional representation seats, I am very much against the extension of the 60 proportional representation seats, because I view it as an extension of systematic elimination of women from governance issues. But this is one thing that women have not put into perspective, especially women in politics in Zimbabwe. It is unfortunate that women in politics continue to be used as pawns in the game of political chase, and the extension of the 60 proportional representation seats to 4 parliaments also reflects on our government's unwillingness to comply with the constitutional provision enshrined in Section 17 of ensuring gender balance in organs of the state and all government organs. Women are not children of a lesser God and should not be pretentiously handed power on a silver platter in the name of quotas or affirmative action. Who does these quotas benefit besides the male politicians in parliament? Women are forwarded on party lists, and we all know what the selection processes are like, especially for people who are in politics, the violence, the skullduggery, the manipulation, the sexploitation that happens when women are about to be forwarded into these party lists. And I thought that our parliament was going to respect the decision that political parties did at the Gender Commission in Daba, which happened in 2019 at Golden Peacock Hotel in Mutare, where all political parties represented there, that was mainly ZANU-PF, MDCT, MDCA, and LEAD, made a strong resolution that we did not want the extension of the proportional representation seats because of the abuse that women went through, and that women were never chosen on merit, but were chosen by being the best bootlickers of political party leaders. These seats have been used to divide women, to give them unequal opportunities to contest in primaries, as they are constantly reminded that they have 60 Bakosi seats. With these seats, women are just given an illusion of power, which is non-existent. So at the end of the day, when the resolutions of the Gender Commission are also not respected by our parliament, we actually start to scrutinize on whether they should exist or not, because it is important for the women's voice to be heard and to be respected by our parliament. But the extension of these 60 PRS seats just showed some of us that women are still viewed as second-class citizens in this country, and that our government does not even respect our constitution, because Section 17 of the Constitution of Zimbabwe is clear on the issue to do with gender balance. So maybe we'll take it back to the narrative that patriarchal dominance is real in this country, and we are not even at that stage where we will view every human being as an equal in this country, because we want to continue giving women quotas, yet power is not given to anyone on a silver platter. And when I look at the constitutional amendment on the public protector, I think this position is very vital and very important. However, the appointment is supposed to be broad-based and led by an independent commission made up of members from different political parties who then from time to time sit to interrogate, supervise, and oversee the public protector for the sake of the accountability. And I am also in support of the increasing the clause that increased the number of ministers who are non-constituency MPs. Why I'm in support of increasing the number of non-constituency MPs is the fact that our constitution does not provide for academic qualifications for MPs and senators. This means any person, including some who can't even handle ministerial positions, were being given those positions and performing terribly in those positions. So I think this provision also gives a sitting president the room to include technocrats into his cabinet, and reducing chances of ministers being involved in factional battles, whilst improving efficiency, and not having ministers who are tied up to the issues that we have seen, which have characterized our former ministers in this country, especially those who are coming from political parties and who are constituency MPs who want to ensure that they do not go against the president's will. So it will bring me to the last fact, which is the contentious issue, the extension of the Chief Justice. And I think my contribution on this will be quite controversial. Why? Because we also have to put into consideration the fact that any government will want to protect its interests. We've seen this world over. It's just not unique in Zimbabwe. But at times when we view things as Zimbabweans, we want to say, why has this happened? They want to entrench this particular narrative. But we also have, in countries like America, the president being responsible for the appointment of the Chief Justice. We also have Chief Justices across the world who are over 70. And any sitting president all over the world will ensure that they have a Chief Justice who serves the interests of the sitting government, and that is the reality. We might come up with all academic explanations on how this particular narrative is wrong, but at the end of the day, most of the issues that we're dealing with are good for the progress of this country, but every politician will do what is in the best interest of their own particular interest. I'll draw us back to the 2013 constitutional amendment. I'm one of the very few people who voted no for the constitution. Why did I vote no for the new constitution? I had not seen the draft. I had not gone through it. I did not know its contents. We all know that the consultation process as well was done haphazardly. Both MDC and the ZANU-PF and the other MDC went around Zimbabwe encouraging everyone to vote yes for that constitution. And at that particular time, the late Morgan Richard Shangirai also thought that what was in the constitution was going to be best for him and whatever that they wanted to pursue later on. But the error that Zimbabweans made was to just listen to the political leaders without interrogating the contents of the constitution. And now we're at a stage where some people feel that these clauses that we put into the constitutions are not okay, we have to amend them. And then we go back to the 2/3 majority, which Dr. Alex Magaisa was speaking about. When it comes to everything that we are facing right now in Zimbabwe, I think the problem goes back to the political ignorance of the political economy, who are just moved by mob psychology.
I think we have lost Linda there. I'm not too sure if she's still on so that she can carry on with her presentation. Okay, I think we have lost her there. I think she has rightfully unpacked
the constitutional issues. Aaron?
We had lost you for a minute there, so I think you may need to go back a little because you were silent. So go back a little, I think the last 30 seconds, and then you can proceed. Thank you.
Okay, so I was talking about the importance of having the electorate understanding the importance of upholding the Constitution as supreme law of this country. As long as we keep constitutional issues around the politicians, the church, or people in governance, we will not resolve the constitutional crisis in this country. But when people understand that when this particular issue is happening, it's a violation of my rights, we will have people that are woke, that are able to challenge whatever they are being told. But the scenario we have in Zimbabwe right now is people will just listen to their political party leader, even if that political party leader is leading them astray because they're ignorant of the importance of constitutionalism. Like I rightfully said earlier on, that when some people view some of these debates that we'll be having, they just view them as academic things. They don't understand how they affect their own livelihoods. So there is a lot of work that needs to be done to ensure that we get Zimbabweans understanding the implications of not participating in any constitutional bill consultations that happen. And we also need to take our parliament to task that when they're doing these consultations, information should be disseminated to all corners of Zimbabwe so that people come and participate. Time and again, I've challenged the parliament on why information seems to be concealed when they're doing bill hearings. And that is something that everyone has to ask out boldly and say, why is it every time when there are amendments which are supposed to be done or when we have bill hearings, the information seems to reach to a very few people? And why do MPs not go back to their constituencies and have meetings in the constituencies, getting feedback from people on how they feel on some of these amendments that will be going through? At the end of the day, every political party leader in Zimbabwe has got the responsibility to teach their followers on the importance of constitutionalism. I thank you.
All right. Thank you so much, Linda, for that quite comprehensive presentation. I think she rightfully unpacked some of the proposals that are now law. And I can see that there are some proposals that she agrees with, and then there are some that she doesn't agree with. But of course, I'll just highlight, I think, the ones that she agrees with that are quite controversial. I think she speaks of the issue where she agrees that there is need to increase the non-parliamentary ministers from 5 to 7. She agrees with that. Then she also agrees with the tenure of judges, to say that I think we should allow them to sit on the bench beyond the age of 70. But of course, there are issues where she was saying with the women's quota, I think she doesn't agree with prolonging it to beyond 2023. And also she speaks of the issue of the running mate clause, to say it should have been given a chance, to go into operation, but it was removed before it was given a chance. Thank you, Linda Masarira, for that presentation. I think we'll move over to Senator Komichi. Why we invited him here was because we need divergent views, of course, but because we want to understand that he was one of the senators who voted no against the amendment. So we want to understand why he voted no, why he felt that this amendment might not be in the best interest of the citizens of Zimbabwe, and hence his vote for no. So Senator, you can unmute yourself. Over to you. We want to hear your view. Thank you.
Thank you so much, and greetings to all people that are participating at the moment. Let me just give a small background to how this constitution was then achieved. Remember, we had a protracted struggle for a very long period in Zimbabwe for rewriting of the part of the national constitution. Remember, people were arrested, many people were abducted, and demonstrations were took place in Zimbabwe. People trying to force the government to agree to the rewriting of the constitution. And finally, it was agreed. And a very noble process was was then put in place called COPAC, in which 70% of the society, churches, and others were involved, and only 30% of the political parties were involved in the drafting of the constitution. And I remember people, general public, from the rural areas in urban centers, the church members, the business community, students, women and youth, farmers, miners, vendors, and so many people were involved in the whole process of consultation, which therefore means this was an emotional process in which people really felt and thought that we are now going to be building our own national constitution. And a lot of work was done all over the country. So people really owned this document, owned the document. And when it came to the election process, remember more than 3 million people voted for it, and all political parties, churches, business community were involved in the campaign for it to pass. And the vote no was really defeated, and then vote yes was in a huge majority. And that on its own, we must respect that. We must respect that. And if we've decided to give the power to the people, let's make sure that the people remain with the power of governance in the country. This process on its own meant that the government was going to be accountable to the people. This process meant that one day the people would question whoever was governing them, if ever they've gone wrong. So it was an emotional process. So the document was then drafted. And remember, this document was out of a negotiation process. It was not MDC who dictated the pace or ZANU-PF dictated the pace, but people sat down, people negotiated, agreed on things that were supposed to be, that were put in the constitution, agreed, and finally the document came out. And this document brought the spirit of unity among Zimbabweans. There was the spirit of togetherness, trust, confidence, and a once highly polarized state found ZANU-PF people, MPs, and ZANU-PF and MDC MPs sharing the same vehicle, going to consult the people, sharing food when they were moving around the country, sharing ideas when they were moving around the country, sharing the same platform to talk about the same group of people. They became friends. Remember, before COPAC, you could not greet a ZANU-PF person if you were an MDC person. That antagonism was dealt with through the process. So the process built a new Zimbabwe. The process built trust among ourselves as Zimbabwe. And today, we are putting all that under threat. And for the first time, ZANU-PF supporters and MDC supporters began to share jobs, felt sorry for each other, even shared regrets of violence, shared stories of war. A strong mutual relationship was established. Why would you want to destroy that? Why would you want to destroy that? This was the new beginning. After having gone from 1980 with so many conflicts in the country, and many others conflicts, and Zimbabweans hated each other so much. And I felt strongly that the 2013 Constitution dealt with those emotional issues, which really built the foundation for a united nation, so united country, and that cannot be underrated at all. We need to make sure that we maintain that and we build on that. Remember, there was a big idea behind the writing of the new constitution. Our worries were that the powers were too much centered in the office of the president. Many Zimbabweans felt strongly that President Mugabe was too powerful, was too strong, and everyone feared that man. You could decide whether you need to live or you need to die easily like that because of the powers that he had. So you remember, even if you go back to the 2000 referendum, people voted against that draft constitution simply because they thought that the powers of the president were not diluted. So the 2013 Constitution dealt with that concentration of powers, and a lot of power was then distributed to many other institutions, such as judiciary. Judiciary is stated in the Constitution that it derives power from the people. Parliament derives power from the people. The cabinet, the president, it derives power from the people. And the independent commissions, chapter 12, supporting democracy, also took some of the powers, and the main other institutions that are in the Constitution. And the whole idea there was to make sure that we don't have a big man, a big, strong man kind of a president, a man who would be termed a dictator. And the Constitution dealt with that idea very effectively. So if you then look at the amendment number 2 Act now, it actually reverses all that, because within the omnibus of the amendment number 2, there are 2 issues which are of power, of power. Which remember, the one dealing with the running mate, the power issue, one dealing with the appointment of the judges is a power issue. And those issues really naturally would give the power to an individual or to an office. Like if one decides who becomes my vice president, I would choose the one that would never even threaten me, or anyone who even contest my ideas. I would do that. And if I am to choose judges again willy-nilly, I'll be able to select my own team, rebuild a partisan the setup, and in so doing, you are moving away the power of the people from the process of building up a fair judiciary. You are moving up the power of the people again from holding that judiciary accountable, because at the end of the day, you will see the judiciary will become partisan, and the judiciary will act in a manner which would please who then appoints them. Yes, of course, you know the president is the head of the government, and is also the head of the state, which means he's the overall big man in the country. But he has to make sure that he practices those responsibilities with due care. The fact that the Constitution was crafted in such a way that he cannot abuse his powers to influence these institutions. We need to protect that kind of checks and balance which are there in the Constitution. So at the moment, if we then continue to amend the Constitution, we are removing these checks and balances, and power is sweet, power is corrupt. Power can corrupt somebody, and who knows? We make constitutions. We don't make constitutions for the angels. We make constitution for Lucifer and this team. So we are worried about the Lucifers in this team, who then one day become our presidents or our prime ministers. And we need to make sure that their powers are always put in check. And we also wanted to make the Constitution also took care of the doctrine of the separation of powers and the principle of independence of independent commissions as such. And these must be protected. And if we do not protect this independence of our commissions, and also make sure that we respect the separation of power, we would end up having all these institutions, playing second fiddle, or they will not be able to play their role, which is to protect the Constitution of Zimbabwe, also to protect the human rights of the Zimbabweans. So the idea here was to create a democratic president, and a democratic president is what we want to see, and we must protect this idea, because anything that goes against the idea of establishing a democratic president will slide back into a president whom we had for 37 years, and we suffered quite a lot under him, and we cannot go back to that. One of the weaknesses that I want to share with you here is the amendment of the Constitution using parliamentary route. Parliamentary route has got its own dangers. Basically, And technically, theoretically, the parliament is supposed to bring that to, yes. But practically, it's very, very, very different and it's very, very difficult. ZANU-PF has got a supermajority, for example, in the Senate, where I am. MDC totally approximately 22 senators, which therefore means ZANU-PF plus the chiefs constitute 58 senators. And for it to achieve this, the supermajority, the two-thirds majority, they need 54 votes to get the two-thirds majority. So it's so easy for ZANU-PF to get two-thirds majority in the Senate. In Senate, although it is perceived to be a democratic process, come out laws, the perception, the reality is that we apply what is called the voting system, which is basically the partisan voting system. And it has been demonstrated over a long period of time. And you would find in our structure, in our setup in the Senate, although chiefs are regarded as neutral people, but when it comes to voting, they've always voted along with ZANU-PF. Although they are not ZANU-PF, but they voted ZANU-PF. So technically, the figure 2/3 is so easy to achieve in the Senate. So the parliament route therefore destroys or kills the spirit of unity that was created by the COPAC system that brought the constitution in 28. Because in 2013, so whilst we wanted in 2013 to establish a mutually agreed process of which brings unity, togetherness among Zimbabweans, which is the foundation and the platform for future national dialogue and future nation building. This is actually being destroyed by the process that we use in parliament. It actually recreates polarization, which was dealt with during COPAC time, and it destroys the relationship which had been built during the COPAC system. This system is inferior to national dialogue approach, which therefore means that's why there's been a calling, and some of us have been supporting the idea that the Zimbabwe must engage itself in a process of national dialogue, which is inclusive, which is basically what we went through during COPAC time. So we need to look at this as Zimbabweans and really say, if we had really gone through a similar COPAC structure to deal with the amendment number 2, which we are dealing with today, we could have achieved an agreed outcome. People could have shared the fears that they have in amending the constitution. People could have shared new ideas of improving our document so that it's going to be democratic and inclusive. So therefore, this particular moment calls upon the Zimbabwe to relook at the idea of the national dialogue, which is inclusive, because Zimbabwe has been put under restrictions in international isolations and many other challenges. The economy of the country is sort of depleting every day. The political environment is not improving, and which therefore means the country is ripe for a national dialogue. And to me, what I really preferred when I was voting no, I wanted at least people to start to engage, people to start looking into issues where we can discuss this thing around the table, other than using the competing, the big men tactics in dealing with matters. If it's not me, then it's not you, and we need to make sure that we go back to the idea of national dialogue. Whatever is agreed through a process of national dialogue, Parliament would have no problem at all, and people would have been included. Even the public processes which my counterpart was talking about are done. If you look at the report of the public consultations which were done about this amendment number 2, people rejected it. So what? At the end of the day, Parliament will decide. Parliament will vote, and the ZANU-PF will achieve the 2/3 majority very easily. So we can consult people, but at the end of the day, we don't do that. So again, it calls for the need for the people to engage through a dialogue, because any other form of contestation it will not help us at all. So therefore, we need to make sure that we look at the issue of dialogue. There's a perception also third point created by amending the constitution, especially the number 2, the amendment number 2X. This put the risk of a president who would then appoint his personal friends to the bench. In the process of appointing his personal friends to the bench, he is instilling fear in the judiciary system itself. It destroys the confidence in the institution. The people lose confidence in the institution at all. People will simply go to the courts and, if it's just a chin, and they will have no respect for the judgments. And all those things, they need to be dealt with. The process of appointing judges is so easy without any other checks and balances, what were there in the constitution. It creates a dependent syndrome in the institution. The institution will survive. The men and women who survive in the institution will be basically those ones that would be regarded as they cannot challenge the president. And no future, if you don't play the ball mentality, will be created in the bench. Like people would simply say, if I don't play the ball, therefore I cannot survive in this institution. One of the challenges that I've seen for the past years is in that no bench in the last 37 years has ever challenged the decision of the president. It was a known fact that if any case involved Robert Mugabe, President Robert Mugabe, by then, you would know the outcome. The outcome was predictable, minus the fake case of Jela Samuel of 2013, which challenged the 31 July election date. That thing was fake, was stage managed for Mugabe to lose. It wasn't that he wanted to go to all the elections on the 31st of July 2013. All that is coming back if we are not careful. It's coming back. I would wish to see a situation in which the judiciary is able to challenge a case in which the president is involved. We have seen this in Kenya, where the voting elections were nullified. We have seen this in Malawi, that where we saw the result of voting nullified. This is, we would wish and would want to see this happen in Zimbabwe. So, because that would mean that the judiciary is independent. The judiciary plays a key role of the doctrine of separation of powers, and it's not under threat from anyone. It's an independent institution. We want to see that. But the process of amending the constitution, as we see it in the amendment number 2, it gives us an impression that we are going towards a bench that would be intimidated, a bench that would never challenge any idea coming from the president's office. And that's dangerous because it creates a big man president, and it creates a situation where people feel fear is going to be established. And therefore, it creates a partisan bench. If you remember, during the Mugabe time, you would do, if you were involved in a clash between ZANU-PF and MDC, and you could go to the police, you would find out that the police would be, whether an MDC person is wrong or right, would be arrested and jailed and put in the cells. The ZANU-PF person, whether wrong or right, he would be freed, because that created a very weak institution. One of the characteristics of good governance and the characteristics of a strong government is to have strong institutions around the government. Strong institutions are built around to build a very strong government. Institutions such as independent institutions must be strong. Institutions such as judiciary must be strong. Parliament must be strong. NPA must be strong. Police must be strong. These institutions build naturally a very strong government. But if you threaten these institutions and you fill them with partisan people, and you fill them with the people that are weak, because this is, at the end of the day, the aggregate of these institutions constitute a strong government. Therefore, if you have institutions that are very weak, as we are likely to be having in a very short time to come, the government itself would become also very weak. And the moment the government is weak, no investor would want to come in a country where institutions are weak. So it therefore means the economy is going to continue decaying. And no investor would want to come in a country where there's no strong legal framework about his or her investment. All that will affect. And the peace among the Zimbabweans themselves, the freedoms of the Zimbabweans themselves would be threatened as long as the institutions are weak, because the rights of the people are going to be under threat. The human rights abuses are going to be increasing if the system, if the institutions are not strong, because they would always want to play a ball for them to survive. There are also major fears that are there in amending the Constitution. One of the number one fear that we are all afraid of is to be going back to the Mugabe era of a strong president. Mugabe was one man who was feared by everybody. To me, in my assessment, people were never afraid of the CIO, and the people were never afraid of the army. People were actually afraid of Robert Mugabe. To prove my point was that when the army and the CIO were involved in the 2017 uprising against Mugabe, people were found riding on top of the armored cars. People were being taken photos with the army in the military gear, which therefore the men that they were real afraid was Mugabe, because of what he did, of the character that he built himself throughout his leadership period. So we don't want to go back to that period, and that can be recreated by amending the Constitution and developing too much powers in one place. Another fear that we had is the serious human rights abuses, which are likely to be on the way. Because at the moment, a man has got so much powers, office is so many powers, and if that office is threatened by any other democratic process or any other means, there's bound to be abuse of that office. And another fear that we had, major fear that we had, is fear the international isolation of Zimbabwe, even by our regional partners, because really people are going towards the democratic process, transition processes. People are going towards the process of inclusivity in terms of the governance systems. But if we go back in this arrangement in which the governance systems isolates the people themselves, therefore even other countries will start doubting us. Our intentions will be doubted. We are going towards 2023 election at the moment, and we would expect a free and fair election to be put in place. But as we now we've embarked on amending the Constitution, we are anticipating in a democratic election in 2013, and therefore it means violence will be really big. One of the major issues that we fear really in Zimbabwe is the threat to the amendment of the presidential term limit of 10 years. This could be abolished, and we are safe to have another leader who will be there for more than 30 years again. And we can't afford that. What we experienced through Robert Mugabe, we cannot go through that again. Another fear again that we have here is the people's power. Is the people's power is under threat. People's power. People are no longer important in the process of governance. The powers that were put in the Constitution to make sure that the powers would hold the government accountable is now being threatened. And we say, no, that's not right. So really, as I said before, that constitutions are not made for the angels, but for Lucifer. Lucifer is why we make constitutions. And the process of amending the Constitution threatens the critical balance of power that had been established by this Constitution. The critical balance of power in these instances, I'm trying to say that the president would always act carefully, and you would always open the Constitution before he says or he does anything, because the tools to check his moves were put in place, and we cannot afford to have a system that is no checks and balance. What do we need? We need to make sure that at this moment we don't destroy what we built, the good thing that we built. Let's maintain our constitution as we agreed in 2013. Let us actually, before now, putting life, give life to the constitution itself, because there are so many sections in the constitution which were threatening, which threaten democracy, which we need to improve. We need to make sure that we improve the independence of ZEC. ZEC, yes, of course, on paper, it said it's independent, but technically and practically, it's not independent at all. And we need to make sure that we need to improve the independence of the independent institution, these institutions, so that they operate effectively. All these institutions that we have in Zimbabwe, such as ZEC, Zimbabwe, and NPRC and so forth, they don't have any legal powers to punish an offender. In South Africa, if you go against the rules and regulations of the IEC, that is the Independent Electoral Commission of South Africa, the Independent Commission of South Africa can actually disqualify a candidate, sort of prefer some punishments of some sort to an offender in South Africa. That is what we want to be doing now. In Zimbabwe, ZEC does not do anything. They're just watchers. You know, you can do whatever you want. You can go and talk nonsense or rubbish before their office. They cannot do anything at all. They will do probably. Anyway, I remember when I got arrested, there was actually a witness against me, but but behind them there was a force that was more powerful than them. But we want them to be more powerful, want them to be in forefront, want them to be in the forefront, want ZEC to have the powers. So these are the things that we must do now to improve the constitution that we build, to make sure that we work on the alignment of the constitution. The relevant acts must be aligned to the constitution now. We've been waiting for section 210, which is the independent compliance mechanism of the security service members. We've been waiting for section 208 for the conduct of the members of the civil service to be dealt with, so that at least we align these issues with our constitution, with our acts, so that at least a more democratic atmosphere, a more democratic country can be established, so that people can interact and be able to express their views and make sure that their rights are protected. We need these things to be done. We also, and instead of focusing on the amendments, we must focus on the alignment of the constitution. But however, the amendment number 2 had its own challenges. It was an omnibus, which really divided the members of parliament. In this situation, I'm speaking as an analyst here. Now I'm being critical to what I observed, the challenges that I saw in the House of Senate and Assembly. The Act had 2 sections. The first section was the one dealing with power issues, which was the running mate issue and the appointment of the judges issue, which is really the one which is which has got a bone of contention, the one which you are worried about. But remember, when it came through to Senate, we voted it under committee stages, and we voted against it. You know, we were 19 votes from MDC, and 45 votes for ZANU-PF. We voted against it. But however, we were beaten because in this contest we used the simple majority. But we expressed our dislike on those particular issues. However, the second one is the one with the direct benefits. The second one, direct benefits for the MPs, especially the women and the youth. Before the amendment was actually brought to the House, the women had a general consensus through their meetings that they would want the term be extended, and this one was a big challenge, because we were asking women to vote against their own life and their own future. you were asking women to vote against their livelihoods, as well as the youth as well, because the youth were now included in the PRS system. And you would say this was very difficult in terms of really driving the whole issue against the Constitution. The other element which is also there is the 50-50 representation, which is mentioned in the Constitution. It's correct, yes, but it's not yet applicable at the moment. The political parties can be forced to come out with 50-50% of our MPs or our councillors, but this does not reflect who is going to win and who is going to come to parliament. We might have 50-50%, but the same challenges which we know which affect our women in terms of violence, in terms of shortage of resources, all sorts of things would affect them when they go for the elections. So at the end of the day, you will have again a parliament which is composed of more men than women. So the way forward towards this 50% representation is to change the entire electoral system and adopt the South Africa electoral system, which is the zebra system. If
Senator, if you can round up your presentation, possibly, we are a bit short of time, so you can just round it up. Thank you.
I'm just about to close. As we move towards an entire amendment of the electoral system of Zimbabwe and adopt the zebra system of South Africa, therefore we can use 50%. For the time being, we cannot do away with the 60 PRS system. We cannot do away with that. If we do away with that now, I can just assure you there will be less than 5 women in parliament in the next parliament to come. So we must be sensitive. We must be considerate of our gender system in Zimbabwe. And for the time being, let's continue with the 60 PRS system for the women. For now, let's do that until we change the electoral system. Yes, of course, the running mate element was very key to deal with the issues of succession. We have seen this succession issue taking place in Tanzania 2 weeks ago. We have seen this section also taking Malawi, and this has been a very good thing as a running mate. So the running mate, now it has gone, we have a challenge. And with those few comments, ladies and gentlemen, thank you so much for listening to me. I hope I have done justice to the debate. Thank you so much.
Thank you so much, Senator Komichi. I think you really touched on a number of issues, which I will highlight just in summary, that I think some of us are actually experiencing or hearing of them for the first time, where you speak about the unifying process of the constitution making process for the constitution we have that was made in 2013. You speak about the euphoria of unity that was there at that time across the political divide, where we cannot undermine that unity that happened when people came together across the political divide to formulate a homegrown constitution. And you say, no, in this process of amendments, we should have gone through the same process where we brought all actors onto the same platform. And there was that unity amongst people in discussing the amendments of the Constitution. Then you also speak of the arms of the state, that they must always derive their power from the people. This is the executive, the judiciary, and the legislature, rightfully. You also speak that amendment number 2 reversed the gains of the Constitution of 2013. How? You speak of how they eliminated the running mate clause, which was supposed to be given a chance, of course, to operate. And also you speak of the removal of the checks and balances in amendment number 2. But also you speak of how each arm of the state must execute its duties with care. This is the same for the executive, for the judiciary, and for the legislature. And also you emphasize on the importance of safeguarding and protecting the doctrine of separation of powers. You also speak that we need to call for a democratic president, but above all things, I think you overemphasized on the call for dialogue as a solution to the challenges we are facing, as a solution to the constitutional crisis that we are facing. And you seem to also impinge upon the solution that Dr. Magaisa spoke of at the beginning of this symposium, where he spoke about citizens getting a grip of the constitutional situation in addressing what we are facing right now. So thank you so much, Senator. I think I leave this time to our third panelist, who is Mr. Richard Mahomva, to just give us his perspective as an academic on this topic at hand. But also at the same time, I think we should prepare to make our comments, to raise our questions with our panelists. So over to you, Richard. Thank you.
Thank you. I assume that is Tari.
Yes, it is, Richard. You can go ahead. Thank you.
Thank you so much. Yeah, I would start off by, of course, thanking the ZCC for creating this platform, because to me, it speaks to the essence of the church as a pivot of moral consciousness and also as a pivot of political consciousness, in the sense that the first law that governs humanity from a religious perspective is the Bible. And from a more political perspective, we see the Constitution playing that role. And to that extent, I would like to applaud the ZCC. But just to give a few definition parameters of my argument, I want to argue by referring to the presentation made by Professor Magaisa, who speaks of constitutions as products of the collective creation of a people's aspirations or their shared destiny, and how constitutions govern how governors should govern. So that provides a normative path of what constitutions are. But I also see constitutions as contested expressions of interests of those in power or those who struggle for power. And the current situation in Zimbabwe actually depicts the third layer of my definition of what constitutions are, which I refer to as the contested expression of interests of those in power or those who struggle for power. But normatively, again, you'd also notice that constitutions provide levers for the social contract, which means that the state has got to fulfill certain responsibilities to the citizen, in as much as the citizens have certain responsibilities to fulfill to the state, and that is constitutionally encompassed. And now, what I think the key issue is that from the Lancaster Constitution right up to COPAC, we have seen constitutions framing nationhood. And again, you'd also notice that even the Lancaster, he had certain aspects of constitutional illegalities that promoted the issue of land imbalances. And the 2000 constitutional referendum ushered in the realignment of property rights in Zimbabwe. And another very significant hallmark of constitutional architecture in Zimbabwe was that of 2013, where ZANU-PF and the subsections of the MDC came together to formulate the current constitution. And it is on this basis that today we are debating emerging loopholes around the legality of that very same constitution. And the obvious instinct that emerges is that the silence that we observed on the part of the opposition to challenge some of these issues which are emerging today is actually evident of the fact that the opposition was operating on a power retention instinct as far as the constitution creation process was concerned. And you'd recall around that time when COPAC was doing its consultation processes, I was still a student at MSU, and students yet that opportunity to engage, students yet the opportunity to give their views. But today you have a situation whereby certain sectors of our polity are coming back to condemn this amendment, and yet they were key players in the formation of what is actually there in the constitution, what is actually even being contested. And to even come closer to where we are, sometime last year, Enamatai Kwekweza actually led what I refer to as a hashtag-less fight against the constitutional amendment. You'd notice that with the normal trend around the politics of hashtags in our country, when a certain section of activists are arrested, there's prominent narratives in backing them, there's prominent social media hype in backing them. But we saw something different with the case of Namatai. So for me, that on its own actually proves that there are these deliberate silences within our body politic which sustain certain retention of power interests across the political divide. But at the end of the day, having given you a background of the Lancaster right up to the Copper Constitution and the present constitutional amendment debate, what we see is a continuity of a constitutional architecture struggle that Zimbabwe has been going through as a post-colonial state. And now coming back into the realities, the constitutional realism that we are encompassed with. And some, of course, have referred that to as a constitutional crisis. I think we need to admit that the current amendment is a consequence of ZANU-PF's majority stake in parliament. And the truth of the matter from a more realistic point of view is that ZANU-PF is not at fault for having the majority and having the democratic monopoly to decide the direction of constitutional reform as far as its interests are concerned as a party. This is what political parties in any given context would do. So other people may also argue that why did we not have the referendum? But we also need to appreciate that if Parliament takes a particular decision, its decisions are pivoted by the voter backup that constitutes a Parliament. And in that regard, certain sectors of our polity would justify the view that the bill was passed through the Parliament on the basis of its role as a lawmaking entity in the country. And that is actually backed by Section 119 of the Constitution, which states that the Parliament must promote democratic governance and ensure that the provisions of the Constitution are upheld and that all institutions of the government are guided by tenets of this majority thrust of the law. So that is another dimension that I feel has been missing in this debate. And then there's also been an argument about this amendment having to be an omnibus type of amendment. But to me, that depicts that we have a more reactionary side as far as the opposition is concerned, in the sense that what they are referring to as an omnibus amendment could actually depict the statecraft tactfulness on the part of ZANU-PF. And so revolves around the pertinent issue of ZANU-PF changing what is alien to its survival instinct. Look, from the outset, in 1963, when ZANU-PF was established, the whole notion of running mates and all of that is not existent within the ZANU-PF culture. To remove certain aspects which are not in sync with its survival instinct as well. So those are some of the reality. And for me, I then argue that perhaps this should be an opportunity for opposition to work hard to attain the majority status which ZANU-PF has currently. And if it does not
You are breaking up, Richard. I think we can barely hear you. We have lost you for like a minute or so. I think we have lost Richard. I think it's his connectivity. That's a challenge. I'm not too sure. Maybe we can wait for him to reconnect. But I think as we wait for him to reconnect, I think he has raised an issue where he said in the constitution making process, there was an error. And we must admit that the crisis we are facing today is a consequence of the 2/3 majority stake that was put in the constitution during the constitution making process. This is quite interesting, something that he has raised. So thank you, Richard, for that. I think now we should prepare our questions, our comments to our panelists. Of course, those who may not have proper connectivity, you can just send your questions into the chat box and we'll address them. But now we prepare to open to plenary, where we'll ask our panelists, Linda, Richard, and Senator Kumichi, of course, in terms of interacting with their presentations and their submissions. So let's prepare ourselves for the plenary session. But in the meantime, I'll just read in the comment section the comments that you have written. Thank you. So I am seeing that there've been quite a number of comments. The first one being, it's a question: how constitutional issues affect our church today life and as church? How can we address the constitutionalism issue as the church? That's Pastor Mlauzi. Then there's a comment that says smuggling of personal and party agendas. The problem we have here is that of viewing the national constitution as a party constitution, which we can alter and violate at any given time as we please. I think the church now needs to continually be the voice and play a critical role in opening the eyes of the public. Then another comment from Norman Tembo, he says, appointment of non-constituency MPs. I'm not too sure what he meant by that, but maybe his comment is incomplete. Then Takunda Aishe says, okay, this is Takunda just saying we should feel free to also put down our questions in any preferred language. It's okay to do that. Then Hati Yenzani says that as much as we respect the country's interests, should we ignore the constitutional provisions? This is a question to Linda Masarira. So Linda, you may need to take note of that question. Then James Nyao says, my question is to the constitutional law gurus. He says, is it possible to have amendments in multiple choice format? This is in an amendment bill. The proposed amendments are listed in multiple choice format for MPs to pick and vote for what they want and against what they do not want. This is a question, I think, to our panelists. I'm sure they are noting that down. Then this is a comment: as Zimbabweans, we should respect the constitution to avoid violation of human rights. This is in applause to Linda, I think Linda's presentation. Then someone says that, please, let's not waste time. Let's confront the devil in the country. These amendments are being pushed by Emerson Mnangagwa is a dictator in the making and has to be stopped at all costs beyond the application of the law. ED is dangerous for future generations. Then Reverend Norman Tembo says amendment number 2 is creating another powerful and imperial president. Then Tinotenda Kasoshe says the amendment number 2, it looks like a shield for the ruling party to do whatever they want, where at end it benefits those in power at the expense of those not in power. Then Linda says, I agree with you 100% on adopting the South Africa PRS system. I think this is in relation to the presentation by Senator Komichi, less than 5 women, because you men in politics are misogynistic in nature. Then, of course, Dr. Magaisa comments to say, Richard, since Senator Komichi is here and Professor Mtambara, they can tell you that the running mate provision actually came from ZANU-PF. There is a myth that's being promoted suggesting that the running mate clause was not an origination of ZANU-PF. It is simply not true. It was probably factional within ZANU-PF, but to say it was not from ZANU-PF is completely ahistorical. Then we have Pastor Daka. If our neighbor countries have working systems, why not adopt them and make necessary adjustments to our own? The problem we have is that we make our own systems but fail to implement them. Who is to blame? Then the last comment is from Simba Hunji. He says, I think from most contributions, we can say that most of the problems we have are systematic. Is it not wise to change the system and not focus on individuals or entities? I think this is a question to our panelists. I hope they are taking note so that they can address those. But without really wasting much time, I think I'll move to the plenary session. I can see there are 3 hands being raised. Well, I will start with a woman in respect of gender, of course. I can see Esfela Ningoma. She has raised her hand. You can unmute your mic, make your comment and ask your question. You can go ahead.
Thank you so much, Tariro. Thank you to everyone who was sharing. I wanted to, I rise not to share a question, but to share a comment from the floor. And I rise to set the record straight. I think it is important to bear in mind that amendment number 2 had 27 amendments, which were trinkets and tokens for different constituencies in the country. And as a member of the women's rights movement, which continues to be independent and autonomous despite much critique, it is important for me to set the record straight that at no convening of women's rights organizations did we ever support the call of the extension of the current quota that is in parliament for women, nor did we support the current extension of the additional seats in local government. What we have consistently called for is that we should have, for example, the proportional representation system in South Africa, which is zebra listed, or we could retain our first past the system, but we could adopt a system of seat rotation. This, however, these 2 options that we have tabled as a way of ensuring that gender is mainstreamed within the electoral system of the country have been roundly rejected by political parties at various corners. Secondly, that rejection is also coming in the form of being told, not now, but tomorrow. We are now 42 years old. When is tomorrow going to come? The second point I want to raise is that in the constitution that we have currently, political parties have retained and ring-fenced the right to recall. In other words, if you look at a member of parliament today, they can only be recalled by the party that deploys them. And what this does is that it entrenches the vested interests of political parties to exercise that fear, to be able to remind the power of the whipping system has been ring-fenced in that way. And that is the sting in the tail. And so when you begin to see women, prominent women within political parties defending the current proposals, it is because they too now have either A, a vested interest to stay in those seats, or B, they too are responding to the political demands of the day. It is therefore incumbent on us to say, is amendment number 2, because a lot of political parties continue to say amendment number 2 was okay in terms of gender, but it was not okay in terms of other issues. And women's rights organizations in this country are continuously saying, no, that is not the picture. And so I rise to set that record straight. Thank you so much.
Thank you so much. I think you are setting the tone to the discussion we have this afternoon, where we have a representation from the women's movement giving or adding voice to the conversation with regards to the extension of the quota system for women. And as you have mentioned, you are making it quite clear to say most of the women's organizations have rejected extension of this quota system. They've rejected it and said that their recommendations that they've tabled with regards to the zebra representation, I think, of women within the political parties, and clearly it seems as though there's no will within the political parties to substantively address the issue of gender representation in terms of equality within the political space. So thank you for that, Sandy. I think this is quite an insightful and quite important contribution to the conversation. Thank you for that. So now I'll move on to, I can see Bishop Kenneth Swanda. You can unmute your mic, make your contribution, ask your question, go ahead. Bishop Kenneth Swanda, you can unmute your mic, make your contribution or ask your question, go ahead. Okay, so I'm not too sure if you can hear me, so I'll move on to the other raised hand. I can see it's Tapumane Diriza. You can unmute your mic, Fundisi. You can ask your question or make your comment. Thank you.
Thank you so much.
There's a problem with your mic. I don't know what is happening. It's a bit far away. You are not as audible. I think you may need to fix that, Mfundisi. Oh, we are losing you, Reverend Diriza. I think what you can do is maybe send your comment or question into the chat box because we can barely hear you. Thank you. So I think I will move on to, I can see Emangena, whose hand is raised. You can unmute yourself, make your comment and ask your question. Go ahead. Mangena, the device that is named Mangena. Okay, I think they are not there. So I will move forward to Ticharwa Nyamidzi. You can unmute your mic, ask your question, make your contribution. Thank you.
Okay, thank you for the time. My comment is on increasing of quota system of women. Are we not also increasing the number of bootlickers in parliament? Because actually the one who pays the piper constitution. So those who have chosen those women to be in parliament are the ones who are going to control them. So they will not in any way say anything. I think we have to look at the way the South Africans are doing their representation is the best way to go, not to improve the quota system. We have witnessed this day in Norton, whereby the women who are councillors or those who will be chosen to represent certain political parties in elections, they always bootlick the chairperson or those who are in leadership for a certain party. Thank you.
Thank you for your comment. I think you are speaking with regards to the extension of the quota system to say that you are not for it. Thank you for your contribution. I will give Bishop Kenneth Swanda one more chance to ask his question or to make his comment. Bishop, go ahead.
Thank you very much. Somebody just called to interrupt my raising of my hand, but I wanted to make a comment regarding the discussions, mainly on the two-third majority. Like the other speaker was saying, that is a right of the party that is commanding such a majority in parliament. But I was going to say maybe we needed to concentrate on the elections that have been disputed for a number of years now, to say, are they really free and fair? Because if they are free and fair, then maybe those that have won, and in a free and fair have the right to make the amendments which suits them as people that are in power. But are we really having free and fair elections in Zimbabwe? Was that is a big question. I thought that if that is not addressed, we'll continue to have these challenges. Thank you very much.
Thank you, Bishop. And I think I will revert back now to our panelists to give us their quick reactions, their quick responses, I think, to the comments, to the questions. I'll start with Richard. Richard, what are your quick reactions in response to some of the comments and the questions from our participants? Richard, over to you. Is Richard in the meeting? Okay, if he has left, it's still fine. I think okay, you can go ahead, Richard. Thank you.
Thank you so much for that. I was saying is that this particular conversation and even the process of the constitutional amendment contested as it were, it invites us to introspect the morality of our national consciousness regardless of cultural binary. All Zimbabweans must be assigned to an emotive task which questions the type of Zimbabwe that we want. So I think we should have this conversation, but beyond this conversation, have policy, initiatives that redirect us to the path of genuine reform, which reaches out to the person in Kai, the person in Vuri, and everyone who identifies with Zimbabwe and being Zimbabwean.
Thank you so much, Richard, for your response. I will say, Linda, maybe you can go ahead and attempt to give comments and respond to some of the questions raised and comments raised. I think particularly with the quota system extension for women in parliament. Over to you, Linda.
Thank you, Tari. I think people didn't understand my presentation on the Chief Justice. I spoke on two sides of the coin. What a sitting government would do in their best interests. And I also tried to hint on my perspective, which maybe I didn't thoroughly interrogate. But the position that we have as labor economists and African Democrats is that the appointment of the Chief Justice and judges by the president alone compromises democracy in Zimbabwe. That we can never run away from. It is therefore vital to have a Judicial Service Commission not being involved in the process directly but indirectly. The JSC should facilitate receipt of applications from interested parties to take up the posts. Then a separate commission set up from members from political parties represented in parliament interviews the judges and interrogates them. Or the Judiciary Service Commission can conduct interviews, then forward the results to an independent commission where the final selection will be done through further interviews. Maybe the contentious issue with my first or initial presentation was I gave reference to how Chief Justices are also elected in other countries, where I was trying to also play the devil's advocate that whatever has been alluded to by the Constitutional Amendment number 2 is not only unique to Zimbabwe. So my perspective would be judges and ZEC officials serving at the president's mercy do not promote democracy, as there is high probability that they will favor the appointee. However, judges are guided by the Constitution and statutes which make it not easy to interfere with them. So this is a very contentious issue here, my justices, and I think that even as much as we might want to go on interrogating it, it is a matter that is in the courts. We all have to leave the courts to decide what will be the final fate of our Chief Justice Malaba. There is also need for the preservation of sovereignty, and the issue is supposed to be dealt with in an inclusive manner that will benefit the interests of Zimbabweans, regardless of their political affiliation. The issue of judges should never be put in the hands of a single person because they will always run their own agenda with it. And then I want to answer to, I think it's Simba Hunji, who spoke about issues in Zimbabwe being systematic. They are very systematic. The tragedy that we have in Zimbabwe is we just adopted the colonial systems from the colonial masters. There was no effort made whatsoever to ensure that we totally eradicate the oppressive, repressive, and suppressive systems that were in place before independence in Zimbabwe. That is why we still have laws and bylaws which continue to oppress people in Zimbabwe. Because even our legal gurus never made an effort to say some of these laws that they keep on running to the courts with when activists are arrested are actually abolished because they are no longer in sync with what people termed that they attained independence, because they are still suffering the same way that people suffered when it comes to some legal issues way before independence. So it is important for our Dr. Magaisas and company to ensure that they get to a stage where they sit down as legal people and say, how do we reform the system in Zimbabwe? How do we reform some of these suppressive and oppressive laws and totally abolish them from existence? It is important for us as Zimbabweans to start walking into that trajectory. And lastly, we do need a system overhaul in this country, but it will need all stakeholders to be on the table and have a sincere dialogue that will benefit the people of Zimbabwe in terms of us fusing our own former traditional systems that we have with the white system that is used all over the world. That has been the tragedy of Africa. We have never been innovative ourselves to say, how do we start doing things that benefit us as African people and our continent or our different countries? Lastly, I'll respond to the issue of the extension of the PRR seats in short, where I will say I am very much in support of the PRR system that is used in South Africa. We need to amend our electoral act to ensure that it becomes comprehensive in allowing every demographic population in our country to be able to participate, whether in council or parliamentary elections. When we look at our MPs, most of them are geriatrics. We look at our councillors, it's the same thing. Because in our very own political parties, kunoshanda patronage, they are using the loyalty, your rank and file in that particular party. And it always leaves out the younger generation who are always given maybe the opportunity to run for elections on tokenism. So it is important for us to be able to try and have a conversation with all political actors and other stakeholders involved on how possible it is for us to use a zebra listing. We are already using it in the Senate. I don't see the problem why we cannot use it in Parliament. Why we need the PRR system? It will help us have diversity in Parliament. It will help us depolarize our political economy, and it will help us achieve the 50-50 gender equality that we've been crying for as women since time immemorial. Some people who do not want this PRR system to be in existence are those people who are gatekeeping their political seats or their political position so that they remain in Parliament. The way they've done it in South Africa, every political party will ensure that every age group is represented when they are drawing up their party list. They will make sure that all special interest groups are also included. And when we have a man-woman scenario, we will definitely achieve 50-50 gender representation. And we will ensure that we've got a diversity and the cremora of the cream in our parliaments. And we will never get to a situation where we have one party with 2/3 majority, because every party that will run for an election will have their representatives in parliament according to how many seats that have been allocated from the percentage that they get from the total vote. I think that will be my submission. I don't think there's any question that I did not answer that was directed to me.
Thank you so much, Linda, for your responses and quick reactions, I think, to some of the questions and comments raised. So I'll hand over now to Senator Komichi. I think he can just give us his quick reactions and responses to some of the questions and comments raised. Over to you, Senator.
I think I'm done now.
I'm not too sure if he's still in the meeting. Senator Komichi, over to you. Any quick reactions, comments to the questions raised by our participants? Over to you.
Thank you so much, Tyrell. Can you hear me now?
Yes,
Can you hear
loud
me?
and clear.
Thank you so much. I'd like to start by commenting on the issue of the running mate. The running mate issue was very popular with MDC. We actually wanted it implemented in 2013 elections. And we were very much strong behind it, because to us, it was going to be, we did not want anything that would disturb the term of the government if anything had really happened to the sitting president, because we did not want to have another election before the end of the term. So we really preferred a system that will have a smooth transfer of power, a very peaceful succession plan. So we supported the running mate very much, and we wanted it. And unfortunately, the then president Mugabe didn't want it. That's why he didn't implement it. And even during his term, he forced that it would be implemented after 10 years. So according to the constitution, it was supposed to be implemented in 2023, but MDC we've always preferred it earlier than that. But unfortunately, the other ZANU-PF leadership is there now, quickly ran with it to the parliament to change it. So now it's changed. To us, we really thought it was a very good idea. Then the other comment that I wanted to pass on is on the issue here, zebra system, the South African-based one, is the only way to go. I think Zimbabweans should start now working on it, push for it. That's the one amendment which we must all support, because definitely it will resolve some of the issues that we've been having in the country, the gender issues, men, women, and the youth. The zebra system will resolve that once and for all. And it will actually bring peace to our country, and it will actually even improve democracy in our own country. And I believe most of the political parties are in support. I don't know which parties are against it, but our women from all political parties are in support of this zebra system. The women that we have were playing a key role in the decision-making process in the amendments number 2. This is where I'm sure one of the listeners did not get me right. The authority to make amendment fail or succeed lied in the parliament. And in the parliament, that's where we had women from ZANU-PF, women from MDC, youth from ZANU-PF, youth from MDC. So these are the women caucus that I was referring to. The Parliamentary Women Caucus supported the extension very much, and they're also very much behind the zebra system in South Africa Women Caucus. The MDC Party Caucus women supported the extension. The Youth Caucus as well supported the extension. That is the same with what happened with ZANU-PF as well. So these are the people that were part of the women who were supposed to resolve number 2 challenges. So we had people who were actually seated on the table, on the desks, who had something to benefit out of a process, something to benefit. All our women in parliament, all of them, whether ZANU-PF or MDC, they really supported the extension. But at the end of the day, they also support the zebra system. Don't get me wrong there. They all support the zebra system. They would actually prefer a zebra system than this extension. But however, at the moment, we are still very far away from achieving the PRA system. So they would say better get the extension than leaving nothing. So really, I agree with you. The women organizations did not support this, and they still recommend that we have a PRA system, and we all support them as well. Then,
you round up, Senator.
There's other comment about the elections. Definitely, Zimbabwe. If you look at the election challenge in Zimbabwe, it has been there since 2000. We have never had an election in Zimbabwe which was not disputed, one or the other. Each election has got its own faults. So Zimbabweans need to relook at this particular situation and say, what do we benefit out of the election process that is always challenged? So I go back again to the idea where we need the Zimbabweans to sit down and dialogue around elections, because there are issues that are raised by political parties and many other organizations why these elections are regarded as not free and fair. So we need to sit down around the table, negotiate around those issues, make sure that we come with electoral reforms that we need, make sure that we have an independent SEC, make sure that we don't have partisan food distribution, so that we don't have traditional leaders that get involved in the election process. These are some of the things that we need to sit down and negotiate. So this is another agenda again, which Zimbabweans must take very seriously. Otherwise, if we go to an election again 2023 and it gets disputed again, an election becomes an election when it gets the legitimacy of the international world, whether China, Russia, whatever. We must have the legitimacy of a process, so that at the end of the day, after election, we must have an investment coming in this country. We must have partners, we must have friends, so that at the end of the day, people will benefit out of a process. If we then undertake a process that's not to have legitimacy, it will be sheer waste of time. So we need to look at this matter very seriously. So I really want to support Bishop Swanda. He's very correct on that matter. Thank you so much.
Thank you, Senator. I think I'll just touch on some of the comments in the chat box. I'll start by speaking to the one from Zaka. Mine might be misplaced, but I would like to find out what hinders the allowance of the diaspora community voting at consulates and embassies in the nation that they are in. Then we have a comment from Beginko Sisvanda, who says, from Richard's presentation, I'm convinced that we are trying to climb a very tall mountain, because the 2/3 majority and the fact that these MPs are a representation of us out there. So unless and until the elected members of parliament and senators represent the constituencies that put them there and the people that elected them, will always be in such mercy where the laws are amended to suit those at the top. Then I can see there's a comment from Dr. Pilanza Mchia, where he says that Zimbabwe must be wary of state feminism in non-democratic regimes, where the government tends to enact what appears like women-friendly policies, but for the purposes other than those of achieving gender equality. Then I think this is a question to Senator Komichi, which I hope you'll address in his closing remarks, where he says that our opposition leaders working together to stop ZANU-PF from getting another 2/3 majority, which will lead to the change of the constitution for a 3rd term for President Mnangagwa. Then number 3, he says the degree of elite cohesion within ZANU-PF on legislative changes stems from the uncertainty of the post-military coup period. The coup must be cured. Citizens must take charge. Then, of course, someone says, I agree with you, Linda, that the power of the judicial system should not dwell on one individual. The JSC becomes a necessity. Madam Masarira, you are very impressive. Thank you, Senator Komichi, for a very mature and sober analysis. Network is jamming in and out, but I'm learning a lot from the symposium. As usual, time always runs short, as most presenters are either cut short or they say because of time. How can we improve this on this effect? Why is it that these constitution amendments are done without considering the majority? I mean, Voice of Zimbabwe, all people, not MPs and senators alone, because these leaders are doing it for their own benefit and not that of the majority. People are not consulted. Why are these amendments? Why about these amendments? Why? Then someone speaks about on women's quota, it should be on merit. I think these women should be identified through their contribution to the community, not political persuasion, truly, so that they do not represent women, but the interests of the appointing authority. Thank you, leader. So you think ministers will not bootlick, like you said, women chosen were based on bootlicking basis? Kindly clarify there. So I think this is a question to Linda. Then someone says, my question was to all the panelists, are we in a constitutional crisis as a country? This is Mfundisi Diriza, he is asking. Then someone says, thank you, Sakile. Thank you, Sakile, for the clarity on what women want. I think that most contributions, we can say that most of the problems we have are systematic. Is it not wise to change the system and not focus on individuals or entities? So I think now I'll ask our panelists to just give closing remarks where they are tying in their presentations by giving recommendations going forward to say, so where to from here now that we are here? So I'll ask Richard in 2 minutes or less, may you just tie in your presentation and conclude. Richard, over to you. Okay, so I think he has left the meeting, so I'll hand over to Linda to tie in her presentation and give her concluding remarks. Linda, over to you.
Okay, thank you very much, Tari. I think in closing, we have to encourage each other as Zimbabweans, not just political players, that we have to ensure that we move an agenda that benefits every Zimbabwean, regardless of political affiliation, class, society, religious background, tribe, etc., etc. The biggest problem that we have had in our country is we major on minors. We only want to talk of issues when they are pushing a certain narrative. We have to remember that we only have one Zimbabwe, and no Zimbabwean is due for export. Whatever decisions that we make as a collective, as Zimbabweans, will affect our livelihoods. It is important for us to start plugging into a transformative agenda that will benefit every Zimbabwean. As long as we are still apportioning blame or looking for someone to blame, we are not going to be able to deal with the constitutional crisis at hand. When we look at the political parties in Zimbabwe, most of them do not even respect their own political party constitutions, but we still have large followings thinking that these leaders that they vote into office will respect the national constitution. If a particular leader cannot abide to their own party constitution, how do you even trust them with a vote and think that they will transform your livelihood, they'll transform their economy and respect the constitution of this country? Sometimes we are swallowed by the fake promises that come, and we forget the critical and important issues that we always talk about, which is, how do we deal with the constitutional crisis? How do we get out of this situation that we're in? People have to understand that you just do not vote for a popular political party. Vote for the voice of reason. Vote for an MP or a councillor or a president who resonates with your aspirations at a personal level. Stop voting for people because Vane Chaunga, because from 1980 people have been voting for Chaunga and nothing has been transforming in their own livelihoods. We need to get to a stage where we vote for sustainable human development, sustainable economic growth. Vote for leaders who interact with you, who you know, who you have met, who you understand their agenda. Not just voting for Huku because you end up as a political party. That is the tragedy of Zimbabwe. And as long as the electorate do not know why they vote, we will keep on having these conversations until we die, and our children will carry on these conversations because we're not giving sufficient political education on the importance of voting for leaders who will respect the Constitution as supreme law of this land. Thank you.
Thank you, Linda, for those comprehensive closing remarks. We really appreciate them. So I would ask Senator Komich to just round up and conclude. Over to you, Senator.
Thank you so much, Chariro. I would like to start by commenting on the need for the opposition political parties in Zimbabwe to unite. The opposition political parties in Zimbabwe, they have no choice but to unite. If they want ZANU-PF to win elections in 2023 without any challenge, therefore they should choose not to unite. And the unity of the opposition political parties, it must not be selective at all. You must make sure that you unite with everyone who is in Zimbabwe, who is in opposition political party. We need unity. We got to more than 2.1 million votes in 2018 because of the MDC alliance, which was the unity of 7 political parties. And from those lessons, we should not really have any headaches. We must come together and unite, ensure that we go for the election united at all. I think what we need to do now at the moment as the way forward is to build on the national consensus as Zimbabweans, all people, ZANU-PF, government, every political party that you know, the churches, business community, students, women. Let us build on the national consensus. Let us build the national consensus on our politics. Let's design the political framework which is Zimbabwean best, the one we want. Let us design the economic framework that we want to improve our economy. Let us make sure that we deal with issues that divide us, issues that have caused polarization in Zimbabwe. Let's deal with them. Let's make sure that we work out on a framework of national healing and national reconciliation. We must, as Zimbabweans, again come together and put our heads and make sure that we bring back Zimbabwe to the international fora. Zimbabwe is isolated. Zimbabwe is under sanctions, and as a result, our economy is deteriorating every day. At the end of the day, our people in Zimbabwe are suffering with no employment. Our women are suffering. Our youth are suffering. Our hospitals are suffering. Our roads are dilapidated, and this is unacceptable. This is not an acceptable type of decision that we must go through. As Zimbabweans, let us unite. Let us have a national consensus. Let us go for the national dialogue and make sure that we come out with a national blueprint, a blueprint that we all agree and we sign as Zimbabweans for the benefit of Zimbabweans. Stop hating each other, stop fighting among ourselves, stop the violence, stop the human rights abuses, stop everything that is negative to our country, stop everything that will put our country on the international arena in bad taste. So as Zimbabweans, I urge all of you guys, let us work towards a national unity that will bring up a nation building that will bring us a great economy in Zimbabwe. Thank you so much.
Thank you so much, Senator, for your contributions and for making the time. I would like to take this opportunity, I think, to thank our panelists, Linda Masarira, Richard Mahomva, and Senator Komich. I think they've taken us through the session for us to understand the politics surrounding the constitutional amendments and, of course, the implications of this, I think, for them as political players in the field, but also we got an academic view of what the deficiency is with our constitution and how that deficiency is affecting the state of constitutionalism in Zimbabwe. So I would like to really thank you from the bottom of my heart on behalf of the Zimbabwe Council of Churches family for taking the time to be with us. So I think we'll end this meeting here. And then those who would want to reconvene for our last session, which is the third session, that speaks of the economic, of course, and the civilian voices around the amendment. You can join us at exactly 2 o'clock. But for now, I call this meeting as ended. So thank you so much, guys. We reconvene again at 2 p.m. Thank you.
Thank you so much. Thank you so much. Bye-bye.
Good afternoon, colleagues. I think we are about to start because I can see that most of our panelists are already in. So good afternoon to you. We are now in the last session of this constitutional symposium where we are going to find out from our panelists the economic implications and also just to hear the civilian voice around the amendments that happened to the Constitution. So without really wasting much time, I would like to introduce our panelists for the afternoon. We have Professor Atham Tambara, who will take us through the economic implications and, of course, as someone who was there during the constitution making process, to tell us what happened then and then where we are now in terms of our state of constitutionalism. Have we regressed or have we progressed? Then our next speaker, we have Kispen Gundani, who of course is an economic player who will give us his voice according to that perspective. We also have Namatai Kwekweza, who has been a bit loud, I think, around the constitutional amendments, but also is a law student. We need to hear from the youth perspective and also from the civilian voice in terms of how they perceive these amendments and how they perceive they will be affected by the amendments. We also have Stabile Dewa, who's from Walpe, who I'm hoping she'll be able to bring the women's movement perspective with regards to the proposed amendments and where to from here now that the quota system has been prolonged to beyond 2023. Last but not least, our panelist is Blessed Mhlanga, who is a journalist. But of course, I think it's important for us to have contributions from the fourth arm of the state to how they have been following the stories that are being written, how they have been capturing the developments that have been happening, but also to hear, as a monitoring arm of the state, to hear their perspectives in terms of the constitutional developments, if we are progressing or if we are regressing. So good afternoon to you all. So without wasting much time, I will allow Professor Arthur Mtambara to open this session for us by giving us his presentation on what I've already mentioned. So over to you, Prof. I'm glad you've been with us since in the morning. We've been seeing you, and I think you've been hearing the submissions from the legalities, the politics, and here we are. We need to hear the civilian voice and, of course, the economic voice with regards to the constitutional amendments that happened recently. So over to you, Prof. Thank you. You can unmute yourself.
Okay, thank you so very much. I want to start by thanking the Zimbabwe Council of Churches for this opportunity to share with all of you. Now, we are discussing amendment number 2 of 2021. But what is going on in the country? What is going on in the world? We are operating under COVID-19. There is a pandemic in the world. There's a pandemic in Zimbabwe. We have had losses of life and losses of livelihoods. So we are going through economic decline globally and also in Zimbabwe in particular. So amendment number 2 takes us away from the core business of addressing COVID-19. The amendment number 2 takes away our attention, our efforts, our resources from saving lives in the country. It takes us away from saving jobs, saving livelihoods in Zimbabwe. That is the implication, that is the consequence of amendment number 2. It is a sign of lack of leadership on the part of our government, on the part of our country, to be concentrating on amendments to our constitution which are misplaced, which are misconceived, which are meant to serve power retention strategies, instead of concentrating on COVID-19. So that's the number 1 implication of all this. These political shenanigans, this constitutional crisis is a terrible indictment of us as a people. Instead of saving lives, instead of saving livelihoods, we are concentrating on meaningless amendments to our constitution. That is number 1 concern. Other countries, other responsible governments are concentrating on vaccines and vaccine rollout plans. They're concentrating on how to save lives. They're concentrating on what is called building back better. How do we rebuild our economies, which have been ravaged by COVID-19 in the past 18 months? That is the global concentration in terms of effort throughout the world, but we're doing something else in the country. Now, when we say the economy, how do you come up with an economic framework for a country? The first thing that you must do is to have a shared national vision, okay? The Zimbabwe we want was a starting point. But more specifically, you must have a shared economic vision. Where do you want Zimbabwe to be in 30 years' time in terms of economics? GDP, per capita income, infrastructure, education, manufacturing, all these things. We must have a shared national economic vision. Now, how do you craft a shared economic vision when we're busy fighting? When we are taking each other to court over meaningless amendments? When we're concentrating on division? When we're concentrating on misleadership? This is the major implication of this amendment. It has divided our people. It has divided the country. The country can't concentrate on a shared economic vision because we are fighting. We are in the courts. We are speaking at cross purposes. This is a terrible indictment of us as a nation because we can't concentrate on a shared national vision. These are the implications of amendment number 2. After crafting a shared national vision, the next question is, how do you move from where you are to the promised land? The shared national vision is what we call the house on the top of the hill, the aspiration for a nation. Then you ask yourself, where I am right now, where I am at the bottom of the valley, how do I move from the valley to the top of the mountain? That's what we call economic strategy, the game plan. How you move from where you are to the promised land is what we call economic strategy. That economic strategy requires all hands on deck. It requires buy-in and ownership by all Zimbabweans across the political divide. Civic society, business, academia, young people, women, the entirety of Zimbabwe must buy in into the national vision. It must buy in into the economic strategy that will take us from where we are to the economic promised land. How can we craft an economic strategy when we are bickering, when we're fighting, when we're desecrating our constitution? This is the implication of amendment number 2. We cannot craft and concentrate on an economic strategy to take Zimbabwe to the promised land, to prosperity, to shared economic growth, to inclusive prosperity. We cannot do it when we are concentrating and measuring minors, desecrating our constitution, concentrating on authoritarian consolidation, concentrating on controlling the judiciary at the expense of the economic agenda. What we need for the economy to move forward, what we need for our lives to become better in the economy, we need investors, domestic investors. We need foreign investors, FDI. We need entrepreneurship. We need infrastructure. We need beneficiation. We need value addition. All these economic activities require certain things. Number 1, the rule of law. Number 2, certainty of rules. Number 3, predictability of our frameworks, predictability of our laws and circumstances. Amendment number 2 is an attack on the rule of law. Amendment number 2 is an attack on certainty of our laws. Amendment number 2 is an attack on constitutionality. Amendment number 2 is an attack on constitutionalism. Now, for you to have economic performance, for you to have a vibrant economy, you must have constitutionalism. You must have constitutionality. You must have certainty of rules. We must make sure we are predictable in the economy. So amendment number 2 is a fatal attack on our ability to attract investors, an attack on our ability to attract domestic investors. Our own people, our own entrepreneurs must believe that there's the rule of law in Zimbabwe. They must see certainty in the way we use our laws. And of course, foreign investors, FDI, capital is shy. Capital will not come into a country where there is no rule of law. Let me explain this. Dr. Magaisa spoke about it in the morning, but let me dramatize it. Constitutionality is being in accordance with the Constitution, accordance with the law. Amendment number 2 is a violation of constitutionality. Constitutionalism has 3 parts. The first part is about limited government, the philosophy of limited government. Yes, a government must have power, but that power must be limited. That power must have checks and balances. That's number 1 aspect of constitutionalism. Number 2, we must have the behavior, the culture, the tradition of respecting a constitution. That's part of constitutionalism. The culture, the tradition, the behavior of respecting that document. That's constitutionalism. Number 3 aspect of constitutionalism, functional separation of powers, the judiciary, the executive, and the legislature. They must be functionally separate, not just separate, but functionally separate. Amendment number 2 is an attack on the functional separation of powers in Zimbabwe. The powers of the judiciary are being taken by the executive. The executive is going to control the judiciary by having a pliant, surrogate, and captured judiciary, by having surrogates as judges in Zimbabwe. The powers of parliament are being usurped by having a rubber stamp parliament. The laws are being made by the executive. Amendment number 19, amendment number 2 is a product of the executive. So 3 attacks. Number 1, an attack on the limited government aspect. The power of the president is no longer limited. We now have an imperial presidency through amendment number 2. Count number 2, the whole activity around changing amendment number 2 is a manifestation of the lack of culture, tradition, and behavior of respecting the Constitution. Count number 3, amendment number 2 is an attack on the separation of powers. Now, all those 3 are not good for the economy. All those things undermine economic activity. We cannot attract investors if we have no constitutionalism. We cannot attract investors if we have an imperial presidency. We cannot attract investors if there's no functional separation of powers. But more importantly, we cannot attract investors if there's no constitutionality in the country. Remember, amendment number 2 is a violation of both constitutionality and constitutionalism. That is not good for business. That is not good for the economy. We must remember that. Also, values. What kind of values are we manifesting around amendment number 2? If you look at the language of the Minister of Justice, if you look at the behavior of the President, the behavior of the Chief Justice, there are no values there. We need norms and values which are supportive of economic activity and economic performance. Unfortunately, values cannot be legislated. Values are developed over time. Values are a product of civic education. Values are a product of exemplary leadership, which is missing in the country. This is the challenge we have in the economy. And of course, civilian implications, the people, where are the people in all this? Let's look at some of these changes. Around the judges, there will be no more interviews of the judges. The interviews are a chance for civilians, for ordinary people to see their future judges. And also there was a provision for the public to nominate a CJ, a Chief Justice, which was taken out in Amendment number 1. The public is being undermined. The public has no role anymore. The civilians have been disempowered by both Amendment number 1 and Amendment number 2. You won't be able to see your judges being selected. You won't be able to propose and nominate a judge as Chief Justice. So the civilians, the ordinary people, have been disempowered. Running mate, what is the value? The value of the running mate clause is to make sure that there's clarity around succession. When the president dies, we know who is going to take over. And we as the electorate, we have an opportunity to choose that successor. So you have the president and 2 running mates. They present themselves in an election, which means the people, the civilians, have an opportunity to say, I want that guy, that woman to be my successor if the president dies. So the people of Zimbabwe are involved in choosing the successor. That is the efficacy, that is the value of the running mate clause. Again, power is being taken away from the people. The people are being disempowered by removing the running mate clause. Now, let me explain this very carefully and clearly. This was the motivation behind the running mate clause. But let us be very clear in terms of who was opposed to it and who supported it. Komichi was not correct in his presentation this morning. The MDCT under Tsvangirai, some of them supported the running mate clause, but their president did not. I was there, I was one of the 3 principals. President Mugabe, Prime Minister Tsvangirai, and yours truly were the ones at the end of the process. President Mugabe was opposed to the running mate clause. Prime Minister Tsvangirai was opposed to the running mate clause. Kovic did not tell us that. Maybe he was too junior. He didn't know that. It took only people like me to know that. Now, why was Mugabe opposed? He didn't want Mujuru, Joyce, as his running mate. Mujuru was a place filler. Mugabe had no respect for Maya Mujuru. She was just being used by Mugabe. Morgan Tsvangirai did not want Kupe to replace him. He was just using Kupe as a place filler. So yes, there were people in ZANU-PF who wanted the running mate clause because they wanted to be nominated as running mates. There were those also in MDCT who might have wanted it to, for the same reasons. But the leaders, Morgan Tsvangirai and Robert Mugabe, were opposed to the running mate clause. I was supportive of it. They were opposed to it. Now, what is the moral of the story? The churches and civic society, you have a role to play. Don't leave these debates to political parties. Sometimes political parties are conflicted. Sometimes political parties have vested interests. So right now, for example, if we're going to defend the running mate clause, don't leave it to MDCT, don't leave it to MDCA, don't leave it to ZANU-PF. Most likely, those 3 parties I've just mentioned might have no appetite for a running mate. But you and I, ordinary people, you and I, the churches, you and I, civic society, can easily see the efficacy and value of a running mate, as we saw in Tanzania, as we saw in Malawi, as we see in the US. But if we leave it to parties, the leaders, the ordinary members might like the running mates, but the leaders, the top leaders, might want to control succession. They want to keep it open. The moral of the story is, do not leave these major decisions and debates to political parties. Civic society has a key role. The churches have a key role. Ordinary people have a key role to defend the Constitution in many respects. Devolution, again, since morning, no one has spoken about devolution. The devolution provision in amendment number 2 is against the people. It is meant to kill devolution. Of course, the opposition people in parliament were blind, deaf, and dumb. They didn't realize that. They thought it was promoting devolution. ZANU-PF has had 8 years to implement devolution. They've done nothing. So what makes you think that they will turn around and then put in provisions to promote devolution now? Why? You've had 8 years to implement all the provisions from chapter 14. You've not done it. Now you come up with a nice clause to promote devolution. We are not foolish. We're not naive. The changes in amendment number 2 around devolution are meant to undermine devolution in general, and secondly, to undermine the opposition, in particular in the metropolitan councils, which are controlled by the opposition, Mutare, Bulawayo, and Harare. The motivation is to undermine those councils because ZANU-PF have no presence in those places. So they're trying to come in through the back door. They're trying to undermine the strength of the opposition in those councils. But in principle, the ZANU-PF does not like devolution. Even if Zimbabwe was a one-party state, there'll be no devolution because they do not like that as a value, as a concept. So devolution is against the civilians, the people of Zimbabwe. Devolution, the devolution proposals in amendment number 2 are meant to undermine the people, undermine civilian power, take power from the local to the center. There's a problem there. Okay, so we must understand the implications to society, to the economy, and the problems that come with it. What do we need to do? We need to make sure that we understand that constitutional changes are not bad in general. In fact, the tragedy right now is that given what has happened with amendment number 1 and 2, people now think that amendments are a bad idea in general. Not necessarily. We might find an area where we say our constitution is great, but there's a missing dimension here, and we can have good reasons for changing the constitution. So right now, the environment is so poisoned in the country to the extent that people might think that actually never change the constitution or hardly change it. No. For example, I'll give you examples. If you want, for example, to have the diaspora vote, the diaspora must vote. There should be no taxation without representation. Our diaspora is supporting our economy through remittances. They must be given the vote. To make sure their vote is guaranteed, we might have to put it in the constitution. Change the constitution to make sure the vote for the diaspora by the diaspora is guaranteed. If we want, for example, 100% PR, because ideally we want 100% PR for everything, PR in parliament, PR in Senate, everything PR, not this limited PR, 100% PR. To do that 100% PR, we have to change some sections in our constitution. To guarantee 50-50, 50% women, 50% men. To guarantee that, we might have to change our constitution. All these are good things, good reasons to change our constitution, not these devious reasons. And by the way, the idea about women quota, youth quota, ministers 5 to 7, that's what's called a poison chalice. These guys are trying to be clever and half. What they want is to scrap the running mates. What they want to do is scrap the appointment mechanism for judges, and then to cheat you, they give you a little, some few sweets in there. Women quota, youth quota, changing the ministers from 5 to 7. But the whole thing is poisoned. It must be rejected lock, stock, and barrel. Why? Because it's an omnibus act. It's an omnibus change. If they were sincere, they'll do one at a time. You give us the women quota, give us the youth quota, and the change in the ministers on its own. We approve that. You give us running mate, we reject that. You give us the change in the judges, we reject that. But they try to be clever and half. They think we're blind, deaf, and dumb. They put the evil stuff around a few goodies in the middle. And some foolish opposition members vote for that. that should have been rejected in total, because there is no rush for the youth quota. There's no rush for the women quota. The elections are in 2023. So we could have gone back and put those if we wanted them. So there's nothing good at all in that amendment number 2. It should have been rejected lock, stock, and barrel. Whatever is positive must have been introduced on its own, not with running mate clause changes, not with the judges changes. Should have been done. That's what's called a poisoned chalice. We don't want a poisoned chalice. The church, way forward, the church must speak eloquently against amendment number 1 and 2. You are the leaders of society. Leadership by moral authority. Speak out, stand up and be counted. Don't wait to be invited to the conversation. Take a position against amendment number 1. Take a position against amendment number 2. The people of Zimbabwe must support the legal challenge against amendment number 1 and 2. It's already in the courts right now. We must all support these lawyers. We must all put our shoulders to the plow and support action against amendment number 1 and 2. The government of Zimbabwe, Emmerson Mnangagwa and his colleagues, here's my advice to them. Show some leadership, back down, stop digging, withdraw your appeal in the Supreme Court against the High Court judgment. Now that amendment number 1 and 2 has been challenged, don't contest. Let it go. Let it go. Don't force this matter on the people of Zimbabwe. Show leadership. Concentrate on the economy. Concentrate on COVID-19. That's where our efforts should be. Show leadership and respect the people of Zimbabwe. Amendment number 1 and amendment number 2 are a direct violation of our constitution. They're illegal, they're unconstitutional. They're a manifestation of what we call an attempt to create rule by law. You know, we want the rule of law, not rule by law, or rather misrule by law. What you are doing with amendment number 1 and 2 is what we call misrule by law. So let us have some leadership from Emmerson Mnangagwa by, number 1, withdrawing that challenge in the High Court. Number 2, not fighting against those who are challenging 1 and 2. Back down and respect the people of Zimbabwe. Now, if they don't back down, there must be political mobilization against those 2 acts. And also, it has been mentioned earlier on, let us make sure in the future, no party gets 2/3 majority in parliament, no matter who you are, because we want checks and balances. Let people have majorities, but not super majorities like 2/3 majority. So we should make amendment number 1 and 2 election issues in 2023. And by the way, the regime is basically testing the waters. What they would want is to change the term limits for the president so that Emmerson Mnangagwa can have a 3rd term. They might also want to disqualify Nelson Chamisa by lifting the age requirement for the president. All these things are possible if they abuse their 2/3 majority. Civic society and the churches, please let us all work together to stop any further changes to our constitution. We must make sure never again do we allow a few people to destroy what was approved by 94.5% of the people on 16 and 17 March 2013. 3.3 million Zimbabweans spoke, and their views are being discarded today. As I conclude, let me congratulate my brother Magaisa for the Constitutional Law Center. Very noble institution, very noble effort. We must all support that. That's what we want, for people to be educated about the Constitution. That's what we want, to make sure we are all conversant about the Constitution. However, Brother Magaisa, I have one for you. I want to challenge you and say, it's not enough to have the CLC. The CLC must be the beginning. What we want, what we must have, is what I call the Zimbabwe Civic Education Commission, a constitutional commission, a Chapter 12 institution. Chapter 12 institution. Chapter 12, that's why we have our independent commission. Zimbabwe Electoral Commission, Zimbabwe Human Rights Commission, Zimbabwe Gender Commission, Zimbabwe Media Commission, National Peace and Reconciliation Commission. Among those commissions, there must be another commission, which we call the Zimbabwe Civic Education Commission, a constitutional body, a constitutional institution, a formal institution to champion education around the Constitution, to champion education around governance, local governance, national governance. In America, they call it civics. Our people must get an education in civics, political processes. So the Constitution is the main thing, but not the only thing. We need civic education about governance, civic education about values. That cannot be left to a private institution or a civil society body like CLC. Great organization, but not enough. Why? It can easily be said, oh, it's politically biased towards A. Oh, it's a private institution. We want a constitutional body. A constitutional body, a Chapter 12 institution, the Zimbabwe Civic Education Commission. And I hope CLC can do a lot of work to prepare, motivate, and advance the changing of our Constitution to add the Zimbabwe Civic Education Commission. In fact, a little story. This was my idea during the constitution-making process. You know, as the three principles, we had an opportunity to look at the Constitution and put things in there. I suggested this one, and unfortunately, it fell through the cracks. But now, given what has happened and the work of our colleagues, Alex Magaisa and his colleagues, you can see that there's need for a national commission whose obligation is education around the Constitution, education about civics. So let us take this forward. Civic society, the churches, don't shy away from constitutional changes because they've been abused. You can change the Constitution for the better and change it the correct way. You change it either by 2/3 majority or through a referendum. One, you have the right motivation. Two, the right processes. I think we must toy around with the idea of introducing in this Constitution the Zimbabwe Civic Education Commission. We might also think about the 50-50 provision so that we have 50% for women, for men in the Constitution. We might also think about overhauling our electoral system and say 100% PR. All these grand ideas might require a constitutional change. Some of them might require just an act of parliament, but it's up to the lawyers to tell us which way forward. But I've done my investigation. Some of these activities will require constitutional changes. So let's not shy away from that. And so I would want us to have more of a discussion. So I will limit my remarks and emphasize that in summary, what has happened around Constitution Amendment number 2 is detrimental to the economy of Zimbabwe. It is detrimental to the quality of life of our people. It is an attack on the civil liberties of our people. It is taking away rights from ordinary people. It is disempowering society and the civilians in Zimbabwe. And also, by the way, we are dealing with a government which is the product of a coup d'etat from 2017, a government which is the product of a challenged election outcome in 2018. So the bedrock, the foundation of this government is the military, the army, and not the people of Zimbabwe. So there's a problem of context here. So when we see rights being taken away from other people by a military government, it's a terrible indictment to all of us. We have to work together to make sure we save our constitution, we save our people, and more importantly, we concentrate on rebuilding our economy. We concentrate on creating a shared national economic vision. We concentrate on creating a national economic strategy. No one is going to come and save us from this situation. No one is going to come and create a national vision for us. No one is going to come and create an economic strategy for our country. You and I, we the people, must become the economic revolution we want to see in Zimbabwe. We must become the defenders of the constitution in our country. I thank you so very much for this opportunity.
Thank you, Professor Atham Tambara, for a very direct, I think, presentation. And I think you were rightfully mentioning that a vibrant economy hinges on the rule of law, certainty of laws, predictability again of the same laws. But you also highlighted that the amendments, they were actually a case of misplaced priorities, because as other countries assist with COVID-19 response, as other countries assist with trying to rebuild economies that were negatively impacted by the effects of COVID-19, Zimbabwe finds itself on the other side, concentrating on amending a constitution, yet the citizens are hungry, yet the hospitals have no medication, and etc., etc. But I also like that you also emphasize the issue that we can only get solutions or have solutions to what is happening if we start by having a shared national vision that includes an economic vision for the country. So citizens should come together and put their ideas and thoughts in one place in terms of having a shared vision that includes an economic vision for the country. But also you emphasize that it seems as though the amendment, instead of unifying the citizens, it has divided the citizens. And you've also spoken about the recommendations. I think they were quite clear as a way forward. You spoke of how a vibrant economy should include having domestic investors, should have foreign investors, should emphasize on infrastructural development and entrepreneurship. And all of these things, for them to happen, they are hinged on an environment that is conducive with the rule of law, with constitutionalism. And I also like the fact that you spoke of values. Besides us having a document, we should also be guided by values as a society that are supportive to making sure that we have economic activity that is inclusive of citizens of Zimbabwe. So you also gave us a task as the church. I think we are challenged by the task you gave us to tell us the role that we have in this conversation, taking it forward. And also you've recommended something to Dr. Magaisa's newfound platform to say that it's not enough to put a center together, but also you need to go on forward and possibly advocate for what you have called the Zimbabwe Civic Education Commission. We should be part of the Chapter 12 commissions found in our constitution. Thank you so much for that profound presentation. I think one that has been quite enlightening for our participants, and I hope that we are following in the conversation. So without wasting much time, I would like to introduce our next panelist, Ms. Namatai Kwekweza. I think it's very imperative that she gives us a perspective from the young people and also a perspective of the civilian voice with regards to the amendments that have sailed through. She's been quite vocal, speaking against the proposals from last year up to this year, and she continues to advocate for constitutionalism in Zimbabwe and of course rule of law. So Namatai Kwekweza, over to you. Thank you.
Can you guys hear me?
Yes, loud and clear, Namatai, go ahead.
All right, thanks very much, Teriro. Yeah, so it's very amazing that I've had to speak after Professor Asam Tambara. A very, very excellent presentation, and I really appreciated how we explained the issue around the running mates. I think it's very profound that people understand it that way, as well as the issues around the judges. So that was very profound. Yeah, so young people, it's very, very unfortunate that people don't have good enough levels of civic education, political literacy, as well as power literacy, for them to be able to interpret the behavior of the government, in particular reference to the political context to which we find ourselves, and also asking the fundamental questions as to who benefits what. I must say that it was very disappointing for me in this particular process to realize that young people and women who were benefiting from the arrangement of the youth quota and the women's quota, we're going out to mobilize people to be sympathetic to the whole of Amendment Bill number 2. Very, very unfortunate. The biggest beneficiaries, and I like to call them out by their names, you look at people like Priscilla Messiah-Irabwe, who was mobilizing women for the women's quota. You look at people like Honorable Mavetera, also for the women's quota, as well as the youth quota. And if you look at all of these individuals, fundamentally, they have been beneficiaries of the women's quota. And subsequently, they will also benefit from the youth quota, them and a few other politically elite and politically privileged young people and women. But to actually ask in the context of the substance of the everyday young person who is selling tomatoes on the corner of the street, there is absolutely no substance. To question this from the perspective of the everyday woman who does not have water, clean, safe drinking water, and they have to carry buckets for kilometers on end, to provide the basics for their family. You look at those people, have they been represented via the women's quota? Has the women's quota over the past 10 years been effective and instrumental in dealing with the issues that women have faced? And naturally, the answer is absolutely not. We have PR MPs who never spoke a word, and not even what we call the maiden speech, just to stand up and tell us who you are, what's your name. They are PR MPs that we don't even know are PR MPs. They have never done anything for women, and yet they want to extend such an arrangement because it serves to benefit an elite class of youth and an elite class, a politically elite class of women. But in actual essence, there is no real tangible benefits for young people and also young women in general. So the question for me was, at what cost? Because if we look at these amendments, those who are saying these amendments were okay, we're running about, with the women and youth agenda. They would say, oh, everything else was bad, but hey, look, youth got something out of this, and women got something out of this. And again, we see, women and youth being used to drive a political agenda that, in essence, does not benefit them, and they are being used to cover up, the real issues at hand, the real issues that Professor Asam Tambara mentioned, to say that the real reason why these amendments were happening were with regards to the executive. They were with regards to the president and him consolidating his power. They were with regards to the running mate. They were with regards to the judges. They had absolutely nothing to do with women and youth. And it is very, very unfortunate to see, even, older, women in politics running with this agenda of the constitutional amendments, to see even vibrant youth running with this agenda of the constitutional amendments, notwithstanding, the overall cost in the way of the rights that we have lost, through the president consolidating his power and through the executive becoming so powerful that the judiciary is in their pocket, and also the legislative arm of government has also been disempowered. So I think the question was to ask at what cost, because it's very unfortunate that the constitutional amendments have been masked as something progressive because they serve to benefit youth and women. So I just wanted us to look at it from that perspective, and then now dive deeper into the youth quota in particular. And then we have to analyze, I think at the end of my presentation, if the cost to which we got the youth quota is worthwhile in comparison to what we had to exchange with regards to what the president and the executive got out of this arrangement. That's to start with. And then the next thing that we have to ask is, was the youth quota even necessary in the first place? And was it something that was motivated by young people, by youth in general in Zimbabwe? So the first thing that we have to understand is that in our interface, in our conversation with the Minister of Justice, we asked him that, because he had confirmed that, the constitutional amendment.
We can't hear you, Namatai. We have lost you, Namatai. We can't hear you. I think you are muted. Namatai, you are muted. Oh. Namatai, you had been muted for a minute or so we can't hear you. Oh.
Is did this group of old men
Namatai,
actually
Namatai, we lost you for like a minute, so would ask you to go back a minute and give us what we may have lost. Thank you.
Okay, so I'm not quite sure where we left off. Do you mind just letting me know what was the last part you heard?
I think it's the part where you spoke about what people didn't understand they were giving in return when they celebrated getting the youth quota and the women's quota. Thank you.
Okay, that's fine. So yeah, like I was saying, the issue there has always been a question of, at what cost? And when we ask these fundamental questions to say at what cost did we get the youth quota and the extension of the women's quota, we understand that
again, we have lost you. Yeah, you can go ahead. We had lost you, but go ahead. It's okay.
All right. So, yeah, that having been said, with regards to, what is the cost of all of this? I think it's fundamentally important for us now to ask the key questions with regards to, where did, the clause on youth.
We have lost you again.
Actually consulted youth in ZANU-PF, who said that they wanted the youth quota. And my question to him and the panel that we were with on the day was, are the youth of ZANU-PF the youth of Zimbabwe? Did you go out and ask MDC Alliance youth if they wanted a youth quota? Did you go out and ask youth who are not in any political party if they wanted representation? And you realize that all of this was not done. So basically the youth quota, and I doubt even if these people asked youth in ZANU-PF if they wanted a 10-seat quota system. This is purely an arrangement that emanated from a group of old men who just decided to say, like, as we amend this constitution, let us make it appear beneficial, to the majority of citizens in our country who are constituting of youth and women, by giving them something so that we face less resistance. Because if the youth movement feels like they get something out of this arrangement, and the women's movement feel like they get something out of this arrangement, they will not in essence mobilize themselves against
We have lost you again, Matai.
Hello, can you hear me now?
Yes, we can hear you. Go ahead.
Okay. So I'm going to turn off my video. Maybe that will help with the network.
Thank you.
That's fine. Am I clear now?
Yes, you are quite clear. Go ahead.
All right. So the issues there are with regards to the fact that young people were not properly consulted. And the arrangement with regards to the Constitutional Amendment Bill number 2 does not, in essence, serve young people. It serves the political agendas of those who proposed that particular youth quota system, because it was meant to divert attention from the real issues that were in Constitutional Amendment Bill number 2, and to create a situation where it was a give and take. So you take something, we take something, because it now became very difficult for the youth movement to then say, we don't want you to go ahead with the running mate issue or to go ahead with the judges issue, when they, in essence, were going to take something with regards to the youth quota. It became very difficult for women to say, no, we'll take the women's quota, but we don't want you to amend the part on judges or the part on the vice presidents, because they would, in essence, say, but you are also getting something out of this. So the issue was that the people who supported the youth quota and the women's quota played directly into the politics, into a perfectly orchestrated political arrangement that made it very difficult for people to mobilize each other, for people to become polarized with regards to taking a position against Constitutional Amendment Bill number 2, because there are genuine groups within the youth movement and genuine groups within the women's movement who are going about saying, no, we want those amendments because we want to extend the women's quota. We want those amendments because we want the youth quota. And this is something that we saw not just from citizens, but something that we even saw, with civil society organizations. That also became very polarized, with some civil society organizations in the youth movement saying, well, we'll take the youth quota because it's a starting point, but not in essence, analyzing what was it cost, what were we exchanging for that youth quota. By agreeing to the youth quota, we were agreeing to far beyond, in the context of losing our democratic rights, in the far context of the presidency consolidating its power. And the end question would always be to ask, as the president becomes more powerful, as the president and the executive are undermining the judiciary and undermining the legislative arm of government, will these arrangements of the women's quota and the youth quota actually be any beneficial to the people of this country? And this was the lack of analysis and lack of in-depth thought that we saw happening with the youth movement and also with some elements of the women's movement. So I just want to go through the youth quota before now I link this to the social and economic issues surrounding this particular amendments. We understand fully well, to start with, that young people do not, in essence, need a quota system to solve the problem of their lack of representation. A quota system of 10 seats in itself is extremely tokenistic and has been forwarded by grown men, old men who understand that if youth were to come together and decide that they as young people wanted to be led by younger people, then they would absolutely have no chance against them. So this is a group of people who understand the power of youth and are now tokenistically giving youth things that youth can spend their time fighting about and focusing on, without actually focusing on what they need to do to get real and genuine power. So one of the first reasons that inspired youth like myself and various other youth groups to go against the amendments, in particular regards with Clause 11 that spoke on the youth quota, was that number one, the age of running for public office, is age 21. And yet we understand that youth can start to vote at 18 years old. And we as the youth movement, who are obviously against these amendments, were saying that an amendment to give youth a quota is not addressing this particular systematic exclusion of participation of youth who are contributing votes, and yet they cannot participate in an election to actually be voted for. We also went on to say that this quota system is very unclear about age specificity. So you have someone who can get in through the quota system at age 34, and the next year they're 35. A year after that, they're now 36, they're no longer a youth. How are we dealing with those issues? We have questions around the issue of saying that who appoints these particular young people through the quota system. We understand that in political parties, it is old men, and there is no way old people are going to appoint a youth who is not aligned to an agenda that they're driving. Therefore, youth interest will not be represented, because the youth who will make it into parliament through that quota system are more likely to advance the interest of the people who sent them to parliament, who appointed them to parliament, who in this case will most likely be old men from political parties and not the youth that they intend to serve. So this becomes a very tokenistic arrangement in the context that there is zero accountability to the young people that are supposed to be represented in parliament through this particular arrangement, because the youth are still being appointed by old men. So the question here had been to say, wouldn't it have been better to have an elective system with regards to the quota system? Another issue that went on was to say that a 90 seats within the context of the youth quota, why did they then settle on 10 seats? Why not settle on 90 seats? Why not settle on 20 seats? Why not settle on any other thing? And one of the reasons why they just threw in 10 in there as a number and said it was upon provincial lines is because there was no proper consultative process with regards to the youth movement as to say, would they have wanted 10 seats in a quota system? Would they even have wanted a quota system in the first place? Another issue that was raised with regards to young people is that, like I had said, the quota system does not have an elective system in place. Henceforth, the young people that are going to go in through the quota system will only be treated the same way women were being treated, being called Bakosi. You don't have a constituency. You are here through a sympathetic system that has, basically awarded you for doing nothing. So basically, youth are saying that we don't want that particular arrangement because it does not serve the genuine interest of youth. The other issue that has been raised by youth from where I stand has been the issue that it is restricted to political parties and it does not foster the representation of youth who have no political affiliation, youth who are not in any particular political party. So you would have to be in a political party for you to have access to parliament through this particular arrangement. And therefore it becomes exclusionary to youth who are in political parties, but not the everyday ordinary youth who might not necessarily affiliate to a political party. The other issue was with regards to, a gender mechanism with regards to those particular seats, as we realize that they will probably go, to mostly maybe young men. And we can rest assured that the young women who access parliament, public office through that quota system will probably have to experience a lot of sexual harassment and sexual abuse for them to get in through that quota system into parliament. Some of the issues that were raised was that it does not solve the issues of representation. Parastatal boards, commissions, councils, wards, at community level and at village development level. It does not solve the issue of youth representation. It is only speaking, to public office in the context of youth in parliament. Then the final issue that was raised with regards to young people who were vehemently against the youth quota system was with regards to saying that there were other legislative alternatives to particularly, the youth quota, amending the constitution for a youth quota. A legislative alternative would have been, a youth bill. Right now there's talk about a youth bill. And some of the things that have been put there with regards to representation could have been addressed in a youth bill instead of amending the constitution. Some of the issues that are happening is that with the youth bill, it is stipulating a 25% quota. But with the constitutional amendment, it is stipulating 10 seats for a quota system. And there is absolutely no alignment between a law that is being introduced and a recent constitutional amendment, proving in essence that there was no coordination, there was no prior communication, there was no prior effort to engage the youth movement with regards to where they were and with regards to the constitutional amendments that were happening. Because those who are putting the 25% quota with regards to the money in government, with regards to opportunities in government in that particular youth bill, and also with regards to representation in key sectors using that particular youth bill, are using the National Development Index, which clearly states that youth will get 25% in the way of all the things that they're supposed to benefit. But we see a misalignment with the constitution, because those who amended the constitution, they did not even bother to engage the youth movement, to engage youth organizations who were working around youth issues, to engage young people across the broader political, economic, and social spectrum. They were just old men who decided that we'll give young people this because this in particular was serving a particular political narrative and agenda that they were running with. So that having been said, we need to understand that with regards particularly to youth representation, the youth quota in itself is not solving the social, economic, and political issues that young people are facing. In essence, it actually becomes a machinery for political parties to get in youth who are going to be driving party agendas and not necessarily youth agendas, because we understand fully well that these youth would have been appointed and would have been sent to parliament by the old people, the old men in particular, who are going to appoint them, because those are the people who have the power to appoint, these young people to get into parliament, via the quota system. So that being the case, it's very important for us to come to a point where we understand that this is classical in our socio-economic and political systems, that youth and women are essentially abused to drive the political agendas and narratives of the powerful, who in most cases are much older people and who are usually men. So basically, most of these arrangements, the way that this whole fiasco has been packaged, it has been packaged as something progressive because it serves to benefit youth and it serves to benefit women. But in actual essence, it does not serve to benefit youth in any way. It does not serve to benefit women in any way. It is only a tokenistic and cosmetic agenda, a cosmetic fix to the real issues that are to do with the systematic exclusion of youth from public office. Some would have argued when we had these conversations amongst other young people that what would have been ideal was to work on the youth bill such that we have youth-friendly reforms in our laws that allow maybe for systems whereby for a political party to be eligible to contest in an election, they must submit 50% of their candidature as young people who are under the age of 35. Because the argument was that, for youth to be able to make it into public office, it's highly unlikely they would win elections as independent candidates. And therefore, we as youth can only vote for young people if we see them on the ballot and if we see them in political parties. We can actually go and put an X on a young person so that young people are actually elected into parliament and not having to go into parliament through a cosmetic quota system that seems like it's empowering youth, but in essence it's not. So that
We have lost you, Namatai. I'm not too sure. I think we have lost you there. Okay, I think we have lost Namatai there, but I think I'll just highlight some of the issues that she has made.
I'm back, carry on.
Yes, you can carry on, but I hope you are rounding up. Namatai, go ahead.
Absolutely fine. Thanks very much, Tero. So I'm not quite sure what was the last part you heard. Hello, Tero. I'm not sure what was the last part you heard.
I think I lost you on your last point on the youth bill, the one that you spoke about, to say that it should possibly have a proposal for 50-50 representation of young people when political parties nominate their people at elections. So 50% of young people, 50% of older people to contest. I think that's where I lost you.
Okay, absolutely. So we were not too far off. All right. So I think I'll just round off my presentation with regards to some of the key and crucial issues that have to be stated. Young people in Zimbabwe constitute a demographic majority. According to ZimStats, we constitute about 77.9% of the overall population. And UNFPA has stated that 62% of our population in Zimbabwe are young people under the age of 25. So we are generally a very young, population, and we cannot undermine, the importance of youth, not just to our economy, which is highly informalized, but the importance of youth in our social and political situation as a country. Young people must be genuinely represented in leadership, decision-making, and governance positions, because the behavior that we are seeing from the people who are much older is the behavior of people who are looting and eating because they know that most of them will not be there in the next 20 years. How does one person, sell off a mine, for instance, maybe to a Chinese, corporation, upon some shady deal that does not benefit the country? And yet we understand that in other progressive countries like Norway, they actually developed a sovereign youth fund whereby youth who are born 200 years from now can actually say, oh, from the oil that used to be there here in Norway, the money that we are enjoying, the infrastructure that we are enjoying, the education that we are enjoying in this country, it was because of the oil that existed 200 years ago, whereby our forefathers decided to sell these things off at a good price, invest that money into socio-economic development, into social services, such as education, such as health, building about infrastructure that helps this country to develop and become a better country. But we're not particularly seeing that behavior because we are being governed by people who have a very short outlook and very short scope, who are going to loot everything because they understand fully well that they will not be there in the next 20 or 30 years. And they are so entitled that they're going to just take everything and leave absolutely nothing behind for young people. So the issue has to be stated that young people must, in essence, fight against the Constitutional Amendment Bill number 2 because it is a tokenistic arrangement that does not solve their social, economic, and political issues. The Constitutional Amendment Bill number 2 must be viewed from a perspective of intergenerational injustice, because in essence, it is young people who have the longest time to be governed under this constitution. It is young people who have to bear most of the pressing issues that will emanate from a lack of checks and balances between the executive and the judiciary, as well as the legislative arm of government. If now the president can get into international treaties without having to go through parliament, without having to seek any kind of approval through parliament, as has been allowed for in this Constitutional Amendment Bill number 2, we're going to realize that they will basically do whatever they want. With regards to the present minerals and the present wealth that this country has, and also with regards to the future impacts that will have on our economy and on our children and their children. So young people must be in a position where they think it through to see that the Constitutional Amendment Bill number 2 is about bread and butter issues. It is about the future of young people who have the longest time to be governed under this particular constitutional arrangement. And it is absolutely ludicrous. It is absolutely scandalous that the Constitution was amended without involving the people who have the longest time to be governed under this particular constitution in full. And also after, just basically ignoring the voices of the few young people who participated during the public hearings, who basically said no to the constitutional amendments, particularly clause 11 on the women's quota and the youth quota. And we understand that this is something that is even recorded in a report that was produced by the Portfolio Committee on Justice, that the people said no in the public hearings to the Constitutional Amendment Bill number 2. But all of these voices were just ignored, and these people continued with the amendment process because they were saying that the people who said no in that particular consultative process had been sponsored or had been paid to come and say no in that particular public hearing process. So I think that it's very important for young people to understand that every decision that will now be made by the executive, every decision with regards to mineral resource governance, with regards to infrastructure development, with regards to what kind of investors we're getting into the country, the kind of mega deals, arrangements that are being made. If we don't have an effective judiciary system and the executive so happens to get into a corrupt arrangement that is stealing our future, when we go to those same judges who absolutely report to the president and the executive and no one else, we will not get justice in the context of protecting our future, in the context of defending our future, in the context of defending the future of this country economically, politically, and socially. So it's very important for young people to understand that a lot is at stake. And if we think we are suffering now, if we continue on this trajectory of allowing our constitution to be amended nilly-willy, then in the future, we are going to suffer even more because the executive arm of government would have stamped on the constitution to a point where we as citizens cannot get any kind of protection from that constitution. I think to round off my presentation, I will end with the words of Bobby Wine, when he said that we must, as citizens, defend the Constitution before the Constitution is too weak to defend us. Over to you, Terrio.
Thank you so much, Namatai. A very vibrant, I think, presentation and articulation of the perspective of young people with regards to the amendment number 2. And I think you have hinted on the transactional nature of the youth and the women's quota and what we had to trade in exchange for those quotas. Then you also speak of the compromised contribution of youth and women in this amendment process when they spoke to the issues of the quota system for youth and women. But also, I think you touched on an issue that runs constant all the time in conversations about how we are roping in the young people in terms of representation and in terms of their participation. The issue of meaningful representation, remains hanging in the air. And you know, you have rightfully mentioned that the quota system doesn't solve the socio-economic challenges that youth are interfacing with every single day. And also you have highlighted that there's a tokenistic piecemeal representation of youth and women through the amendment number 2. I think I'll stop here. I would have wanted Stabile Dewa to go next, but because of the flow of the conversation, we should speak in detail about the women's representation. But Blessed Mdlanga might leave us early, so I really wanted to make sure that doesn't leave without having given us his contribution. We just want to hear, as the fourth arm of the state, as someone who operates within the media, how stories have been covered around the constitutional amendment, what were the issues that were coming up, the court cases, the issues that are just going forward right now, just to hear the perspective of the people who operate within the fourth arm of the state. I know people always speak highly of Zimbabwe as 3 arms of the state: the legislature, the judiciary, and the executive. But there's also a fourth arm of the state that monitors the activities, you know, of these 3 arms of the state, that being the media. So Blessed Mhlanga, over to you. Thank you.
Thank you very much. I hope everybody can hear me.
Yes, we can hear you loud and clear. Thank you.
Okay, no, thank you. So I've had the privilege of working closely with communities and leaders of society as we check this bill from the principle before cabinet and when it was gazetted and to the point where it became law. I'm having a lot of people, including Namatai, Alex Magaisa, discussing this constitutional amendment. Now, of the paramount importance as a journalist, as I followed this story over the length and breadth it took, was that in the first instance, Parliament went through to do what they call public consultation. And in the public consultation, there was an overwhelming no to the constitutional amendment attempt. Also, this public consultation was very, would I say, not exhaustive, because it went into certain areas during the COVID lockdown, and not a lot of people managed to put their input. For the first time, I traveled to Chilonga village, where we have over 50,000 people who are around that area. And we went through there and we asked them if they knew anything about the constitutional amendment, bill number 2. They had not heard anything. They had not been consulted. As far as they were concerned, nothing was happening to the constitution that they had voted for. But those few who managed to speak, they spoke and said that they would not want to have the constitutional amendment bill. Now, this was consolidated in a report that was brought into Parliament, and that report clearly said that the people of Zimbabwe had refused and had not consented to the Constitutional Amendment Act. But the Constitutional Amendment still went through, regardless that the people had spoken, regardless that the consultation had gone through and people had rejected. Now, this raises a serious, especially to the drafters of the law, to the Alex Magaisas of this world, and a whole lot of people, that what role then, what importance is the consultative? Because when you consult and people still say no, Parliament can still go ahead and act in a manner that it did. There's also this notion that the constitutional amendment was a give and take, where people were enticed to support certain clauses of the constitutional amendment there, number 2, mainly the youth quota and the women quota. But all the women that we have spoken to, all the women organizations that I have had time to interact with, court and in delivering the stories as we looked through this and as we checked that did not want the women quota. What they wanted was that the clauses in the Constitution, the clauses that already exist in the Constitution, be implemented. And these clauses are the 50-50. I'm glad to start the wise here, because I had an interaction with as well, and it was clear to youth were also clear that they did not want to have tokenism and be given certain clauses to do with empowerment, because in their view, those things did not provide empowerment. Now, I will not belabor on this point because Namatai just did talk about it. So the most important aspect is that there's only one political party that said it was confused because of these clauses. I did not hear, even during the consultation phases, the women or the youth being confused because they clearly spoke against these clauses. But it was only the MDCC coming from their backgrounds who said that they were confused. But even as they said they were confused, the women in the party were voting against those clauses. The most powerful women in their political party were voting against the clause of women and youth empowerment. So you'd have Thokozani Kupe, who's the vice president, voting no. You'd have the secretary general, who's Paulina Mpario, also voting no. So from the data that we have, the confusion becomes a myth and becomes an excuse for political people to achieve political power at their own interest and want to hide in terms of, to say, women empowerment. Now, having spoken to women who have been, who have say, benefited from this proportional representation, none of them are happy about the presentation. Those who are in parliament at the present moment are not even happy about it. Now, I spoke to Lynette Kairenyi, who's now the vice president of the MDC Alliance. She was recalled from parliament because she was proportional representation MP, and she has no recourse. So you then realize that with section 129K around, it makes women who benefit from that proportional
Blessed, if you could put your mic closer to your mouth, if you could, your mics. Yes, thank you. Yes, you can go on.
Okay, sure. So if you realize it, section 129K of the Constitution still alive. Okay. Section 129K of the Constitution being alive, it basically means that proportional representation cadres can be recalled at any given time, and they have no recourse in terms of going to a by-election, in terms of going to a by-election, because once they are recalled, the party can choose the next person using a party list. So they have no political width, they have no political power, and they have no real power. They have to be subservient to the political party, and women are aware of this, and they have no they're not disillusioned about it in any way. You then go to the youth, and they are gifted 10 seats. Now they're gifted 10 seats in parliament. What does 10 seats in parliament do, people in Zimbabwe, where you know that the law is not passed in parliament, but it passes through parliament? So parliament has been reduced even in terms of its power, because you also have on the bill amendment, on the Amendment Act number 2, where the powers of parliament to scrutinize debt that this government or any government that enters into its private players from other countries cannot be approved by parliament. So it then gives this power merely to the executive, and it takes away power from parliament. But then youth are then put into parliament, where power is actually being taken out of it. So they have been very, very clear. Now you then go to look at the court challenges and the court challenges, where the media has played its role in terms of highlighting the issues and keeping the nation informed to the processes of what is happening, and also thank you to social media, even organizations that are going through these processes have been pushing this, their own information through social media. But the biggest problem is that government holds the biggest propaganda machine, right? Holding this biggest propaganda machine, it has been able to control the information that comes through to the public. So, for instance, you had the first narration, coming from the Sunday Mail, where it said that the ruling that Musa Kika and others got from the High Court would not hold unless confirmed by the Constitutional Court, right? And this became the whole song, to the point that that legal view is the one that is holding today, where the Chief Justice Malaba is now back at work and is reporting for duty in complete disregard of the rule of law. But the same people in yesterday's Herald went forward to say that this matter can now be heard in the Supreme Court because it is a narrow point of law. This view was put forward by Professor Lovemo Maduku, and the government seems to agree with it because it has approached the Supreme Court and it is now saying that this matter is a narrow point of law. And if it is a narrow point of law, then a declarator can deal with a narrow point of law, and an appeal does not then suspend a declarator. But because they control the levers of information and propaganda, and they have the biggest share on the media market, they've managed to spin all these things to the point that even now, some people believe that there were women organizations who were confused as to the clauses. But in the morning session that I attended, there was one leader from a woman organization, I don't remember her name, and she said that she was clear that women were never confused about this. They don't want it. They want the 50-50 that is provided for in the Constitution. So the propaganda machinery has been working, and has been working effectively to disenfranchise citizens by giving them information that is wrong and that is false. But to my dismay, I found that civil society has been aiding and abating state propaganda by taking money to fund programs on state propaganda and thereby keeping it afloat, but then come and complain about being treated unequally in private media spaces where they don't even want to take their money there. So they've become hypocrites, and they've become enablers, in Alex Magaisa's words. They've become enablers to oppression that they claim to be fighting against. So it means a vicious circle, in my view, where we want the nation to have a buy-in, but there's no investment in ensuring that information reaches to everyone, even in the deepest of all spaces, so that people begin to understand the issues that they're talking about. Reductions to hotel rooms, to the urban confines, and leaving out the rural people has been the biggest undoing in any system of democracy in Zimbabwe. Because at the end of the day, those who are without the information have become the majority. We have decided how we are governed by who in most of the instances. Because every time you go to elections, you find that when you start counting Uzumba, when you start counting Maramba, Fungwe, discourse changes. Basically because these people have been starved of information, they've been fed lies, and that is the only information that they have managed to hold on to. In the past, you used to have SW radio that would reach in those places, and then this is why. Sorry, so this is why you found that during that particular time, you then had youth militias and war veterans going door to door, confiscating radios from rural people, because that allowed them to information which was factual and which would make them understand the rules of democracy and how it is handled. So generally for me, without serious support from because at the moment they're the ones with the big money, they're the ones who are sponsoring programs to do with democracy, and you know, without them, without their support, the private media will die. And when it dies, that means that the monopolistic propaganda media will remain, and it will be then that which will be used to influence and to send a message to people who are around Zimbabwe, who would matter when they come to vote. They will vote without information. In my closing submission now is that the role of the media in a democratic society is to inform people so that when they go and vote, they do so with clear conscience issues on the table. In Zimbabwe, at the present moment, we have a constricted space for factual media, and it has given advantage to those who want to manipulate and take power and consolidate power to themselves and ignore the voice of the people, which in their instance, they said the voice of the people is the voice of God. So this, for me, would be my submission at the moment. Thank you very much.
Thank you, Blessed Mhlanga. We really appreciate that view from the media where you spoke of for the issues of access to information, and not just any information, but access to truthful information for all citizens of Zimbabwe, especially those who are in marginalized communities, and how there's this propaganda that continues to go around. And we spoke of private players in the media who have sort of like helped to balance the outgoing of information of what is happening in Zimbabwe, and also in terms of tracking and reporting the various conversations that are happening around national development. Thank you for that presentation, Blessed. I think I'll now move on. We have two more panelists, so I'll move on to Stabile Dewa. I think I would wanted to touch on the women's movement, and in terms of the extension of the quota system for women. She's coming from WALPE, I think an organization that primarily focuses on the representation and meaningful participation of women in the political space. So Stabile Dewa, over to you.
Thank you very much, Tariro and ZCC, for organizing this important meeting, and to all the speakers that have spoken before me. It is quite difficult to speak second from last, so I'll try to be as brief as possible. I think our position is very clear as the women's movement. We said no in totality to the extension of the women's quota system and to amendment number 2. But surprisingly, I think you have seen what has happened, that those in power continued then to extend the women's quota system against the wishes of Zimbabweans. So I don't want to bore you with the definitions and all that has been said before, but I think as Zimbabweans, beyond the discussions, the talk shows, we really need to go back to the drawing table and analyze what this means for democracy going forward, because it looks like we are approaching this as if we are dealing with people who are still reasonable. We need to understand where they stand. I've seen presentations around it affects the brand Zimbabwe, it affects issues of investors, but where do these people stand pertaining to the amendment number 2, the lack of respect for the Constitution? My take is they no longer care. They don't care whether they live, they die. They don't care whether Zimbabwe rises or falls. And already we have fallen as a state. So whatever mechanisms or whatever propositions that we make collectively, we need then to define where we stand with those in power so that we'll be able to deal with the situation as it is. Because they know that if they amend the Constitution, it's going to demoralize investors, it's going to create chaos, it's going to further divide the nation, but they still don't care. So as we plan on what to do next, we need them to define exactly where we stand with those in power. I just want also to emphasize that there are some other areas where people are not touching regarding the extension of the quota system and also other amendments that were proposed. I want to speak to the proposed lumping of the Zimbabwe Human Rights Commission, the Zimbabwe Gender Commission, and the Zimbabwe Human Rights Commission under the public service. What are the implications to democracy? What are implications to separation of powers? Many people say that these commissions haven't done much, but were they capacitated to be functional? So I think those are also areas of contestation that we also need to push collectively, because with the little that we were gaining from the Zimbabwe Gender Commission, from the Human Rights Commission, what does it mean when they are lumped together under the Public Service Commission? And what action can we take now going forward in terms of pushing that they remain autonomous and that we avoid these amendments going forward? Someone has indicated that this is just the beginning. So in terms of being proactive, what can we collectively do as Zimbabweans? Because I remember last year, there were very few organizations in June that mobilized citizens to go and speak during the constitutional bill hearings across the country. And as the women's movement, we came together, we mobilized women in all the 10 provinces. And I can authoritatively speak that the women's quota system was rejected by the women. It was rejected, the youth quota system, by the youth. So we need then to define whose interest is the quota system serving. Already it's not the women, already it's not women. So how do we then deal with a situation that is only benefiting the elites who are in power? Even if you read like what Namatai was saying, the reports from Parliament, the Justice Portfolio Committee report, it was clear that the women rejected the quota system. I, for one, together with other women's rights organizations, we did engage the women. I've seen others saying that there are some women from other political parties who supported. I don't want to agree with that. Maybe they supported on the day of voting, but in terms of engaging them, at first there was confusion. Yes, I would want to admit there was confusion. Some wanted the because they didn't understand the benefits of having gender balance in parliament, in local authorities, and all leadership positions. There was a lot of work that was done by the women's movement in terms of engaging bilaterally political parties, the ZANU-PF MDC, various MDCs, and also independent commissions, parliamentary caucus, so that we come up with one position, including the Zimbabwe Gender Commission was actually in support of 50-50. We then went to the hearings. The women actually supported 50-50. And I have not seen since the past 2 years, because this discussion started in 2019, I have not seen a single woman leader from all the political parties who came in the public to support the extension of the women's quota system. So in terms of our discussions, we need also to start evaluating and assessing the whipping system, for example, because if you get in touch with the people who voted for this bill, they'll actually tell you that in the Senate, there were 2 people who had the database calling one senator at a time. It was not even a secret voting system. They were told, do you support, do you not support? Obvious people would say, yes, we support, because there's the recalling aspects over their head. So how do we then deal with these things in going forward? There's also the issue for us to achieve gender parity in Zimbabwe. We really need to start discussions around changing the voting system in Zimbabwe from first past the post to proportional representation. That then guarantees gender parity from the top to the bottom, because now we have 30% quota in local authorities. We have another quota in parliament. What about the president? We actually don't have a woman vice president. What about in other community level leadership positions? What about in the church, the religious groupings, and youth aspect? So when we are pushing for reforms, we need to make sure that they meaningfully benefit the ordinary person. And as we start discussing about the way forward, where does the ordinary person stand in all these constitutional deliberations? Because we cannot only engage citizens when it comes to numbers so that they just include in terms of statistics. How do we unpack the issue of the amendment number 1, number 2, and the broader constitutional agenda, so that the ordinary person understands, the ordinary woman in the rural area, in the informal sector understands? Because right now this animal remains up there and very difficult to understand for the ordinary person. So I think more of our efforts have to go towards engaging the ordinary people in communities, wherever that you find, especially women in their safe spaces. How do you link the everyday challenges that women are facing to issues of lack of respect of the constitution? We have women in the informal sector. How do you then make them understand that the reason why we have 90% of Zimbabweans in the informal sector and 10% in the formal sector is because things are not going on in terms of respect of democracy and rule of law? So let's go back and then engage communities and make them understand that youth issues of abuse of drugs and also forced prostitution, women should choose to get to be sex workers instead of being pushed into that because of poverty. So how then do we engage these women so that the agenda does not only remain at our level? How do we then make communities, even starting from the most minute level, to understand that the reason why we have all these social ills increase in cases of even murder cases in Zimbabwe? I think you have all noticed that there's been an increase in cases of murder. We have seen in cases of rape. How do you then link all that to the failure of the government to manage the country and also issues of corruption in terms of access to health and access to education? I also want to point to the issue of gender equality being a low-hanging fruit for the government. I wish there are people who are close to the system to try and explain to them that besides just trying to push, doing demonstrations around sanctions and all other dramatic things that we're witnessing as a country, issues of gender equality are actually a low-hanging fruit that can actually put Zimbabwe on the international map. I was in Rwanda recently with some government officials. Rwanda is not performing well in terms of human rights cases, but they're actually number 7 the whole world in terms of promoting and achieving gender equality, and number 1 in Africa. We might fail Zimbabwe as Zimbabweans economically, socially, and politically, but we can do well in terms of ensuring that we have gender balance in all leadership positions. And in terms of going forward, we really need to fight. We should be more proactive rather than reactive, especially before things are put into law. When we start seeing the indicators of dictatorship, that's when we should start fighting instead of waiting and then start reacting when all this has already been put into law. But these people, they do not care. They don't care whether we live or we die or we eat or we sleep hungry. So we really need to make sure that collectively we come together, the oppositions, other progressive, even people from the ruling party, civil society, social movements, and the youth, and fight. Like now, look at Zambia. Sorry, they do have the running mate clause, and 5 of the major political parties have fielded women as running mate candidates. That's something that is quite progressive towards women empowerment, and it's something that we are fighting in Zimbabwe. So we really need to make sure that these issues are put in the fore and make people understand why we are pushing this agenda. Right now we have the patriotic bill, and how do you then make people understand that fighting for constitutionalism and alignment of all remaining laws is actually an act of patriotism? How do we link the struggles that we are pushing for as civil society to the struggles of the ordinary person who's sleeping on 1 meal per day? And you know, as Zimbabweans, we have a challenge of the bystander syndrome. How do you then motivate people to continuously fight against the tyrant, against the violence? And also, how do we continue rejuvenating people to claim their rights at every turn? When you're waiting in a queue for transport, how do you then link it to constitution? How do you link it to democracy, the rule of law, and also a functioning economy? As long as people do not understand those basics, we will continue to be speaking to ourselves. Then in terms of conclusion, these people are not going to stop on amendment number 1 and amendment number 2. So we really need to be, I will emphasize on being proactive. We really need to work together and stop working in silos, and also engage all other stakeholders including people in the diaspora. The diaspora remittances should come to Zimbabwe with conditions that if you promote dictatorship, Mami, Dedi, my brother, if you support people who are infringing on other people's rights, we will not send money. We should also come with conditions that if we give you the money, you have to guarantee us that you're going to register to vote and also vote. So in a nutshell, this is what I want to say to Zimbabweans. We still have time before we, like what has been said before the constitution is beyond repair. We need to guard jealously our constitution. As we came out in our numbers in 2013, we can still do that now going forward and make sure that it's never again Zimbabwe, where you have people just playing around with people's rights. And also we need to be wary as civil society not to play within the factional fights of the ruling party. Right now, I believe that the judiciary is captured. Last year, we took the government to court over failure to carry out by-elections. It was in October. The case was only heard last week. And for me, I felt relieved, but I then started asking myself, whose agenda is this case now pushing within the ZANU-PF fights? Because why now after 8 months, including the other case of Malala, are we not playing into the factional fights of ZANU-PF? And how do we then shape our own agenda rather than playing into the agenda of the elite over? And thank you very much, Tan.
Thank you so much, Stabile Dewa, for quite a clear presentation, I think, in terms of the perspective of the women's movement. I think they actually have particular amendments that affect them, not even affect them, affect us as citizens. And I think she spoke with clarity to say that, we need to zero in as citizens in engaging the ordinary citizen and try to link the plight and the struggles of the citizen with what is happening with the constitution. And we also need to see that gender equality is a low-hanging fruit, that if government was indeed sincere, it's something that they can address comprehensively and without wasting much time, in as much as we may have other challenges, but gender equality is something that is a low-hanging fruit. We can learn lessons and borrow leaves from other jurisdictions. But most importantly, I think this is something that is running consistent throughout most of the presentations today, is that if these amendments have sailed through and we are where we are today, it means more are to come unless and until we get a grip of this situation as Zimbabweans. Thank you, Stabile Dewa. So now I hand over to our last presentation from Kipson Gundani. Kipson Gundani is a player in the economy, and we just want to hear his perspective, of course, as a player in the economy, in terms of the amendments, in terms of the implications, and what he thinks are the solutions going forward from this point. Over to you, Kipson Gundani. Thank you.
Thank you, and greetings, everybody. I think a lot has been said by those who spoke before me. So my intervention will be very brief and short. Firstly, I think this war constitution amendment noise is sending wrong signals to the economy, to the people, to the international world. It's a country that changes things willy-nilly, is a country that is not consistent with what it does, is a country that does not guarantee predictability, and that alone, it further exacerbates the already weak confidence base that we have in the country. And ultimately, it affects a number of economic variables which are essential. One of it big investments, like what Professor Mtambara talked about. Then I want to focus on mainly amendments proposed on Section 327 of the Constitution, which are to do with the tabling of agreements made by foreign private institutions. I think in any health institution, health country, health government, there ought to be checks and balances, especially when you are dealing with issues that affect the public. Given that we have got a government that has got a habitual historical record of borrowing and actually misusing funds, I think if you look at our dirty statistics, they speak volumes for themselves. It will actually be a blow to us as a people to have such kind of a provision. At least the parliament may provide an oversight role and also a critique on some of these agreements and commitments, which are actually a burden ultimately on the population. Because the government itself should not be in the business of transacting, but it should facilitate that as private citizens we transact. So whatever the government contracts with a foreign partner, ultimately it is the population which either benefits or suffers from it. So in this case, I think it is only noble and wise to allow the parliament at least to provide scrutiny and oversight on any agreement that the government ought to do with a foreign partner. But more importantly, I think I liked the point that Professor Mtambara raised to do with civic education. But I wanted to propose that the civic education starts with the parliamentarians themselves. I am highly convinced that our parliamentarians do not really know or do not have the conscience of what decisions that they are passing. I don't think that they are adequately informed. Instead, they are just whipped into rubber stamping something which they do not fully understand, and the implications thereof, even on themselves and even their future generations to come. So I think our parliamentarians need to be highly informed, educated, and taught. I'm one guy who proposes that yes, we might say O level it's the primary qualification that you can have to go to parliament. But I think we ought to send our parliamentarians to school so that at least they are able to read and interpret and able to provide a critique, a reasonable critique to some of these things. So I think in a nutshell, I think there's general consensus across the sectoral divide of our society to say these constitutional amendments, they're not the right thing to focus on at the right juncture. Secondly, they are also sending wrong signals. And thirdly, they do not serve any immediate purpose. And therefore, we begin to question what is the motivation behind. So I think we've got a long road to walk as a country. I think we have got a lot of vested interest in this war matrix, vested interests which are ultimately leading everyone astray, vested interests which are actually leading to toxic, if I may use that word, amendments, which may not be very healthy to modern day democracy. Those will be my summary remarks. Thank you.
Thank you, Kipson, for being as brief as a miniskirt. But I would also want to highlight that I think in being brief, you also highlighted something that is, I think, something we should start deliberating about and considering as actors in the CSO sector, where you are saying that civic education must actually begin with parliamentarians themselves. I think it's something that I've not heard before. It's the first time I'm hearing this, and I think it's a point in case I think we may need to consider. But of course, you spoke about the misplaced priorities of our government, and also that, you know, in terms of this amendment number 2, it is sending wrong signals to the international community that we are trying to woo back and we are trying to outsource or trying to make sure that they give us some form of foreign investment. And we are also seeing that you spoke of sending parliamentarians to school. So it doesn't end with providing civic education to parliamentarians, but you also said for them to comprehend the implications of some of these legislative developments, it's also important that our parliamentarians are brought almost to the same level of understanding, you know, in terms of the developments in law and other things, so that now when there's advocacy going around, people are on the same level of understanding and just don't just rubber stamp developments, because some may do so without knowing the implications or the consequences of doing so. So thank you so much, Kipson.
Hello, we can't hear anything. Hello.
Okay, can you now hear me?
Yes, I can hear you now.
All right, thank you. I'm just reading the comments in the chat box, so I think I'll go back. Someone says, thank you, Professor Mtambara. You have enlightened us with a good presentation. Someone says, arise and shine, for your light has come, and the glory of the Lord is risen upon you. For behold, the darkness shall cover the earth, and deep darkness the people, but the Lord will arise over you, and his glory will be seen upon you. This is Isaiah 6, verses 1 to 2 in the New King James Version. Then someone says, splendid presentation, Professor. Thank you, Professor Mtambara. Well presented, very insightful. Someone says, the attack on our constitution must be a very good impetus for all law-abiding citizens to unite in a fight against those who seek to amend the national charter in order to create totalitarianism in a democratic dispensation. There must be a way for citizens' voices to be heard, and action taken that indicates that their concerns have been taken on board. Then someone says that, so the bulking of the amendments was meant to smuggle the intended power consolidation tool. Are we not equally to blame as CSOs or civic society organizations? This is a question. Why is the CSO and NGO forum silent prior to the making of the law? We are then now seen to be more reactive than proactive. Someone says that's a very interesting perspective. I'm not sure about the reference to old men too much. I think this is to Namatai. Perhaps you could make it more nuanced so that you do not lose the support of a certain group of the population. Then someone says, I wish youths were listening to your presentation, Namatai. You were on fire. Brilliant presentation, Namatai. My take is that the proper accommodation of youths is through a party list electoral system than what is in the amendment. This is Machova Nangube from the Law Society. Then Marjorie says, a regime that seeks to increase the presidential age to disqualify the youth doesn't care about the youth to begin with. Well said, Namatai. Excellent presentation, Namatai. Then someone says the proportional representation indeed creates puppets, thereby making those candidates vulnerable to abuse. Those are the same people who bring the false 2/3 majority. How does this become a representation when they were not subjected to the selection processes of the representatives? Then someone asks a question to say, is it possible to amend the constitution to remove clauses allowing parties to recall their members of parliament from parliament without consulting the electorate? This is a question. Then someone says ZANU-PF has manipulated the media to their advantage. Spot on, blessed. The challenge is some of the discourses are so elitist in nature, confirmed to urban and not the rural communities, hence the lack of nationwide traction. Then someone says, when such women are not in the decision-making bodies and those tokened are in positions, there is no hope of sanity. I think this is in reference to Stabile Dewa. Engage and we need real representation. Following a good presentation, only network challenges. Then someone says that the second amendment of this constitution is just a poisoned chalice. The ones pushing the agenda of this amendment were aware that the real meat of this was not in all of the other issues we are now wasting time talking about. They threw a bone at us and now we are busy chewing at it whilst they are consolidating their positions elsewhere. Someone says, great point, there must be education of parliamentarians. Someone says, point on the parliamentarians as well as even the councillors, and it goes to all arms of the state. Great presentations, Professor Mtambara, star and blessing. Then our parliamentarians are like furniture. They do not understand that their job is to represent the electorate who elected them. So I think these are some of the comments that are coming in. Thank you so much. I think Namatai says, yes, intergenerational connections are important. I refer to old men in the context of systematic exclusion of both youth and women. It is usually men who are usually old who have the power to decide. Even young men are excluded, even though they are men. So I was trying to be specific, but thank you for the comment. Then a must attend meeting from the morning till now, even though there were some network challenges. Then thumbs up to you all who presented. Professor Mtambara, Namatai, you have really empowered us. So now we go to the plenary session. I think we can now see with the raising of hands, those who would want to interact with the presentations of our panelists in this last section, those who want to comment and those who want to ask questions. So if I recognize you, you can then unmute yourself and make your submission. So I can see that Sake Sfelani Ngoma has raised her hand. Sake, you can unmute yourself, make your contribution, your comment, or ask your question. Go ahead.
Thank you very much. And thank you most especially to the panelists who displayed clarity on the position of the women's movement regarding amendment number 2. I wanted to pick up a matter arising from the conversation. And the first one that I wanted to pick up was the accountability, or rather the non-existent accountability of political parties in our system. And to also acknowledge that amendment 2 also represents an outsourcing of political party problems to us as citizens. And yet citizens, as I shared earlier, have got limited right to recourse in terms of making political parties accountable. And it is unfortunately a framework which any political party which walks into. So if, for example, the opposition was to walk into a ruling party position tomorrow, we have a high risk that they too would fall prey to the same weaknesses that the current ruling party is facing, because we have inadequate checks and balances on political parties themselves. If it comes to pertaining to issues of education, we are now scrambling to deal with quality of representatives when they are seconded by political parties to those seats as candidates. Why is it that we don't have adequate controls within political party system itself to ensure that we don't get low quality representatives? Of course, the law becomes a tool in how to achieve this, but we must be able to have a bigger discussion about making political parties accountable. Secondly, above and beyond the representation that we get from political parties, is how do we begin to build the political cost for making political decisions that don't meet the demands and the rights of citizens? If we look at the engagement both well before amendment number 2 was tabled and many other pieces of law, we see that citizens have their own voices and perspectives, and yet they are persistently ignored or literally just, put aside. How do we begin collectively to say, you are supposed to be governing, not to be ruling us? How do we begin to make the Constitution have weight beyond the court and the litigation conversations? I would say that coming to this forum is one of those mechanisms. But I would ask those who are in the room to say, how do we create political consequences for political actions that are obviously at the table of political parties, whether or not they are visible in their actions? And finally, I think it is important to speak about the hidden hand of Pollard in all of this. We cannot, simply because we are not part of Pollard, we cannot run away from the fact that it is clear that there were political negotiations that were going on. They were going on behind the scenes, and there were positions that emanated from that, which they tried to instill within the national processes of the country. Why do we have political forums that are not accountable to citizens? And what do we do with them? Thank you.
Thank you so much, Sake, for your contribution and your questions. I think our panelists have noted those questions down. I would want to move on, I think, to Lamek Mahachi. You can unmute yourself, make your comment, or ask your question. Over to you.
My comment is just to try to consolidate what the previous speaker has just said, that how does the voice of the people go through to the powers that be so that their concerns can be taken on board? It's quite obvious that the electorate is shunned upon, is not looked upon. No one wants to know what the electorate says. Hence the passing of these 2 amendments. There is an air of
totalitarianism within ZANU-PF, like what the philosopher, the old philosopher said, a person who does not know that he does not know. Our ruling elite, they have got that sense of entitlement, that what they say stands. So there's no way we can do anything. There's chaos all over the country. Thank you.
Thank you so much for that contribution. I think our panelists are noting this comment, and I think the question there down. I can see that there are no hands, there's no show of hands in terms of questions that would want to be asked. I know people are
Hello.
I know people are tired. We've been on this bus for too long, but I am glad that we are still together even up to this point. I'm not too sure. I had heard someone speak. I think they had unmuted themselves. If you have a question, you can go ahead and ask your question. Okay, so I think they are not there anymore. So now, I think in the interest of time, I'll ask our panelists to address the comments, the questions, whilst at the same time they tie in their submissions and conclude. So I'll start with Professor Arthur Mtambara. You have heard the comments, you have heard the questions, but also in the spirit of tying in the conversation, may you please make your closing remarks as well. Over to you, Professor Mtambara.
Thank you very much for the excellent questions and comments. I'll try to be as brief as possible. We are supposed to be proactive. I think the criticism that we're coming too late is a valid source of criticism. We must always be aware. We must try to always be proactive. We are now reacting. So going forward, I think it's important that we are proactive so that we can handle things and have a better impact. But it's never too late to step up to the plate. So what we're doing right now is a good effort and we must keep working hard. But yes, in future, let us be proactive across the board. Now, PR, let's be very careful about PR. There's the PR that we're trying to introduce with these quotas and so on. It is devious, but PR in general, we must discuss it. It's a potential good thing. If we go 100% PR, which means Parliament 100% PR, Senate 100% PR, that allows small groups, minorities, women, and everyone to have a better share. That's what you find in South Africa. So let's have a reasonable discussion on the pros and cons of 100% PR. Recall of MPs, very good point. That power is in the Constitution because our Constitution was produced primarily by political parties. That's one weakness of our document. You know, we must always be able to do self-criticism. The MDC that I was leading, the MDC led by Changirai, then ZANU-PF with Mugabe, the three parties, although it was an all-inclusive process, the three parties had a very strong influence. And you find things like the recall of MPs by the parties came through. So it is something that favors parties. So parties will put that in there. That's why I said earlier on, civic society, the churches, ordinary people must have more say than parties. Sometimes parties are conflicted. Sometimes parties have vested interests. So yes, there's a problem. If we agree, we can take it out of the Constitution so that there is no power given to parties to recall MPs without going to the people. But it is in the Constitution because the overbearing influence of the three parties that were involved in the constitution-making process. Now, the issue of outsourcing of problems, that's a very good point. Right now, the running mate issue, this is a Mnangagwa versus Chiwenga problem. Mnangagwa is trying to manage Chiwenga. Mnangagwa wants to control succession in ZANU-PF. He doesn't want Chiwenga to be a strong VP. So what does he do? He changes the constitution. So that's a very important point. You find parties that have problems are now coming to the people, using the constitution to settle their internal problems. We can't allow that. The constitution is too important to be used as a tool to manage internal problems. to manage succession, to manage factions using our constitution. Unacceptable. The constitution must be above parties, and we must make sure that we protect the constitution. Here's the theory, people. Never trust the governors. Never trust the rulers. Never trust the political parties. The constitution is your defense as a people against the rulers, against the governors. In other words, the constitution is the mechanism to put checks and balances against the governors. Never, ever trust the governors. Trust the constitution. Trust constitutionalism, not individuals, not parties, not governors. Never trust the governors. That is the philosophy behind making a constitution. Quality of candidates, very important. Let us make sure that in our different political parties, we have a mechanism to improve the quality of our candidates for council, quality of candidates for parliament, quality of candidates for president, so that we can have enlightened leadership in the executive, enlightened leadership in parliament, and also the judiciary. So the quality does matter. Now, education of the MPs. Once you set up the Zimbabwe Civic Education Commission, it will start by educating the leaders, educating the parliamentarians about the constitution, about civics, and so on, and the people at large. Everybody needs education, in particular those in charge of parliament, those in charge of the executive, those in charge of the judiciary. So it's important that the Zimbabwe Civic Education Commission is a platform, a constitutional body, a formal body to educate everyone about governance, about civics, about the constitution. So we must make sure that we're able to do that. Consequences, creating consequences for bad behavior. That's why we need to make sure that our constitution protects us from abuse from politicians, so that the consequences for bad behavior are ingrained in the constitution and we are able to solve that. Now, in summarizing my thinking, let's understand this very clearly. Everything is about the economy. Democracy is about the economy. Constitutionalism is about the economy. Constitutionality is about the economy. Free and fair elections are about the economy. If you mess up any of these, democracy, constitutionality, constitutionalism, free and fair election, you are damaging our economic prospects. Amendment number 2 is an attack on brand Zimbabwe. What are we known for? We are known for violating our constitution. What are we known for? We're known for having lack of constitutional behavior. We're known for violation of the factional separation of powers. Once the brand of the country is damaged, you can't attract investors. You can't attract tourists. You can't attract anything into the country. In fact, you give those who have a beef with the country a rationale to keep their measures against the country. Let me make it very clear. We are opposed to sanctions against Zimbabwe. We want them to be lifted. But what ZANU-PF has done through amendment number 2 is to give those who have sanctions against Zimbabwe the rationale, the reasons to keep the sanctions in place. Count number 1. Count number 2. Amendment number 2 and 1 are a type of internally imposed sanctions, self-inflicted sanctions. So when we say sanctions, we as Zimbabweans, the government of Zimbabwe, are the biggest imposers of sanctions on Zimbabwe. We as the government of Zimbabwe are creating the rationale, the reasons why sanctions must be maintained against the country. Shame on us. We are playing hostage to fortune. We are damaging our economic fortunes. We're damaging our ability to attract investors into the country by pursuing these misguided amendments. You know, let's have no confusion about the efficacy and value of amendment number 2. There's no value there at all. The rushing of the amendment betrays the motive. Why would you rush on the quota for women? Why would you rush on the quota for the youth? Why would you rush on the change from 5 to 7 for ministers? You only rush because Malaba was retiring on the 15th of May. So the whole basis, the whole motivation behind amendment number 2 was power retention, creating a blind judiciary, create a compromised judiciary, which will then sit and decide over a rigged election in 2023. This regime is anticipating a contested outcome of the election in 2023, and they want a vulnerable judiciary, a blind judiciary, a captured judiciary to preside over the debate about the validity of the election in 2023. Forget the youth quota, forget the women quota. That was never the motivation. They try to just dupe you and I. They're trying to just fool us. But we are not that blind, deaf, and dumb. We're clear that the motivation was about consolidation of power, power retention. And also, a very good point from Manamatai, cost-benefit analysis. Why don't you do a cost-benefit analysis? What is it that you benefit from amendment number 2, and what do you lose? What we lose is far much more than what we get. So reject it, lock, stock, and barrel. A cost-benefit analysis would have shown us that there's nothing good for Zimbabwe in amendment number 2 and in amendment number 1. This is what we need to do to make sure it's tokenism, has been explained already. We must make sure we don't go down that route. So in conclusion, let me say to the people of Zimbabwe, we must be masters of our own destiny. We must be in charge of our own country. We must step up to the plate and be counted. We must become the change we seek to see in Zimbabwe. We must become the defenders of the Constitution we seek to see in Zimbabwe. No one else will come to Zimbabwe to defend our Constitution. No one else will come into our country to create an environment that will allow us to prosper economically. We, the people, are going to be the creators of a shared national economic vision. We, the people, are going to be the creators of a national economic strategy in Zimbabwe. We, the people, are going to be the defenders and protectors of our Constitution. I thank you so very much.
Thank you so much, Professor, for those closing remarks. And we also thank you for the recommendations that you've also finished. I think it's a challenge. You have challenged us. You have challenged us to do something about this situation. Thank you so much. So I'll move over to Stabile Dewa. I think in a few minutes, I would want you to respond to some of the questions and some of the comments, I think, and of course, to round up your presentation with the concluding remark. Over to you, Stabile.
Thanks very much. Most of the contributions were comments, and as the questions have already been answered. And just to emphasize that on the issue of parliamentarians needing training, I don't think that's exactly what they need. Like I mentioned before, the issue of the whipping system, there's no way when you have voted through a political party, you can go against that political party in terms of a position. So in terms of concluding, our eyes on the ball, let's make sure that our eyes on the ball, and let's re-energize citizen power, citizen agency, citizen voice. Right now we are busy shouting, screaming about the constitutional amendments, but they are already campaigning for 2023. So where do we place ourselves? Where do we place the citizens? How do we balance between what is currently happening and what has happened in the past so that it doesn't affect the future? Thank you.
Thank you so much, Stabile Dewa, for your concluding remarks. And I hand over to Namatai Kwekweza, your concluding remarks, and of course, you can comment or respond to some of the few questions that were shared here. Over to you, Namatai. Briefly, please, Namatai.
Okay, so thanks so much. I appreciate the emphasis on me having to be brief, so that's fine. Yeah, so I think maybe my first point would be the importance of naming and shaming individuals who have been part of castrating the Constitution. I think it's very important for history to remember them for who they are, to capture their names accurately, because I think that these are figures whom we cannot celebrate, and they must understand fully well that the people of this country do not condone such behavior. For instance, Star was saying that the women's movement had been very clear about a position, but particular women went ahead and just say that no, we'll have that quota system, which was opposing the opinion of the general movement. And furthermore, they create intergenerational rifts by then saying out of the potential 60 seats in the PR, young women only get 10 seats. And they wonder why young women are so angry and why young women are going against older women. So these are, intergenerational rifts that are being created within the women's movement, because there are people who go against, what we have agreed, in the trenches as women, and they go ahead and they do something else that we didn't agree on. People like Malaba, for instance, goes to work, but he was told to stop coming to work. He was fired, but he still goes to work, violating the law. So I think these individuals must be known. We must clearly document their behavior so that, people in the future will know that we did not condone, and we still do not condone such kinds of behavior with regards to how our constitution is treated. My next point is in reference to young people. With regards to always try always. When we went to the Minister of Justice, and last year when we did our procession outside of the Ministry of Justice, people are like, it's just the two of you, or it's just one of you. But at the time, people must understand that it was very difficult to mobilize, citizens to come through for such, because it was a lockdown. It was even so difficult for us to get into town in the first place, to go and try and meet the minister to talk about the constitutional amendment bill number 2. And when we got to his office, they ignored us. They lied to us that he was not there, but we could hear his voice. He was in his office. So I think these are some of the issues that we always say, like people who say it's just one person, they will say, oh, Musa Kika is just one person. Oh, it's Namatai, it's just one person. But I think we must always try. And when we now start seeing citizens in their different pockets trying, we must then find ways, to come together. Those who have already, expressed the interest and the courage to try. And then we try to rope in others who might have the interest but are not as courageous. That is how we locate each other, and that is how we find each other. I always say this with regards to how Chief Justice Malaba ended up getting fired. A lot of people would have said there's no point going to the courts because they're captured. But Musa Kika and team decided to just go anyway and file the application. And guess what? Chief Justice Malaba is now former Chief Justice Malaba because people actually tried. So we must always try. Even if we fail, we must always mobilize as young people to try. The next issue would be on the aspect of paying the price, and particularly paying the price in full. Stabile says that these people don't care. She is very correct. They don't. They could ruin your life for asking why they're behaving in a certain way. They could punish you. They could send people to beat you up. They could do all of those things. But as young people, we must know that the economy is beating us left, right, and center. We must know that we are growing old, without a future. There are people who are now in their 40s who have no job, who are struggling to take care of a family whereby you've got a mother and a father, but they don't make enough to send just one child to school. There are people who have been adversely affected, and it is because things can actually get that bad. And as young people, as we grow older, we must know that if we're unwilling to pay the price to get our freedom, to get a functional economy, to get a functional political system, functional, socio-economic structures that protect citizens, then at the end of the day, we are going to have to pay in our future. We are going to be those 40-year-olds who have absolutely nowhere to start, not because we were lazy, not because we did not have the potential, but because the economy messed us up, because the political systems messed us up, and because we failed to stand up for ourselves and to fight for our future and to fight for the future of our children and to also fight for our rights. The final thing that I just wanted to say is the importance of constitutional literacy. There was a research that was done by the Youth Empowerment and Transformation Trust in 2019, and they indicated that 17.5% of young people are aware of the existence of a constitution. This means that if there are 5 youth, only one of those 5 youth is aware of the existence of the constitution. We cannot rally and mobilize young people to defend a constitution that they have absolutely no idea exists. We understand that Section 7 of the Constitution mandates the state to ensure that citizens are aware of the Constitution. It mandates the state to promote constitutionalism, but the state has no interest in promoting constitutionalism because they know that when citizens become constitutionally literate, they also become politically and power literate. And when they become politically and power literate, they are now in a position to say, oh no, you're not doing this correctly and you cannot be entitled to our support. They know that there will be proper systems of checks and balances and social accountability when citizens, and particularly youth, become aware of the Constitution. So I think as we move forward, it is important for us to go to the rural areas where the majority of young people reside, to go to the communities, to go to young people in urban areas, and to make certain that they are aware of the Constitution and they fundamentally understand how this Constitution affects their everyday lives and affects their future. To just close it up, I always say that it's very important to know that there is no such thing as an overreaction with regards to lawmaking processes and also with regards to defending the Constitution. When we were doing a lot of work around the patriotic bill, I remember getting criticism from people like Nick Mangwana, who were saying that you guys are already talking about a patriotic bill which has not already been tabled in Parliament. But the fact that citizens were already talking about such a bill before it was even in Parliament, it indicates that, you know, they are conscious and they are aware and they're following, you know, things that are happening. So I think that in future with regards to constitutional processes, because I believe personally that it's not going to stop, like what was said by Professor Athamtam, but it will not stop. You know, the end game, of course, is to keep extending the tenure of the president to keep, to keep himself in power. I think that it's very important for us to start doing things before even this bills, even if we hear a rumor that it was discussed somewhere that they want to do this, we have to quickly address the issue before it becomes a nightmare and a problem for us, just as what happened in Constitutional Amendment Bill number 2. We have to build strong movements, and we also have to take cognizance that the COVID-19 context really affected a lot of things in the context of how civil society and citizens mobilize. But nonetheless, we have to keep mobilizing and innovating around how to stay active and also how to stay 10 steps ahead of this particular system and this particular regime. Over to you, Tariro.
Thank you, Namatai, for those closing remarks. I think there are some issues that have been raised that we may need to address as a people, but I also like the fact that you have also just added and emphasized on some critical and important points of action. Thank you so much. I have seen that Kipson Gundani may have left the meeting, so I think I would want to really thank our panelists throughout the entire day, who were able to be with us, who were able to make contributions, who were able to make concise and clear presentations about their perspectives on the constitutional amendments. We are here where we are today. And I think for us as citizens, we wanted to really know the various perspectives so that going forward, when we look for a point of action that is shared across the political divide, across the key sectors of Zimbabwe, we then move together in terms of getting to a place where we have a constitution that speaks for the people, that is people-driven, and one that speaks of the aspirations of the citizens of Zimbabwe. So I would like to really thank our panelists. We are really grateful as the Zimbabwe Council of Churches family for you taking the time out, for you committing to this process on behalf of our church members so that they know what is going on and they know what to do going forward. I would like to also thank again Professor Mtambara, to thank Namatai, to thank Stabile Dewa, to thank Blessed Mhlanga, to thank Dr. Magaisa, to thank Kipson Gundani, and also all the other panelists who were there with us from in the morning, mid-morning up to now. A hearty appreciation to you all. So I think we'll close this session with a closing prayer. I would like to see which.
Just a second.
Yes.
Hello. So just a quick remark. Sorry to disrupt your program.
Yes,
I just want to emphasize the issue of sacrifice. You know, it has been raised, the issue of sacrifice. We go to Patrick Henry. Give me freedom or give me death. The price of freedom is death. Freedom is not free. So if young people want change in Zimbabwe, if you and I want change in Zimbabwe, we must be prepared to sacrifice. The price of freedom is death. Freedom is not free.
Thank you so much, Prof. I think you have heard it from Professor Mtambara, but I think I was about to almost close the meeting without reading out the comments that have led to the conclusion of this conversation. I'll just speak of conversations where someone asked about what is PR. Stabile responded to say it's a proportional representation voting system where people vote for political parties, not individuals, like what happens in South Africa and in Kenya. Then Tinashe Gumbo, Dr. Tinashe Gumbo says that proportional representation stands for PR. Then Reverend Jokonya says her Prof. Makanyanya, hey, naked truth on the judicial system. Then Sydney Mariho says, Prof. Atham Tambara, that is exactly my point. They are interested in consolidation of power. Ale and Lamek Mahachi says, yet it is we, the people, who must course our own journey. But how can that happen when there is not room to achieve that? The powers that be do not want to listen and give access to do that. Someone says that surely we are growing old with nothing and with nowhere to start because of political and economic hardships of our country. Then Lamek says, that's my point. Namatai says it plain that they want to see the Minister of Justice, but they were told he's not there when he was actually around. Who will listen to our voice when they are deliberately shutting the door in our faces? Professor, okay, then thank you, family. Thank you, Taro, and all panelists and attendees for a day well spent. Then I would want to say from George Manyika, it says, and let us now not grow weary while doing good, for in due season we shall reap if we do not lose heart. This is Galatians 6, verses 9 from the New King James Version. I would also want to close by saying that it's been a long day, but I think it was time well spent, where we received some valuable information, some valuable points of action for people who are operating differently in the key sectors of Zimbabwe. So I thank you all for being with us today. So I would ask for a closing prayer from one of our pastors. I think I will try to pick one I can see reflected here in the participants still here. I'd hoped that we would have our president of the Zimbabwe Council of Churches, President Kanye, to give us the closing prayer, but I can see that he may not be in here. So I'll just pick and ask Reverend Goodson Chipendo to give us a closing prayer to this very long but productive day. Over to you, Reverend Chipendo. Okay, I can see that he might not have heard. It's okay. So I'll ask Reverend Peter Rugeda. We are not short of reverends, by the way. We are church, so we can ask him to give us a closing prayer. Over to you, Reverend Rugeda.
Let us pray. Hello?
Yes, we can hear you. You can go ahead.
Okay, shall we pray? Heavenly Father, we thank you for this day. Mazvita Mwari wedu, matigonera, matichengeta muzuva ranhasi. Tiri kukutendai nedzidziso dzese, ropafadzai vana wenyu wataura kunesu. Dzidziso dzese Mwari dzauya kuupenyu hwedu, tinodzitenda nekuti Kristu manga muri pakati pedu. Ngavakomborerwe kunyangwe nemapresenters edu, ngavakomborerwe Mwari, kunyangwe newaita initiate this program. Tinowanyika muropa renyu, ngavachengetwe Mwari, kubva kuhondo dzimwe dzichateerana neupenyu hwavo, kubva kuhondo dzimwe dzicharwisana neupenyu hwavo. Tinonamata in the mighty name of Jesus Christ. Nyasha dzenyu dzinopinda kuziva kwedu kwese, ngadzichengete vana wenyu. Patakuparadzana kubva paplatform ino, tinonamata tichiti nyasha dzatenzori Jesu Kristu, rudo rwaMwari Baba nekuwadzana kwemweya mutsvene zvitichengete nekutikomborera kubva zvino kudzamara nekusingaperi. Amen.
Thank you, Reverend. And this is goodbye from us. We hope you enjoy the rest of your day. Everybody, God bless.